Good morning. This is the Colorado Oil and Gas Conservation Commission. It is 9 a.m. It is February 18th, 2022. We are set for a day again on financial assurances. We will start with determining who is with us. A roll call, please.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez.
Here.
Commissioner Hackett. Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Fantastic. That is a quorum. Happy Friday. We are taking up docket number 2106-00097, the financial assurance rulemaking. We will hear from several parties today with regard to thoughts on the February 11th draft. We start with Wild Earth Guardians. So if we could bring Wild Earth Guardians to the panel. I see Kate Merlin is with us. Do you have anyone else?
I do not have anyone else this morning.
And we have you down for 10 minutes. Is that still accurate?
That is.
The floor is yours.
All right, thank you. I'm going to share my screen. Oh, may I have permission to share my screen?
Yeah, we'll get you that. Hold on just a sec.
Thank you.
You should be all set.
Okay, thank you. Let's see. All right. Thank you, commissioners, and good morning. My name is Kate Merlin. I'm the Wild Earth Guardians Climate and Energy Program Colorado attorney, and I'm here to present our final comments this morning before your final deliberations. Wild Earth Guardians filed a motion requesting the commission withdraw its new voluntary relinquishment proposal. And I'm not going to rehash that motion extensively, except to say that we think it's wrong to suggest that making it easier and less costly for operators to permanently abandon their wells is a logical outgrowth of a directive to make operators more financially responsible. And I can tell you with 100% confidence that there are members of the public who are not a party to the rulemaking who would have things to say about giving operators this get out of jail free card. However, what I do want to talk about is during the conversation, Commissioner Messner expressed some confusion, saying that Guardians itself had proposed an amnesty program. And with all due respect, this is entirely wrong. This confusion is a good example of why this proposal needs to be set aside until everyone can fully understand what we're talking about here. What he was referencing was the proposal for an abandonment prevention program that is designed to prevent wells from becoming orphaned. The APP program targets the class of operators between zombie operators and fully solvent, well-capitalized, and highly productive operators. And we're going to call those distressed operators. If relinquishment is the equivalent of pulling off a Band-Aid, fast, easy, and painful, then the APP is the equivalent of putting a cast on a broken bone. This program was developed with me with the input of dozens of people, including representatives from environmental groups, local government, industry, and the commission, and I've spoken individually at some length with each of you about it. This is an annual voluntary discretionary program that will save distressed operators from bankruptcy, will save the state from the burden of these operators' orphaned wells, will prevent these wells from being orphaned in the future, and will result in more rapid plugging of more inactive wells without public subsidy, which is one of Guardian's primary concerns. The APP program would allow an operator, if approved, to forego paying increased financial assurances as long as it remained in the program, and would allow it to nominate up to 20% of its inactive wells annually to a centralized COGCC plugging list in exchange for a fee or penalty negotiated by the commission. These wells would not go into the orphan well program. They remain the operator's property and ultimate responsibility until they are properly plugged. The second half of the program, which I'm not going to discuss in depth here, would allow other operators to plug these wells off of the centralized list in order to receive temporary offsets against their own financial assurance requirements. One example of a distressed operator might be Renegade Oil and Gas, who was the final speaker yesterday. Renegade has approximately 175 wells and $585,000 in financial assurance, which is a little over $3,300 per well. They have relatively few productive wells, about 70, meaning about 60% of their wells are not in production. Renegade averages a little over 1.5 BOE per well per day. But Renegade is currently an ongoing business that provides employment and pays taxes. And it says that if you will work with them on financial assurances, that they can successfully operate in the future. Without these excess inactive wells, Renegade would produce closer to 4 BOE, be an option 3 operator with single well financial assurance for 70 wells, not 175. Renegade is a distressed operator that will, if pressed for adequate financial assurances, go bankrupt. They testified they'll go bankrupt. If this happens, Colorado will have 175 orphans on its hand, or maybe more like 100 if its low producing wells can be sold. These 100 wells will have to be plugged by the state, remediated by the state, reclaimed by the state, and any future issues such as leaks will also be the responsibility of the state. The abandonment prevention program would potentially save Renegade and the state and the environment. I'll explain. Without this program, the only possible scenarios in these rules are either to try to work with Renegade to determine an affordable level of financial assurance under option 5, or to hold Renegade to the same financial standard as other operators and absorb them into the orphan well program. The abandonment prevention program had several key features to protect Colorado in this scenario. First, it was explicitly 100% discretionary with the commission. There's no right to be in the program. It protects the state from, sorry, I went ahead too fast. This protects the state from transparently suspicious applications. For example, if an operator had sold off productive assets immediately before turning to the commission with hat in hand, the commissioners could reject that application. Secondly, by making it possible for some operators to receive plugging assistance for some of their wells without orphaning all of their wells, it creates at least the possibility that the operator may secure its financial footing, enabling it to eventually graduate from the program with far fewer inactive wells and therefore assume financial assurance for its remaining wells. This protects the state from the burdens imposed by every additional orphan. One orphan prevented will save the state $100,000. Third, this voluntary program would strongly incentivize the plugging of inactive wells and remove administrative delays that are created by adversarial orphanage proceedings. This means inactive wells are likely to be plugged years sooner with this program. And finally, if this program has an unanticipated consequence, a loophole that's found and exploited, or if it just isn't working, the COGCC can stop it or remove an operator from it. So this abandonment prevention program is not perfectly fair. It involves compromises and trade-offs. Operators who've always acted responsibly would benefit less than operators who'd allow their inactive well inventory to accumulate irresponsibly. From an environmental perspective, some would question the benefit of saving distressed operators like Renegade rather than sending them to orphanage quickly. However, it would allow inactive wells to be plugged as quickly as possible by drawing these high-risk operators out of nearly certain adversarial bankruptcy and orphanage proceeding into voluntary negotiations, and allow distressed operators the possibility of rebalancing their portfolios and thereby remain in business. It saves the state from the threat of permanent liability for plug abandonment, reclamation, remediation, and it saves the state and local government the jobs and the tax revenues. There are benefits to non-app operators, and I don't have time to go into detail about the second half of the proposal, which covers discounts to operators who would do the plugging from the centralized list. This isn't necessary to the functioning of the app, but it would provide some additional benefits to the state by utilizing temporary financial assurance credits to incentivize plugging rather than have the state do it. I do have some specific proposals around it, including liability, which has been a major sticking point for operators who do not currently plug off the orphan list. This is the red line language for the app program. In contrast to the app, the amnesty program is not clearly 100% discretionary with the commission. If ABC Oil transfers all of its productive wells to a new Form 1 operator called ABC Resources, and then seeks to relinquish ABC Oil's inactive wells, is that a situation one where the commission believes that it can say no to the petition for relinquishment? This needs to be a clear yes on saying no. Amnesty is a permanent solution to what might otherwise be a temporary problem. The state assumes liability in perpetuity. Also, amnesty is not limited to insolvent or distressed operators. Even an uber-rich corporation could potentially, theoretically, relinquish wells. Amnesty has no fee or penalty. A distressed operator could potentially sell its active wells for profit and then relinquish just its inactive wells, but the commission would not be able to recoup any of those profits to plug the relinquished wells. Finally, amnesty is primarily attractive to distressed operators and not zombie operators, and for this reason, we believe it's unlikely to succeed. Amnesty should only be an option, if at all, to those wells and operators we know with near certainty would be in the OWP in the absence of amnesty, Orphans are expensive. I just want to touch on a couple of the other provisions that we have some concerns with. Option 5. I understand why you want it, but we have a variance process, and this is where operators should go if they're truly these special snowflakes. There's no guardrails here. Even unique characteristics that were proposed in the December draft have now become individual characteristics. Everyone's an individual. Furthermore, by adopting the abandonment prevention program, you have a similar ability to negotiate with an operator while also recouping a negotiated penalty and getting some of the inactive wells plugged, which has benefits both now and the future. An operator in option 5 is unlikely to ever get out of option 5, but an operator in the app program could potentially graduate with a viable company and adequate financial assurances. Standing for surface owners can participate in accessing financial assurances, but not in setting them. The rule contemplates a petition process for participation, so we don't believe there's a need to preemptively cut off surface owners who may have some really good reasons for wanting to be in there. And then I want to end this presentation by bringing us back to the purpose of financial assurances, which is ultimately to prevent orphans. Although we do expect this temporary spike from zombie operators, in the long run, eliminating the profit incentive to strategically orphan wells through neglect and transfer and long-term idling will benefit the state. And there is a benefit to uncovering these zombies sooner rather than later. Getting inactive wells plugged or without transferring these costs to the state or even federal taxpayers is probably our #1 goal. That's why we think it's really, you need to take out the amnesty provision. The abandonment prevention program is within the scope of this rulemaking because unlike amnesty, it ensures operators will remain financially responsible for their facilities. But we understand if you think it needs more stakeholder input and would support carving out the program, the option 5 program and the relinquishment program, and notice them separately. With the work that's already been done, we think you can get these done in a short amount of time. In conclusion, I want to say thank you for your time and effort that you've put into this rulemaking. I know it's been grueling, and I don't want you to think that our remaining concerns make you think we don't appreciate it. So I'll end there.
Thank you. Are there questions? Commissioner McGowan, then Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, Ms. Merlin, for being here today. So I think I think about the draft voluntary relinquishment a little bit differently than you are, and I'm wondering if we could chat about that. So even if under this, if I'm understanding you correctly, your concern is that an operator who might voluntarily relinquish their wells would sell off the operating wells and then leave the rest to the state and then maybe profit from that. If I'm understanding what I hope I'm understanding what you're saying. But the way that this is draft, so I guess it's, for me, it's 6 of one, half dozen of another. If we use the APP program, we still end up with some orphan wells and wells that we want to maintain and have be productive. And I guess I don't think it's a get out of jail free card. The way that, at least the way that I've been talking about it, is the operator can't operate in oil and gas anymore in Colorado, and we pull their financial surety bond, as minimal as it might be. And so that's kind of, I'm kind of working through those things. I'm wondering if you could respond.
Thank you so much, Commissioner McGowan. I think there's a couple different issues wrapped up into that, so I will do my best to untangle it. I'm a bit of a circular thinker, so forgive me if if I don't do as good of a job as I'd like to. So I think the difference between these two programs is that the abandonment prevention program does not create orphans. So with this program, wells that are nominated for plugging would be plugged, but ultimate responsibility would remain with the operator. So I'll give you an example. A well that goes into the orphan well program needs to be assessed for whether remediation is required. It needs to have the site fully reclaimed, in addition to having the well plugged. And if it's in the orphan well program, remediation and reclamation are both the responsibility of the state. As we know, remediation can be incredibly cheap or incredibly expensive, depending on what we find. With the abandonment prevention program, only plugging gets taken care of for the operator. So if, for example, extensive environmental contamination is found during the plugging process, go back to the operator and say, hey, we found this this extensive contamination while the plugging was occurring, and we're going to need to work with you to get that taken care of. But it's not the financial responsibility of the state to assume responsibility for that remediation. The wells, once they're plugged, if contamination is not found, they go back to the operator for site reclamation. And once that process is completed, then it would no longer be subject to anyone's liability, because it would be a fully plugged and abandoned well under your rules, that sort of wiped clean, as it were. Let's see, so that was part of your program. What's the difference between this? Did I explain that part well enough?
I think so. I think I'm wondering what kind of operator you think will try to utilize the APP, because I've heard some testimony from folks that this paradigm shift and the new rules are going to reveal operators who might not be successful under the new paradigm. And in my mind, I'd rather figure out who those operators are sooner than later, and not drag things out and have them like, well, I'm going to P&A and then I'm going to send it back to you for reclamation, but they probably can't afford that piece anyway. So so okay, that's my thought.
Right. So let's see. That's a new question. I didn't fully completely answer your last question. Let me see if I could do this. So one of the questions that you had, and I think these tie together, is why, okay, so an operator who would voluntarily relinquish, they lose their license to operate and they lose their financial assurance, which is true. But that brings me to my example that I gave of this hypothetical fictional ABC Oil. So ABC Oil transfers all of its productive wells to this new company, which we call ABC Resources. ABC Oil loses its Form 1 ability to operate and its existing financial assurances. But now ABC Resources, who might have the same corporate managers, the same employees, you're shaking your head. You don't think that's a possibility?
Well, so for me, the relinquishment is similar to some of the bankruptcy proceedings we've seen in front of the commission, where the language is pretty clear that if you were the head of company A or B, you don't get to run a new company. I just feel like this is a lot of what ifing. And if the current paradigm stays in place, all those wells that get transferred will have to be singly financially assured. So is company ABC going to have the resources to fully financially assure those transferred wells to its own new shell company, or whatever we're going to call this thing? And I think there's other things in place in our rules that would make this rather difficult, this scenario.
So in my motion, I did note that the cost savings from relinquishing one well, we know, would be an average of almost $93,000. An operator who manages to avoid responsibility for one well, if the ratio is just 1-to-1, you save one well and you pay full single well financial assurances on another well, you're still saving money, because they're not going to be paying single well financial assurances of $93,000. So relinquishing one single well is going to be profitable, even if it means they have to pay single well financial assurances on 2 or 3 other wells. So, and I hear what you're saying about what if, this is speculative, but I think that's the purpose of rulemaking, is to go through the hypothetical situations that could arise.
So another piece to the puzzle, right, is a financial assurance plan. So this new company would have to come to us with a financial assurance plan. And I think we might recognize some of the folks who would be involved in the new company and what transfers would be occurring. So I feel like we've created a bunch of kind of checks and balances with the various pieces that we are reviewing here in the financial assurance. So I think I just need to noodle through what you're saying a little bit more. And
yeah. So So, one issue is that the commission has stated that it has no authority to prevent transfers in the past. And so, even if it wasn't a new shell company, ABC Resources, what if it's another operator? So fine. So operator one loses its ability to operate in the state. I'll use a specific example here, not because I think they did anything wrong, but because I think it shows how the potential is there. Whiting Resources decided they didn't want to operate in Colorado anymore, and they sold all of their Colorado assets to a company called Fundare. I don't really know anything about Fundare. Hopefully you do, but the commission said that it couldn't stop this transfer from happening. Well, Whiting, if it doesn't want to operate in the state anymore, what does it matter if they lose their Form 1 ability to operate? They're already leaving the state. So if they gave up, so in that case, they had, I believe, 339 wells and 36 inactive wells and financial assurances of $415,000. So $415,000 is not enough to plug 36 inactive wells. So if Whiting Resources sold only those 303 active wells to another operator and took that profit and left the state and said, here you go, we don't want to operate in the state anymore. Here's our 36 inactive wells, and here's our $415,000 of financial assurances. Now they have profited from that sale, right? Presumably they've gotten more money from the transfer because they aren't including these wells, which are liability to the buyer. The buyer's going to give them a better deal. And the state gets the raw end of that deal, right? We get the 36 inactive wells and the $415,000 of financial assurances. So that's the type of situation, not everyone wants to operate in the state, forever. And it's just, without that ability to negotiate a penalty, without that ability to really delve into this. And to be honest, it's not clear from the rules as written whether you have the ability to say no, as I mentioned.
So I think the new rules do prevent transfers that for whatever reason don't work. And so in the past, it was the old rules and the commission wasn't able to do anything. I think the new rules say if the buying operator cannot cover the financial assurance, the responsibility falls back on the selling operator. So I think I'm interested in the amnesty program because of this narrative that I'm hearing that it's going to reveal a bunch of folks who can't succeed under this new model that we're going to have. The amnesty is only good through the end of the year. I think the way that the draft is written, I think that's a pretty short window. I see what you're saying. I'm going to think through some of those things, and I feel like we've had a lot of discussion about gaming the system, and I'm trying to figure out how often that those things actually happen versus there's kind of anecdotal when really bad things happen. It's someone who's done something really bad. And I just don't think we're going to prevent behavior like that ever, whether it's oil and gas or anything else in life. So I appreciate what you're saying. And I understand what you're saying. I'm going to think through that. Thank you.
Yeah, I think, making it clear, that receipt of a conforming application does not guarantee that you will be accepted would go a long way, because it would allow the commission to use its considerable discretion, and I think that when you peer into these things, when you're looking, you see things. And just maintaining that ability to look, I think, is important. I understand, about making the orphanage proceedings easier. The problem is that a lot of these zombie operators that we really want to target with amnesty, they already don't often, not always maybe, but often don't respond to enforcement. So enforcement proceedings will begin, they will be sent notice, and a year later, you haven't heard back from them. So that just happened, I believe, with PCR. I think you put them into orphanage without having them respond to the notices that this proceeding was going on. Forgive me if I'm misremembering that, but But so the problem is if you have operators that are already not responding to ongoing enforcement actions, and here you're asking them to proactively file a form, asking for relinquishment when they gain nothing and lose nothing either way, I think that what you're going to find is that this operator is not as attractive to these folks who really just, if you're just a mailbox in Arizona somewhere, you're not necessarily going to file one of these things. Whereas if you're a solvent company with assets to protect, and you can find a way to sort of, take advantage of this rule, you're much more incentivized to do so. So that's what I would just say, is a cautionary tale.
Thanks for the conversation.
Commissioner Nanjapa?
Thank you, Mr. Chair, and thank you, Ms. Merlin. I appreciate the thoughts and the dialogue just now. I'm kind of continuing along this thought just a little bit further. I think you said that with the abandonment prevention program that there would be an expectation for the operator to voluntarily nominate their inactive wells, but then they also are covering the plugging costs and potentially remediation costs?
No, thank you, Commissioner Nanjapa. So what would happen is we believe that this it is a program that we mostly incentive not to zombie operators, but to distressed operators who have excess inactive wells, because it would allow them to forego updating their financial assurance requirements while they're in the program. They stay with the level that they're at, and then they're able to nominate a certain amount of their inactive wells to a centralized plugging program. That plugging list would either be plugged by the state or by other operators. And the second half of the program involved credits that other operators could receive to their own financial assurance amounts, which, if there are operators with in-house plugging operations, they might prefer to plug wells using their own equipment and personnel in-house rather than have some money go to a surety company or sit in a bank account somewhere. So no, the operators who are in the program would not be responsible for the plugging costs, unless what could happen is if they decided to leave the program, if the commission said, you know what, we don't think this program's working for you, for whatever reason, it's discretionary and voluntary. When the operators leave the program, they leave with all of their assets. Ownership has not changed hands. So, if a well has been plugged, then check, that's done. They'll have to perform whatever work is left to be done at that site before they can get it off their books. But for anything where the plugging did occur and no contamination was found, and remediation is taken, then they just that's off their books too. Hopefully the goal of this is for operators to reduce their inactive well count, for those wells to get plugged quickly on a voluntary basis, that operators would hopefully be enthusiastic about letting somebody else plug their inactive wells. And then hopefully they'll be able to graduate from the program with a lower number of inactive wells, so they don't have to pay single well financial assurance on all those inactive wells. For example, Renegade, if they could be in this program for a few years, they'll pay a negotiated penalty. You'll work with them on that. They'll put their wells on a list. We'll get those plugged. And again, that's the second half of the program. I do have ideas about this. I think it's really worth stakeholder engagement, because I think it really has some very good potentials to save the state the cost of orphans, to save operators who, like Renegade, they are telling you if you make them pay financial assurances, they will go bankrupt. But if you don't, they're an ongoing viable business. Maybe that's true, maybe that's not true. You'll be able to have a chance to look at their books when they apply to be in this program.
Okay, apologies. I don't want to cut you off, but I want to just keep moving through a couple of the other associated pieces. So they wouldn't cover the plugging costs, but they would be tapped if there were remediation issues that were discovered. So what I'm trying to understand is how that differs from the amnesty program, where they're voluntarily giving. It's essentially like the orphan well, situation where they're turning over wells that get plugged by somebody else, and so they don't have to, I think you're saying maybe there's a penalty or something that gets negotiated. So maybe that's where the cost is. And I want to visit that in just a second. But I think, we did talk through this, and I was one of the ones I think that was initially suggesting, what if there could be a proportion of wells that could be submitted in the amnesty program, that would allow an operator to rebalance their portfolio. I think the more that I've thought about it, it seems like that is, while I understand the intents behind it, it's less equitable, I think, in that it is, to me, that's more of a get out of jail free card. Even if there's a small penalty or something like that, because with the amnesty program as it's currently proposed, you lose your ability to operate in Colorado. And I believe, as Commissioner McGowan was also noting, that as we have in some of our other enforcement orders, it would be any parent sub, anybody, there would have to be some additional review that comes before the commission. And I don't know if Chair Robbins or others has, additional thoughts on the way that's worked in the past, but we would, this would not be a way for an operator to restructure and then give us their worst assets. I think, or we could even incorporate some language to prevent that, because I do understand that concern. And I think that's an important concern, because, there should be something attached to it.
Right.
So I guess just, I wanted to get your thoughts on the penalty if they were to do it this way, and how that is better or more cost effective for a distressed operator to pay a penalty and potentially remediation costs, than being able to just turn their wells over and stop operating.
Sure. Well, every individual operator will have to decide, of course, whether they want to be an ongoing operator in the state of Colorado. That's always the decision. The question about why it's better for the state is, with the amnesty program, you become permanently responsible for those wells and everything associated with those wells. With the orphan well program, you do not. The operator remains responsible. Yeah, they would be responsible for remediation, but they're already responsible for remediation. And the alternative to that already is the orphan well program. If they decide to, go zombie on you. I think some operators might choose to be in this program if they have excess inactive wells, because they would have the opportunity to negotiate with you and come to you and say, look, this is my profit. This is what my overhead costs are. I can pay this amount, but if you make me pay more than that, it's going to eat into my operating costs, and I can't keep going if you do that. And you realizing that the alternative is the orphan well program, and you being fully financially responsible, would say, okay, we'll work with you on that. Then at least, even if that penalty is marginal, you get $10,000 from the operator. It's more than zero in the amnesty program. And you've worked with the operator, you've been able to, if they show you their books and you see, look, this guy is keeping all the money and this is not a good deal for us. Here's, we could see they've done some shady things to try to look like a good candidate for this. You have discretion to say no. Sorry for the noise in the background.
No, it's okay. I appreciate the thoughts and the explanation. I guess then, I think we have discussed, I don't think it's in the current draft, but a fee for relinquishment, as a penalty to participate in the amnesty program. So I think that would kind of get at the get out of jail free notion. But the other thing I think is that, as you said, the operators that choose the abandonment prevention program, if that's where we went, would be responsible for like remediation costs and things like that they're already responsible for, and the alternative is the orphan well program, but that would entail the whole enforcement process. So I think the amnesty program is our way of avoiding all of that lengthy process and staff time and effort in order to just get those wells, you know,
I mean,
covered immediately.
if I could speak to that issue for 1 second, I mean, orphans are incredibly expensive, and I understand wanting to streamline the process, but you're adopting 48 pages of rules here that have a lot of hearings, that have ongoing review of production levels and portfolios, and there's a lot of administrative burden associated with this total rule package. So to say that you want to save going from 3 hearings down to 1 hearing just doesn't really fly with me, because you're not saving that much. You know, what the cost of 1 additional orphan that wouldn't otherwise go into the orphan well program, if even 1 sneaks in, that's like an FTE right there, you know? So from my perspective, it's better to err on the side of going through the process rather than to accidentally let solvent operators who could be financially responsible for their wells take over, you know, that burden, which they've already agreed to. You know, I've heard from some operators that, you know, they might have distressed neighbors. Well, if those distressed neighbors go under, maybe they'd be willing to buy the entire package of wells, including the ones that are, you know, inactive. So, you know, how is that not a better alternative rather than going to the orphan well program? That really should be the very last resort. And I will, you know, not to be, I don't know, whatever about it, but like, it's an election year to say like we're helping operators with amnesty by creating additional hundreds or thousands of orphans. I mean, that's not a great look. I don't think that's gonna fly well with the public. I don't think that's gonna fly well with the press, you know, and when you get orphans, I think I just don't see it. You're not saving that much. It's gonna cost a lot of money. You know,
Okay. I appreciate
have
your thoughts.
some more stakeholder process on it. Like, I know that you asked a couple questions from a few parties earlier, but there was no proposed language for us to look at. Not everyone was asked questions about it, and the public hasn't had a chance to weigh in on this amnesty yet.
Okay, well, no, I appreciate your thoughts on it. I think there's a couple of different things, as Commissioner McGowan also noted, in our rules, you know, including individualized plans, variances, you know, things like that, that we can address some of these unique situations. But I do think that the savings from the enforcement process, it is an important consideration, and it's not, and I've definitely voiced several times that if we can find ways, you know, among the operators to prevent orphans before they happen, especially if we're talking about wells that are otherwise productive, you know, that is going to be encouraged. But, you know, obviously we don't want a whole lot of orphan wells, but if we can get them in a very short, limited time window without all of the enforcement process, I think that actually does save the state a lot of money. Anyway, I'll just end it with that. But thank you for your time.
Yeah.
Appreciate it.
And everything that you said right there, I mean, is let's prevent abandonment. Let's prevent orphans. Let's have a program to prevent abandonment and prevent orphans. And yeah, I hope you'll consider it.
Thank you, Kate. Further questions? One concept that it seems simple, and maybe simple is not good, but the issue of the operator that like sells off the good stuff and then abandons the bad stuff, get it. But if we were to put into the rule that amnesty, you know, you need to file for amnesty by date certain, and that a qualifying or a disqualifying mechanism is if you offload any wells between effective date and date certain, it seems like that would address that issue. Any thoughts?
I think that, you know, it would be helpful, of course. I think just clearly delineating that you have the ability to say no if something smells wrong. I think that would be incredibly important.
Thank you very much. Thank you for leading off this morning with us. We appreciate the time and perspective that Wild Earth Guardians is bringing to our rulemaking.
Thank you.
With that, we will move to our next participant, Citizens for a Healthy Community.
Good morning, commissioners. Can you see me?
We can, and we can hear you.
Great. Oh, wonderful. Okay, if you would give me a moment to pull up my screen to share it. That would be great. Can you all see that?
We can.
Okay. Wonderful. Well, good morning, commissioners. Natasha Leger, Executive Director for Citizens for a Healthy Community. I'm representing CHC, Valley Organic Growers Association, and Terra Ditch and Reservoir Company today. Chris Michalski will be presenting with me. Thank you again for the time. As we keep score on the drafts, we appreciate the improvements that have been made to federal wells, surface owner protection, and environmental liability insurance in the February 11th draft. Today, we're going to discuss federal wells and offsite impacts, and we're pleased to see that the February 11th draft extends state financial assurance to federal wells. While we would prefer to see the application to federal wells take effect sooner rather than later, we have two recommendations. In terms of adding language to the SBP, and I have not seen the new SBP, so I'm not sure if this is already being contemplated, but we would recommend adding to the SBP, acknowledging the decades worth documentation of BLM's inadequate federal bonding program. We want to ensure that the record is clear regarding the state of BLM's financial assurance program, which is what merits the state ensuring that it makes up for the difference to meet its standards. We also think it's important for the SBP to reflect the Commission's commitment to avoiding double bonding, and that extending financial assurance to federal wells is a win-win for both state and federal government in protecting public health, safety, and the environment. With respect to the substantially equivalent language, we understand that the federal programs operate differently on a per lease basis, as well as other differences, which make it difficult to make an apples to apples comparison to the state program and determining the difference in coverage. Therefore, we understand the reasoning for introducing the language of substantially equivalent as a qualifier, yet we already know that it's proving to be problematic in the OGDP applications. And so we would recommend replacing substantially equivalent with exceeds or is equivalent to prevent financial risk to the state and basically ensure that there isn't a lesser standard. Now let me move to offsite impacts. In our conversations with staff and commissioners, I think we can all agree that farmers and water rights holders should not bear the costs of damage to their property, infrastructure, or livelihood that results from no fault of their own. I also think that we all agree that the best way to avoid the issues we've been raising with you is to deny permit applications to geohazard areas and watersheds. The issue in front of us, however, is what to do about existing operations and new permits and how to address that within the current constraint of the rules. So given our conversations with the director and commissioners, we recognize that we're asking you to do something unprecedented to ensure that the costs of damages caused by oil and gas operations are not externalized to impacted property owners and addressed through financial assurance. So today we want to address three questions. Why you may not be hearing from people outside of the North Fork Valley. Does the rulemaking allow for financial assurance considerations for offsite impacts, not just end of life obligations? And can financial assurance for offsite impacts, geohazards, and water contamination in particular be implemented within the current rule structure? So let me start with question number one, why you may not be hearing from more people. If Mark Waltermeyer of VOGA was here, this is what he would say. As a volunteer board member for VOGA, I've taken on the responsibility of representing a diverse group of growers. Small-scale agriculture is a meaningful lifestyle choice that is rewarded richly in many ways, but not in spare time or income. We're busy and our margins are thin, if existent. Engaging with groups and with government entities isn't our first choice and nor our second choice usually. Many of us enjoy the alone time in the fields and have fear and reluctance to speak in public, not to mention the time and interest it takes to keep up with the intricacies of policy and policymaking. The COGCC rulemaking process is intricate, and the financial assurance issue itself is complicated. Industry can engage with paid staff dedicated to working on these policy issues, and we can't. As a grower and a volunteer in the process, I often feel hamstrung and ill-prepared to engage in the way that would best safeguard my farm and my fellow growers' operations. I'm sure I'm not alone with this discomfort, and I believe you would hear similar feelings from other growers, as well as similar concerns as to how we see the threat of oil and gas development to our livelihoods, especially that we should not be absorbing potentially $10 to $13 million in financial impact. I firmly believe that I speak for a larger group of small-scale farmers than we have in the North Fork Valley when I express my concerns, and that you can safely assume my concerns are widespread among those of us engaged in this type of agriculture. If Rich Rudin of Terra Ditch and Reservoir Company was here, he would say Terra Ditch is a dire example of the geological hazard risks. The local community has seen, and people around the state are aware of Terra Ditch's predicament and wholly expect that the COGCC will deal with that issue. Terra Ditch is seen as such an obvious example of the need for financial assurance that rules built around Terra Ditch would solve other similar problems around the state. Terra Ditch should not be put in the position to potentially absorb $1 million in repair costs and $200,000 in annual maintenance. To date, we have been taking a statewide approach to solving the offsite impacts problem. Given concerns you may have, we are open to narrowing the scope, which I will discuss later. But first, let me turn it over to Chris to discuss the scope of the rulemaking.
Morning, commissioners. This is my first time using Zoom on my phone, so I just want to make sure that everybody can hear me well.
Yes, we can hear you.
Okay. My name is Chris Michalski, and I'm the attorney for Citizens for a Healthy Community. SB 181 gives the COGCC broad authority in this financial assurance rulemaking. Specifically, Section 3460-106, subsection 13, contains 4 mandates for what the Commission must consider in this rulemaking. First, the Commission must require that every operator provide financial assurance that is capable of fulfilling every obligation imposed by SB 181. Second, the Commission must increase financial assurance for inactive wells. Third, the Commission must increase financial assurance for well transfers. And fourth, the Commission must increase financial assurance for orphan wells. Through this process, the Commission has limited its rules to the second, third, and fourth financial assurance requirements. That is, inactive wells, well transfers, and orphan wells. Commission staff have further read the second, third, and fourth requirement as a limitation on its first requirement, to ensure that every operator provide financial assurance that is capable of fulfilling every obligation under the Act. With that, the Commission has continued to produce draft rules that constrain their own authority and limit what the rules can address. One example is with geologic hazards and offsite impact. Hydraulic fracturing is designed to induce seismicity. Induced seismicity is potential to cause a geologic hazard, such as a landslide. In areas that have geology that is more prone to landslide, landslide could be more likely due to the induced seismicity. If and when a landslide runs, it can cause damage to property, water infrastructure, and roads, among other things. That damage would be an adverse impact caused by oil and gas operations that the operator both failed to avoid and mitigate, despite its duty under the rules to avoid and mitigate adverse impacts. SB 181 is precautionary in its intent. It gives the Commission broad authority to consider financial assurance for hypotheticals such as that. I.e., the Commission must require the operator to provide financial assurance that is capable of fulfilling its obligations under SB 181, including the obligation to avoid and minimize adverse impacts. However, because the Commission has limited its view in this rulemaking to focus on inactive wells, well transfers, and orphan wells, there is no precautionary safety net to remediate offsite adverse impacts, including the offsite adverse impact from geological hazards, such as the one in my hypothetical. In other words, because SB 181 does not specifically state that financial assurance must cover geologic hazards or other offsite impacts, the Commission has taken the view that financial assurance need not cover those adverse impacts. However, as noted previously, SB 181 contains a broad grant of authority to require an operator to provide financial assurance for offsite impacts, and the Commission need not limit itself in this rulemaking. CHC's goal throughout this financial assurance rulemaking is to make sure that landowners and property owners do not absorb the cost of oil and gas operations. Industry has repeatedly cried that stringent financial assurance rules would be a financial burden. What about the financial burden to a Colorado resident who has to remediate an adverse impact caused by oil and gas operations? Most landowners do not have the resources for a drawn-out legal battle with industry or their insurance. There must be financial assurance for the what-ifs and the worst-case scenarios, so that individuals don't have to pay out of pocket for the damage caused by oil and gas operations. Luckily, SB 181 gives the Commission broad authority to require financial assurance for the worst-case scenarios. I'm going to turn it back over to Natasha Leger to discuss CHC's financial assurance red lines, which show how financial assurance for offsite impacts can be incorporated into the current financial assurance rules.
Thanks, Chris. We have shared red lines with you over this rulemaking process, but I thought we would put together a framework, a visual framework to help explain and understand how we're thinking about it. So we're looking at 4 different category areas of addressing offsite impacts. One is through transfers and adding geohazard information requirements. On transfers, bonding, we see that in 3 areas. One is on the location of assessment relative to the geohazard mitigation plan is requiring financial assurance tied to those plans. Seismic operations, we recommend increasing the bond on that in where those operations are in a geohazard area. And then we're proposing something new, which is a water protection bond, which is built off of the surface owner protection bond. And then environmental liability insurance. And we want to thank you again for increasing the environmental liability insurance to $5 million, but that only really addresses the water contamination dimension of our issues. It relates to accidental, sudden and gradual pollution, and it's not really addressing the physical infrastructure damage. If there is an opportunity for an insurance product that addresses the physical infrastructure damage, we are very much open to that. We do still have some concerns around environmental liability insurance because our main objective is ensuring that these impacted landowners don't have to suffer lengthy legal challenges or insurance claims processes, and that there is a fund available for them to recoup any damages. And that's where the adverse impact fund would come in that we're recommending, which would be $100 per well. As I stated earlier, we were originally looking at this as a statewide issue, and we recognize that you may have some concerns about that. And so we're open to discussing how that might be limited to perhaps geohazard areas or sensitive areas, or just identifying where these issues have been identified in the state. So with that framework, here are the red lines that we have recommended to address that. One is the need for a catastrophic adverse impact definition. And to be clear, that fund is designed to be the backstop for when insurance claims are denied or not available, and bonding doesn't work. Also definition for water rights holder, which would be any person who holds a water right or entity that manages or oversees water conveyance infrastructure. On the transfer side, we recommend amending proposed Rule 218B9 to address geological hazards, that information requirement. And on the bonding side, we see that being integrated into the permitting process in Rule 304. C21 and proposed Rule 704, which would create a bond of $50,000 for geohazards and can be updated based on documented costs. Seismic operations, doubling that in areas that would be in geohazardous areas. And then the water protection bond of $50,000 per well that may be increased on demonstrated cost, or VOGA has recommended $200,000 per well pad. And we have a detailed red line that we can go through, but that's the main gist of it. And then the adverse impact fund, as I mentioned, that would be $100 per well. And then lastly, we've got a miscellaneous proposed rule 709A1E. In previous mission change rules, compliance with financial assurance was tied to withholding action on permits. And we think that should be reinstituted. And so we recommend that here. And so these are more details on the water rights protection bonds. That really builds off of the surface owner protection bond. And I'll let Chris weigh in if I've missed anything. Otherwise, I want to thank you for your time and attention, and happy to answer any questions.
Did Mr. Michalski want to weigh in further? Kind of left that
No,
open.
I think Natasha explained our framework really well, and we welcome any questions from the commission.
Okay. Ms. Leger, just, that's kind of a fundamental question. How many folks in the North Fork Valley have had to pay for offsite impacts from oil and gas development?
I don't know that that has happened to date. I mean, again, our major issue is being precautionary. I mean, the community is concerned about this. We're concerned about the catastrophic potential event and don't really want to wait for the damages to happen in order to address it. Unfortunately, so many of our rules have been reactive. We've got to wait for an explosion to happen. We've got to wait for, a ditch to collapse. And that's what we're trying to avoid here, which is that 181 has ushered in that precautionary principle. And we really need financial assurance to do the same.
Okay. Commissioner McGowan had raised her hand.
Thank you, Mr. Chair, and thank you for being here today and sharing your thoughts again. And I'm curious to know why you think that if we set up a fund run by the commission, that it would be easier to access than, for example, if something were to happen in the insurance company. We would still have to have rules. There would still be an adjudicatory hearing. There would still be a he said, she said. I'm trying to understand why you think it would be easier to access and more streamlined if we had a fund set up in the commission versus going through insurance. So I'm wondering if you could address that.
Yeah, can I turn that over to Chris? He's a little bit more familiar with the insurance process.
Yeah, so an insurance company has a financial interest in either not paying out or paying out as little as possible. So they're going to be an interested party in the litigation with their own set of attorneys, arguing against either causation or the extent of the damage. And for us, especially with geologic hazards, causation is a pretty significant component, which is why in mission change we propose seismic monitoring on active wells to help tie that causation back to a specific operator if it exists. Our idea with the pooled fund handled by the commission, we understand that due process would still have to be followed, and there may be a hearing. But with the pooled fund, the operator who allegedly caused the damage doesn't have as big of a financial, is not risking its own finances, so to speak. There's this pooled fund to draw from. So we think that if a landowner or individual is adversely impacted by an oil and gas operation, and the insurance claim either gets denied or there's significant pushback from the insurance company, going through the commission would help make that process more streamlined. And anyone who's dealt with an insurance company knows that it's not their business to make it make it easy to pay out. They're going to throw up roadblocks at every turn, whereas a pooled fund handled by the commission, we have less interest in the payout from both the operator and the commission, and it's more towards trying to remedy an adverse impact.
Thank you for clarifying that. That makes sense to me now. Thanks.
It's the same way why there's a pooled orphan fund, right? We have all the operators putting this minimal registration fee in. So now we have this large sum of money sitting in a pool that needs to draw from. No one operator is going to, I would assume, no one operator is going to push back with a full cadre of attorneys to try to stop the orphan pool funds from being distributed, because they might have only put a few $100 into it. So that's what we designed the adverse impact fund to look similar and potentially act similar as the orphan well fund.
Commissioner Gonzalez.
Thank you, Chair, and thank you, Ms. Leger, and thank you, Mr. Michalski, for your presentation today. I've got a couple questions on this, and I guess one hiccup I have is when I think about trying to put the commission in a position to make these determinations on a potential payout under this, proposed fund, is what puts us in the position to be able to determine that causation and that connection and that nexus, right? There's no structural engineers on this. There's no, kind of risk analyses professionals on this commission. I'm curious why it would be best for that decision and that, control over that fund. Why is that best with us? And I understand that it may be hard to get what you want from an insurance company, but I think the argument there is the insurance company employs the appropriate people to analyze that risk, to understand and to apply, their own historical expertise towards those types of situations.
Chris, do you want to take that first?
So I can take a stab at it, and we understand that it's not easy to make that determination and make that causation determination. And I guess just to take a step back and touch back on what I told or discussed with Commissioner McGowan, is that the causation issue is a big concern for us, especially with a geologic hazard, which may be remotely triggered from hydraulic fracturing. And I can't see a world in which if an operator does trigger a geologic hazard, the causation issue isn't muddied in court or through the insurance company to where there's no payout at all. And obviously I'm speaking in hypotheticals here, but it would be difficult to manage this fund for the commission. But we think that an ALJ could have this hearing, and yeah, there's still attorneys involved, but we think that by having a centralized fund where the operator who allegedly caused the geologic hazard doesn't have as big of a financial stake in the payout, it may be less contentious as opposed to an operator being solely on the hook. We think, and then the adverse impact fund, we just see it as the backstop for a worst case scenario, what if event. Because we also understand that it's really difficult for the commission to try to plan for every worst case scenario, every one in 1,000 event, and to require every operator to provide financial assurance for every 1 in 1,000 event or 1 in a million event is not feasible. And we get that. And through this process, Natasha and I our best idea has been the catastrophic adverse impact fund. And maybe there are tweaks that need to be made to it. We might not have it perfect as drafted right now. And we're open to discussing that with the commission further. But we just think that given the precautionary principle ushered in by SB 181, there needs to be safety nets for a what if catastrophic event. And I don't know if that fully answers the question. It is a difficult question about how the commission makes the determination, the causation nexus that it's.
I think it does. Natasha, do you want to go? I'm sorry.
Yeah, I just wanted to add to that, which is, during the mission change, we had anticipated that, which is one of the reasons we had advocated for seismic monitoring and a traffic light monitoring system on wells. We had advocated for that for production wells, as well as injection wells. And ultimately, the commission decided to apply that just to injection wells and not to production wells. But we think that that's another way of being able to start to have that early warning system to address some of these causation issues.
So I think when we talk about things like causation and finding this nexus and what I think is the appropriate, type of I guess expertise to apply to that, I don't think that contention is a bad thing. Sometimes that helps you get to the right answer by having advocacy on both sides and presenting that evidence. I think that what y'all are asking for sounds like just an easier way to an easier payback for or payout for for damage that you're claiming or asserting is caused by offsite activity. And so, I think that's where we disagree a little bit, but I appreciate your responses and thoughtful responses in that regard. I'd like to move on to the amounts that you proposed. Did I read that correctly? 50,000 per well for the geological hazards financial assurance bond?
Yes,
And is that to be applied retroactively to all wells?
ideally.
Okay,
But-
so if we're looking at that number and assuming 50,000 wells in the state, that's $2.5 billion.
And
If I have my number right.
that's probably about right. The other thing that I think is important that we'd be willing to, would we be open to is narrowing that, geographically. So while we still believe that this should be addressed as a statewide issue, if there are concerns about that, and as we know that we always learn new things about the landscape and the geography of different parts of the state, that as issues are identified, they can be addressed. So I think that would be another way of being able to deal with that. And Chris, I don't know if you have anything else you want to add to that.
Just briefly, and another consideration that we thought of when talking about the adverse impact fund is that it would, so the way I read the financial assurance rules now is it only applies to new wells. Then we think that the catastrophic impact fund or adverse impact fund, so if a well already in existence, already in production, causes one of these adverse impacts, offsite impacts, the adverse impact fund can be retroactive, so to speak, and cover any damage caused by a well in existence.
I appreciate your response. I think I still have a lot of hangups on the causation and it being the determination being left with the commission. I have hangups on the amount, and then I also just have hangups on the idea of this never having us not having any data points of this actually occurring, and then creating such a large fund that would be covered by all operators and all wells for these, for this hypothetical that may or may not happen in the future, and we don't know in what, as to what level of occurrence is going to happen. So appreciate your response. I'll let you respond, Ms. Leger, but I think that's my comment on it.
And I also just wanted to clarify the distinction between the fund and the distinction between the bond, right? The bond that we were recommending would be tied to a geological mitigation plan. So that doesn't mean that every operator in the state is going to have a geohazard mitigation plan, because that was tied to whether they'd be operating in a geohazard area. So that number right there would be limited. And then the impact fund was proposed at $100 per well. So I just wanted to be clear between that $50,000 figure and the impact fund fee.
And the fund as well. Thank you very much. That's good clarification.
To jump in as well. Commissioner Gonzalez, I understand your hesitancy without a lot of data points on this, but we think that the reason there isn't any data points is because this is something that the commission has never really considered and we've never really monitored. It's hard to have data points for something that's never been a consideration or never been monitored. There could be geologic events that have been caused by oil and gas operations that we just don't know about because we've never had this kind of potential monitoring or impact fund to draw from. And to your point about the impact fund making it easier for someone to receive a payout for claimed damage, yes, that is the goal. I don't know if you've ever sued an oil and gas company, but we have. And when they fly in an attorney that gets paid $500 an hour, $600 an hour, and 4 experts getting paid $400 an hour within a day's notice, that's hard for anyone to argue. Any individual or small organization such as CHC to contend with. And I agree that a certain amount of contention is good, but when there is this war chest for lawsuits that industry has, it's hard for the individual to contend against that, even in a situation where they may be right. So we understand your concern, and this is hard to grapple with, but we've dealt with it on the ground, and just we're trying to figure out a way to make it more streamlined going forward.
Mr. Michalski, which lawsuit are you talking about?
CHC filed a lawsuit against Gunnison Energy, I believe 2 years ago.
It was against Delta County.
Delta County, Gunnison Energy intervened, and we had a temporary injunction hearing. Gunnison Energy had, I would say, 3 or 4 days notice of the injunction hearing and flew across the state. They had with an attorney and I think 4 experts. And there's nothing, I mean, it's hard to fight back against that.
I understand. I used to be a lawyer representing local governments, et cetera. I just was trying to provide some context on that lawsuit. And what offsite impacts were you troubled about in that lawsuit?
So that was dealing with seismic monitoring, and it was close to, or it was in an area that we believed could have been prone to geologic hazards from the seismic monitoring. We thought that the county did not follow their process. So it was actually a 106A4 action against the county for not following their process. And then Gunnison Energy was able to intervene, which we didn't even have a chance to respond to their intervention. Judge granted it, and within, like I said, the 4 days notice of the hearing in Delta County, they flew their attorney and expert across the state, and it's just hard to contend with. So we're trying to make this more streamlined going forward, and that's why that's just one case. There wasn't an offsite impact that occurred. It was more against the county, but just now having an inside view on how aggressive industry can be in any claim of wrongdoing. The concern is that when an offsite adverse impact occurs, there's no reason to think that the pushback's going to be any lighter.
Thank you.
If I could just jump in, just to clarify, Chris had mentioned seismic monitoring. It was actually seismic mapping, so it was seismic operations project.
Okay.
Don't want to confuse seismic monitoring with seismic mapping operations. Yeah.
Okay, great. Thank you both. Further questions? Ms. Leger, if you could make sure that you file your pleadings. There was a lot of red lines there that I know we want to take a look at, so we would appreciate that.
Absolutely, we'll do that.
Okay.
Thank you.
Very good. Thank you both for the presentation and for participating with us this morning. We do appreciate the perspective that you bring, which is a unique perspective compared to others that we've been hearing from, and so we appreciate that.
Thank you. Have a great day.
Thank you.
All right, we now have the Conservation Group and Larimer Alliance for Health, Safety, and Environment.
Good morning. Thank you. Can you all hear me?
We can hear you and we can see you, and we see your colleague, Mr. Delahunty.
Great. Thank you. Tom, can you go ahead and share your screen?
Is that coming in okay for everybody?
It is.
Great.
Give me one moment here. All right. Good morning. My name is Mike Freeman, and I'll be representing Logic, the Sierra Club, Earthworks, and Larimer Alliance this morning. With me is my colleague, Tom Delahanty. First, we'd like to thank all the commissioners as well as the staff for the work you've put into developing these rules over the recent months. I'll start off our presentation and then hand it off to Tom for his remarks. Next slide. You heard a lot yesterday about how much the largest operators and the trade associations like these proposed rules. That's not surprising because they're a great deal for those operators. But the proposed rules as presented are a bad long-term deal for Colorado. The old saying applies here. If you're trying to get out of a hole, the first step is to stop digging. The commission is making efforts to get out of a hole that was created by decades of inadequate financial assurances. But these rules would simultaneously continue to dig that hole even deeper, and that just won't work. Yesterday, a number of operators presented numbers about how much their bonding amounts will increase under the proposed rules. But it's important to keep those numbers in perspective. We ran an analysis of what the financial assurances would likely be statewide under the draft rules. And a conservative estimate found that the aggregate statewide bonds would more than double from current levels. The problem is that currently bonds only cover a very small percentage of the asset retirement obligations that operators have. It's about 2.7% of the total. So doubling those bonds from about 181 million statewide to on the order of $425 million statewide would only increase the aggregate bonding amounts to 6% of overall liabilities, which means the state would still be at risk of covering the remaining 94%. So the increase of bonding here doesn't fundamentally change the situation in Colorado and won't give operators a materially greater incentive to plug their wells in a timely fashion. These rules would also add multiple layers of complexity to the existing rules with 6 different tiers, adding a plugging list, and providing for exceptions to almost every rule. That complexity is a concern for us because we see numerous opportunities for companies to game these rules, and by doing so, to avoid the commission's intent in adopting the rules. And that complexity apparently concerns some of the larger operators as well. Oxy and Noble and a couple of other operators are advocating for a comprehensive bond that would allow them to avoid many of those complexities, which I think just illustrates how difficult these rules will be to administer. Now, we certainly support the effort to charge a per well fee and to use federal money to address orphan wells. But it's important not to overstate the benefits or the impact that money will have, because the funding available for the orphan wells program isn't likely to come close to covering the full scope of the issue. Just by way of example, if KP Kalpin and its 1,100 wells went bankrupt, that by itself would likely exhaust all the federal money available and all the state well fees for the next several years. So if the commission adopts these rules as drafted, you can expect that a decade from now, Colorado will find itself largely where it is today. There'll be some additional wells that have been plugged, but many other wells will reach the end of their useful life. And the large majority of those wells won't have adequate bonds to cover their cleanup. Kicking the can down the road this way is maybe appealing for operators, but it doesn't serve the state's long-term interests. And that's not what the legislature intended with SB 181. And now I'll pass it over to Tom.
Thanks, Mike. So to address some of the issues that Mike just discussed, we'll go over 5 main topics here for the remainder of our presentation. I'll begin by talking about the need for single well financial assurances for all new wells. I'll then hand it back to Mike to talk about the 3 kind of middle bullet points there on your slide. And then I'll wrap up to discuss a few sort of miscellaneous additional changes at the end. So the first issue I'll discuss is new wells. For this rulemaking to be a success, the Commission must require full cost bonding or single well financial assurance for all new wells. As Mike just alluded to, and as we'll discuss more, the rules approach for existing wells fundamentally has lots of problems. They're unnecessarily complicated, they leave gaps and loopholes, and the required bond amounts cover a really small portion of the potential risk to the state. Now, we understand that these imperfections, at least to some extent, are expected for existing wells because it's an inherited problem that's been building up for decades that this commission is now tasked with addressing. And that's a difficult thing, and we understand that. But there's just no excuse for new wells. Requiring full cost bonds upfront for new wells is a clean and straightforward opportunity to get Colorado on the right path moving forward, with all of the costs of doing business being fully internalized and all of the financial risk being borne by operators rather than the state. And we can do that while giving operators full and fair notice that going forward, this is what's required to do business in the state of Colorado. And here is just a short red line that would put single well financial assurance for all new wells into the existing draft. So it's also critical to recognize that this approach of full cost bonding for new wells is eminently doable as a practical matter, and it does not impose the burden on operators that it may seem. You've heard some participants in this rulemaking throw around some scary sounding numbers about the sheer amount of bonding that would be required under a full cost bonding regime. Now, first and foremost, any big sounding number really should be scary, not for its imposition on the operator, but for the risk to Colorado, because whatever bond amount the state chooses not to require is the amount that the state, risks being liable for. And furthermore, when you put the numbers into perspective with companies' profits, it just becomes patently absurd for companies like the Noble Oxy PDC group to act as though this will be a problem for them, which Mr. Lepore did yesterday. So using Oxy as an example here, based on their SEC Form 10Q, this is from 3rd quarter 2021, you can see that full cost bond amounts really are just a drop in the bucket. So as you see on the slide, Oxy reported almost $1.5 billion, that's billion with a B, in net income or profit in Q3 2021. So assuming it drills 200 new wells in Colorado per year, which would require around 18 million in single well financial assurance, Oxy generates the bonding for a full year's worth of wells in about 1 day and bonding for a single well in about 8 minutes. And using profit just from the Rockies region, Oxy generates a year of single well financial assurance in about 3 days and 1 well's worth in 22 minutes. So along similar lines, you also heard West Slope Koga yesterday throw out some putatively scary numbers, including the 255 million that would have been required if single well financial assurance had been posted for all wells spud by all operators in Colorado from 2019 and 2020. So again, to put that in perspective, that 255 million is about 1/6 of Oxy's quarterly profit, or the amount of profit that it generates from domestic oil and gas production in about 2 weeks. And again, that's for every well drilled in the state by all operators over 2 years. Furthermore, if surety bonds are available to the companies that are drilling wells, and you heard yesterday that the Noble Oxy PDC types are able to get surety bonds worth 30 million, then these already small numbers would be even lower, potentially as low as 1% of the bond value. So applied here, that suggests the actual costs to operators might be as much as 2 orders of magnitude lower than what's on the screen, i.e. like 4.8 seconds worth of profit or 13.2 seconds worth of profit in the Rockies to get single well financial assurance for 1 well. Now, the point here, regardless of the precise amounts, is that full cost bonds represent chump change for the multi-billion-dollar companies that are drilling new wells, period. Operator cost is not a rational basis for choosing not to require full cost bonds for new wells. The alternative to full cost bonding for new wells that's been proposed is single well financial assurance on transfer. And this approach is just flatly insufficient as a substitute. While we certainly support it as a backup measure, it just has too many holes to supplant full cost bonding for new wells. So you heard operators indicate yesterday that single well financial assurance will affect how asset transfer occurs and will prevent some transactions from happening. So if that's true, it also means that these untransferred wells won't get full cost bonding. But there's another point that probably will be much more common, which is that if buyers have to incur a substantial cost in the form of single well financial assurance when a transfer occurs, you can expect those companies to structure their deals in order to avoid those costs. So for example, the draft rules would exempt acreage exchange transactions, but it doesn't really define those exchanges or put sideboards on what qualifies. So a seller could potentially offload non-core assets to a buyer for a combination of cash and some small amount of acreage. And another example of transfers that could be designed to evade this new rule are stock transfers. And Civitas is the clear example of this that many of us are familiar with, where Civitas acquired multiple operators in the DJ Basin without needing to use Form 9s. And so under this model, a parent company can acquire assets without posting single well financial assurance. And then under draft rule 702C7, they could wrap other companies in under a single bond that's far less than a single well financial assurance amount. So while some parties yesterday suggested that this kind of transaction with bigger companies scooping up smaller ones are good, we just can't assume that the acquiring firm is actually a good risk. And again, Civitas is the great example here because it has a junk bond rating, which is to say that credit agencies have evaluated the company and concluded that it's a risky investment. We don't really see a reason for the state to take on that risk by allowing bonding for companies like that with less than single well financial assurance. And furthermore, this type of transfer also risks creating sort of a too big to fail problem where high risk assets are consolidated under a single company's bonding, which would leave the company with fewer regulatory options if things do go south. Furthermore, so operators can also use the plugging list to shield their transfers from bonding requirements. And that's because the draft rules currently exempt wells that are on the plugging list from the single well financial assurance transfer requirement. This means that the Shell Corporation strategy would still work. And this is one that we've seen in the context of Oxy transferring assets to CRC in California, which is a Shell company. And that would still be allowed under the rules as drafted, which we think is a pretty far cry from turning over a new leaf for the state on this respect. And finally, something we've talked about before, the commission's options remain uncertain, where a buyer acquires assets, doesn't post single well financial assurance, and then claims it can't afford to bond that. And this is the Overland fact pattern from a few weeks ago. So while the new rules would allow the commission to order wells shut in, that doesn't seem like a real solution if the buyer is just going to be orphaning the wells. And the draft rules also let the director call for a hearing, but that also doesn't provide a clear remedy. We're nervous about an approach that basically amounts to, when things go off the rails, just getting everybody in the room and trying to figure it out then. So the bottom line here is that transfer is just a difficult place to impose single well financial assurance requirements with a lot of loopholes that are pretty hard to fill. So while it's certainly better than nothing, and while we support this measure as one step, it's just not a substitute for full cost bonding for new wells. If the commission does choose to require single well financial assurance on transfer, then the rules really need to make crystal clear that if the buyer can't bond up, the seller has to provide single well financial assurance. This is really critical if bonding on transfer is going to mean anything. And we've got a simple red line here reflecting that. So I will now pass it back to Mike.
Thanks, Tom. I'm going to be discussing our concerns with the new options or tier structures. But before I do that, I'd like to address an issue in Rule 707 that's really important, but hasn't gotten much attention so far in these hearings. And that's the question of how the director's annual review of financial assurance plans will be documented. With the system that the commission is considering, the director's annual review is going to be key. Operators will be moving between tiers from year to year as their production levels change and as they transfer wells from operator to operator. And with the complexity of these rules, assessing operators' compliance and evaluating the extent to which they're gaming the rules is going to be absolutely necessary. The current draft of Rule 707, however, doesn't require any written report documenting the director's findings. In fact, the draft rule is actually really vague about what specific issues must be evaluated in each review. It's not even clear from the text that the annual review will, for every review, confirm that the operator actually is eligible to remain in the same tier. So the commission under Rule 707 should require written findings so that you, the commissioners, and the public can assess whether the operators are complying with the rules and complying with their plan and how the rules are being implemented. Without a written report from each annual review, it's going to be very difficult to do that. Moreover, this kind of a report has another benefit just in terms of incentives and enforcement. Because if operators know they're going to be getting an annual report card from the director, just the mere fact of that written findings or that written set of findings will give them a greater incentive to comply and ensure that they're following their obligations under the rules. The written report annually doesn't have to be lengthy or an extensive analysis. It can be just a form that documents that the key findings were made and noting what the basis for those findings are. Next slide, please. So this next slide is just a brief red line summarizing some language we propose to implement that in Rule 707. Next slide. So now I'd like to go into the tiers, and we think that the various tiers have a lot of issues with them. The main one, I think, is with option 6, which you've heard a lot yesterday. It provides for an operator to post a $30 million blanket bond, and by doing so, avoid many of the obligations of these rules. Doing so, I think would allow some of the larger operators to avoid those rules. And while the new staff draft adds some hortatory language about ensuring that operators are financially capable of meeting their obligations under the rules, the structure of these options will almost guarantee that in practice, the statutory requirement won't be met. Now, with regard to the option 6 bond, there doesn't appear to be any reason basis for choosing $30 million. Just picking the two operators that are most likely to use the option 6 bond, their current posted bonds are already well over that. They're 45 million for Noble and 46 million for Kerr-McGee. And putting that into context, a $30 million bond represents only about $6,000 to $7,000 per well for Noble and Kerr-McGee. And in exchange for that 30 million, both companies would be exempt from the requirements for inactive wells and the requirements for out of service wells, and wouldn't be required to bond up for well transfers. That's really significant because those two companies alone hold roughly 50% of the inactive wells in Colorado. And in exchange for that arrangement, there's no requirement in option 6 for an assessment that these two companies present a good risk, that they maintain certain production levels, or even that there's a cap on the number of inactive wells covered. We think that allowing the largest operators to take this approach would just be arbitrary. Moreover, there's another concern here more broadly, which is that if the commission adopts the sort of parent subsidiary consolidation proposed in Rule 702C7, other operators may also be able to use option 6 to evade the rules, and we're thinking in particular of the Civitas entities. Next slide. Now, next, we'd like to talk about tiers 1 and 2 for a moment. As drafted, tiers 1 and 2 would require a single well financial assurance only for excess inactive wells. But we actually like the approach offered yesterday by West Slope COGA, which would change that to require single well financial assurance, not just for inactive wells, but for all low producing wells. We'd go a little bit further than West Slope COGA and not require single well financial assurance only for excess low producing wells, but to require it for all low producing wells. In addition, we would support applying that kind of a requirement for plans under options 5 and 6 as well. I think the benefits of single well financial assurance for low producing wells apply just as much in options 5 and 6 as they do in 1 and 2. Requiring single well financial assurance for low producing wells would be a significant improvement, and it would help capture the individual low producing wells that are held by the larger and the stronger operators. As of 2020, roughly 36% of existing wells in Colorado were low producing. And so I think this would be a really significant step toward requiring adequate bonds on the highest risk set of wells. Second, and this is specifically with regard to options 1 and 2, you've heard this from us before, but we would ask the commission to require additional eligibility criteria for the blanket bonds here. As we've explained in our earlier presentations, blanket bonding is a form of self-insurance, and relying on production-based criteria for those blanket bonds is not a good measure of a company's capability to meet its obligations in the future. If blanket bonds are going to be allowed, the Commission should require a demonstration of the operator's financial strength with specific requirements for credit rating, net worth, and other measures. And as we described earlier, that's how EPA approaches this. We think that's a good model for the Commission to use. Next slide. Now, turning to options 3 and 4, these ones we think have major flaws. The tiers would apply to stripper well operators and to companies that are holding mostly non-economic wells. And they purport to require single well financial assurance for every well. But at the same time, they allow operators literally decades to bond up, 10 years for an option 4 operator and 2 decades, 20 years for an option 3 operator. Those timelines are much, much too long. Those long runways might provide some benefit if they resulted in operators bonding up in part over time, but the draft rule provides a way for operators to avoid much or all of the bonding up requirement, because it, in addition to single well financial assurance in a long time frame, it allows operators to subtract their plugging expenditures from any financial assurances that are due. And what that means in practice is that under these tiers, operators can use the out of service plugging list to get double credit for what they spend on plugging wells. The out of service list lets the operator avoid paying financial assurance in exchange for closing wells or plugging wells that are on the plugging list. And that reflects the goal of the out of service list. The idea there is to incentivize operators to commit to plugging their wells by letting them spend that money on plugging rather than bonds. But tiers 3 and 4 go a step further, and they let the operator not only avoid bonding for the wells on the plugging list, but then also deduct those same expenses for financial assurance for the rest of its wells that are not on the plugging list. And the effect of that double counting is to really obviate the single well financial assurance requirement under Rule 702. And that's because the rate of well plugging for wells on the out of service list is going to be faster than the 10 to 20 years required under Tier 3 and Tier 4. I know that's a lot, so let me offer an example to try and illustrate the point. If you take a Tier 3 operator that has 300 wells and it puts 100 of those wells on the out of service well list, for those 100 wells on the plugging list, the operator would, let's say, plug an average of 12 wells a year for 8 years. And if that's $100,000 cost per well, the operator will be paying about $1.2 million a year to comply with its obligations on the plugging list. At the same time, however, for the 200 wells that are not on the plugging list, the operator only has to bond up at 5% a year over those 8 years. And if you do the math, that's 10 wells a year, which comes to an expenditure or a bonding up amount of only $1 million a year. And so because the operator is spending $1.2 million to plug the wells on its out of service list, that more than offsets any obligation to post single well financial assurance for the 200 wells that are not on the plugging list over that time. And what the ultimate result would be is that after 8 years, that operator will have 200 unplugged wells not on the plugging list, and the Commission will have 0 financial assurances for those 200 wells. Next slide, please. There's a similar story for an operator that plugs wells or existing wells as part of drilling new horizontal wells. Mr. Lepore suggested yesterday that the Oxy and Noble and PDC companies are spending millions to plug wells out of the goodness of their heart. But the reality is that 95% of that plugging involves wells that are in close proximity to the horizontal wells they're drilling. There's just no need to give these operators an incentive to plug these wells because they'll need to plug them regardless as part of their development plans. And giving them a deduction for those expenses will shortchange the amount of financial assurances provided for other wells that are held by the operator. If the commission is going to allow operators a deduction for plugging wells, there ought to be limits on it, such as disallowing the deduction for wells that are on the out of service list, and disallowing the deduction where the operator is needing to plug those wells as part of drilling new wells. The commission could also consider only giving the companies partial credit for the amount spent on plugging their wells. Finally, I'll just touch briefly on option 5. The commissioners during your deliberations directed that an undue hardship requirement be part of the bespoke option. But the draft rules currently only state that the operator needs to believe that it would face undue hardship. There's no requirement for the operator to demonstrate undue hardship, and there's no requirement that the commission find undue hardship before approving an option 5 plan. And we would just ask the commission to require for option 5 plans that there be a finding of undue hardship. To summarize, the tiers really illustrate our broader point that the draft rules will get some wells plugged, but then they will continue the existing problem that Colorado faces today with numerous underbonded wells. We think the rules need to do both. They need to incentivize operators to plug their wells, but also require adequate bonds going forward so the state is protected in the future. Now I'll pass it back to Tom.
Thanks, Mike. So for the last part of our presentation, I will just go over a few kind of miscellaneous issues that are important, but that we want to sort of address fairly quickly. The first of them is federal wells. So overall, we're really pleased to see that federal wells are covered in the latest draft rules, which is something that we've been pushing for many months now, and it's great to have them included. So we appreciate staff's effort on that. However, we do think that the language could use some further refinement, and specifically, it's kind of dealing with the substantially equivalent language that appeared in the latest draft rules. You can just look to the recent Longs Peak OGDP to illustrate some of the challenges of applying a standard like that. But perhaps more importantly, this is just a context where a qualitative standard like substantially equivalent isn't as useful, where this is really a quantitative exercise where operators and the commission can just do the math to determine how much additional bonding is needed to comply with state requirements. We've heard a few times about differences between how the feds and this commission structure their bonds, like on a per well or a per lease basis, but we think that can pretty easily be broken down to the appropriate common denominator with the operator responsible for filling in gap there. So that's basically what these red lines try to do. We know that they're borrowed from Pitkin County with some slight modifications, and Pitkin County they've only got federal wells in their jurisdiction, so we'll happily follow their lead and support their approach on this issue. The next issue is dealing with deadlines for the plugging list. They could just be improved with the addition of interim deadlines. We're again really happy to see that there are firm deadlines included now on the plugging list. That's certainly a welcome improvement, and it's really necessary for the plugging list to mean anything. Without interim deadlines, though, operators could potentially delay plugging their wells for up to 8 years initially, and then 4 years for wells after that, without making any progress toward actually plugging them. And so the red lines that we're offering here would basically just require operators to plug a pro rata share or portion of the wells on their plugging list every year as they work toward their final deadline, or in appropriate circumstances to demonstrate other forms of progress toward their plugging obligations. And then the last issue is the trust fund concept. Again, this is a really good one. It's one that we support. We think that a trust fund helps facilitate exactly what responsible operators should be doing and say that they're doing by creating a mechanism to set aside production revenue for end-of-life asset retirement. Really important, though, it's imperative that COGCC and the trustee have exclusive control over fund disbursement and not the operator. That's how EPA does it for its UIC wells, and we would really urge the COGCC to do the same thing here. So that's what the red line is there, striking that sentence about the operator and commission sharing authority over fund disbursement. So we'd also note, kind of related to the last sentence of the draft language regarding mandatory trust agreement language, EPA also has specific requirements there for what kinds of investments the trustee can and can't make. And those are laid out in mandatory terms that have to be used when establishing a trust. So among other things, those rules would prevent the trustee from investing funds back into the granting operator's securities, and they would require annual validation by the beneficiary agency, along with some other good requirements. And so we think that all of those should be considered and should guide the COGCC's thinking and mandatory terms on trust funds here as well. So that concludes our presentation, and we're now open for questions.
Thank you. Commissioners, do you have questions? Commissioner Manjapa?
Thank you very much, Mr. Chair, and thank you so much, Mr. Freeman and Mr. Delahunty for your presentation today. I appreciated a lot of the information and examples you gave. There was one that you were going through rather quickly, and I just wanted to take a look at again, and that was the one of when you were discussing options 3 and 4, and your example had the 300 wells. If you could maybe just bring that up and kind of walk me back through that.
Is this the one, Commissioner Najaba?
Yes, yes, thank you. So this was related to the one-to-one deduction for plugging expenditures in the example there. I just wanted to make sure that I was understanding what you were saying in terms of how this relates to what they're contributing to the trust fund and what they're expending on plugging. And if you could just walk me through, I just want to make sure that I'm understanding.
Sure. So the core of this is that we think that the way this is structured creates a double counting issue for money spent on plugging wells. And the reason is that when an operator puts a well on the out of service list, the kind of trade-off there is the operator is excused from posting any financial assurances for that wells for 8 years or later on it's 4 years, but it gets a grace period when it's not required to post a bond for those wells. In exchange for that, the operator commits that it's going to plug those wells within that specified time frame. So it's already getting a benefit and a pass on bonding for those wells. What tiers 3 and 4 would do, though, would be allow the operator to double count that benefit by taking the same money it's using to comply with its obligations on the out of service list and apply that same money not just to avoid bonding up or avoid posting single well financial assurance on all of its other wells that aren't on the plugging list and that it hasn't made that deal for. And I'll walk through this example again. So let's say you've got an operator, 300 wells, and the operator puts 100 of them on the out of service list. So the operator has 8 years to plug all those wells. And if you just assume on average, that operator would plug 12 of those 100 wells each year. If the cost the operator is spending is $100,000 per well, that's $1.2 million in plugging expenses every year the operator is incurring to comply with its obligations as part of the plugging list commitment. Does that make sense?
Yes.
Okay. At the same time, the operator still has 200 wells that are not on the plugging list program. And if it's an option 3 operator, it's got 20 years to post single well financial assurance for those 200 wells. So that's 5% of the wells each year. And 5% of 200 wells is 10 wells a year. So the operator's, in theory, bonding up for about 10 wells a year. And if you use the same full cost bonding figure of $100,000 per well, that operators would normally be obligated to add $1 million a year or contribute $1 million a year for single well financial assurance as part of those to cover those 200 wells. The problem here is that, as written, the rule will let the operator deduct the $1.2 million for the wells on the plugging list from what it would ordinarily be obligated to pay for the rest of its 200 wells. And so there'd be a complete offset, and the operator wouldn't be required to bond up on any of its 200 wells for at least 8 years. And so the outcome there is after 8 years, the operator will have certainly plugged 100 wells, but there'll be 200 remaining wells that are not plugged yet, and for which the commission just has no financial assurances for that operator. Does that help?
So I think, yes, I think that was helpful. Thank you. I generally had followed initially, but I just want to make sure that I was understanding. So would if there was some language to require kind of a minimum that's kept in, that's held, before the deductions could be allowed, for expenditures towards their plugging, and with an understanding, or maybe there's a proportion of what's being held in trust that they can use on an annual basis towards their plugging costs, or something of that nature. Would that address this concern?
Yes, what we've suggested would be to simply, in options 3 and 4, say that there's no deduction for plugging of wells that are on the plugging list. So if the operator spends money to plug some of its 200 wells, in the example we're talking about, the operator could claim credit for that. But the operator couldn't get the deduction for plugging the wells that are on the plugging list, because it's already, it's already committed to plugging those in exchange for not having to post any bond for those wells at all. So I think the clean way to do this would be to simply say no deduction for any wells that are on the out of service well list.
Okay. Would you also support maybe a minimum that needs to be held at all times, in the account, or you have to get to a certain threshold before you can, and maintain a certain threshold before you can be deducting?
That would certainly work too. Perhaps, not allow any plugging deductions until the operator has reached 50% of single well financial assurance, or something like that. But, our view is that in addition to the double counting problem, it would make more sense to prioritize getting the operator to bond up, or ensuring the commission's covered if it's going to allow that kind of a long runway for the single well financial insurance.
Okay. And if I'm recalling correctly in the draft, that it's multiple types of financial assurance that can be used in these options. And so if there was, for example, a surety bond that covered that 50% amount, and then the remainder is in a trust, could that also help address this concern?
I think so. Your Commissioner Najapa, if the operator is willing to actually post more than 5 or 10% of the financial assurance upfront earlier, instead of just paying in over a decade or 2 decades, that would certainly be a better outcome, definitely.
Okay. And then the other question I had was related to the options 1 and 2. You were mentioning some of the EPA criteria, et cetera. Would you also be comfortable with those types of criteria allowing for operators with different production levels, lower production levels, to qualify into that option?
Are you thinking of, say, tiers 3 and 4, or?
If an operator would normally fall into 3 or 4 because of their production levels, but could provide, demonstration of strong credit rating, asset retirement planning, net worth, et cetera, as a way to on-ramp into option 1, for example, and in particular, if they could qualify for the surety amount in full, would you support that as an option to kind of allow for some additional equity for lower producing operators?
Sure. I think it's an interesting idea, and I'm sure the devil would be in the details there, but I do think that, as we've said before, the EPA criteria are really a much better measure of whether the operator is a good credit risk than just their current production levels. So, what we suggested, I think, in our closing remarks from the deliberations, was a much simpler blanket bonding arrangement where the operator simply had to show a certain credit rating, or as well as a net worth and other criteria, and it wouldn't necessarily need to be multiple blanket bonding tiers. So I think that concept could work. Again, the devil will be in the details in terms of what the language looks like.
Okay. And then the last question I had was related to option 6 of the comprehensive bond, and you mentioned some of the exemptions that are kind of assumed with that one. But there is still a requirement to provide a list of your inactive wells and kind of your intents and plans for returning them to production or to plug them, et cetera. Some of the things we've kind of discussed is a time frame in general for inactive wells, to be able to either be returned to production or to be plugged. If that was, is it more related to kind of some additional guardrails or parameters around things like that could make the comprehensive bond more appealing, or what else? What are your thoughts on that?
So I think I mean, those additional parameters and sideboards would certainly be useful to add. I think the issue is that if you start adding those back in, then the option 6 starts to look a lot more like options 1 and 2. In that, you're what it sounds like you're contemplating is adding in some of the safeguards for the other tiers, which would certainly be a useful thing to do. But by doing that, it really, I guess, raises questions about what the purpose of option 6 would be in that case.
Right, agree. And I think it would, I've been roughly running some numbers, and there may be some instances where the numbers are going to be similar. But I think that, obviously that when you're getting to some of those operators that have the really large well counts, it's, that creates an opportunity for them to, post a comprehensive bond that, covers all of these things. And I think that given that it is, likely going to be a surety instrument, that provides some additional assurance. But I do think that having some information about what is intended with those inactive wells and some timeframes and guardrails could assist with that. And but I just wanted to make sure, from your perspective, if are there any blind spots with that thinking?
I mean, I think again, the pros and cons really depend on the details of what would be included. Our key concern now is that whatever the bonding is for an option 6 operator, or really any operator, that the bonding has to bear some reasonable relationship to the risk presented. And so, for example, this is not a case where $1 figure is going to fit all operators. $30 million may look one way if an operator has 1,000 wells, and much different if an operator has ultimately gotten to 5,000 wells. And so I think, our key issue with whatever kind of sideboards or refinements are put on option 6 is that it needs to, have a connection to how much risk the state is left exposed for those operators, basically.
Thank you very much. Appreciate your time and thoughtful presentation.
Commissioners and Mr. Freeman and Mr. Delahunty, we do need to take a break to accommodate a commissioner's schedule from 11 to 11:30. We are not done with you, so we want you to stick around, but we will be taking our morning break. We apologize that it's atypical, but we have to address issues. So we will break now. We will come back at 11:30. We will continue with questions for this panel at that time. I anticipate we'll probably go for about an hour and then take a short lunch break around 12:30-ish, and then continue into the afternoon. So thank you very much for your presentation. Sorry for the haltiness, but this will give us a chance to go over our notes.
No worries. Thank you.
Okay, thank you, everybody. We will now restart with questions for the panel. Do commissioners have questions? Commissioner McGowan.
Thank you, Mr. Chair, and thank you for sharing your information today. Could you please explain to me, I think you all expressed some concerns about what transfers and single well financial assurance might look like in situations where it might not apply due to some kind of loopholes, and I'm not sure I'm quite understanding.
Sorry, I'm
You want
trying
to
to share
call
my
the slide up
slides.
and
Yeah.
explain that? Yeah.
And they disappeared. Sorry, just a sec. Can you see the slide?
Yes.
Thank you. Yeah, so thank you for the question, Commissioner McGowan. And you're right that we do see some problems with trying to use single well financial assurance on transfer as an alternative to full cost bonding for all new wells. And the reason for it is that there are several loopholes, that each of which is kind of briefly laid out here on this slide. The first three that we went through are basically ways that operators can structure deals to avoid having to actually post single well financial assurance on transfer. One of them is this like kind acreage. One of them is just doing stock deals or acquisitions that don't involve a Form 9 transfer of operatorship. And then also the using the plugging list, which under the current draft rules don't require single well financial assurance. And those are basically ways that they could avoid it altogether. And then the other point that we're raising is that even when there are situations that the commission is dealing with a Form 9 type of transfer, it's still not totally clear what authority the commission would have to ultimately enforce these kinds of, to enforce this requirement. And the fix to that last one that we proposed is basically just adding super clear language that the selling operator needs to post single well financial assurance on the buying operator's behalf if the buying operator isn't able to do so. So those are kind of our concerns, and then the best fix that we have for the draft rules as they are right now.
Okay, so can I walk through some of these with you? So I guess for point number one, what I hear you saying is you're not supportive of like acreage swaps being exempt because that's in the draft language right now, correct?
So I would put it a little bit differently. I actually think that the way, I think many of the ideas for single well financial assurance on transfer and the way that the transfer requirements are written are, at least in some ways, it's a good iteration or a good version of how to write a transfer rule. The problem is just more that inherent in any good transfer rule, there are still going to be some issues with it that don't make it a perfect substitute for full cost bonding for new wells. So, I'm not sure. I guess Mike, feel free to chime in here if you have a different opinion. I think maybe we're agnostic as to whether these kind of acreage swaps should or shouldn't be exempt. I think I understand why they exist, and operators have expressed and described the value in that. The point is that in order to sort of accommodate that, you end up with this other gap that that just leaves a loophole. So it's sort of a which problem do you solve type of question.
And I just, that's right. I agree with Tom. One additional point we just like to make is that during deliberation, I think there were some numbers presented about the number of wells that are transferred or have been transferred in recent years. And I think the implication from those numbers was to suggest that there's no need for full cost bonding for new wells because they'll all be captured on transfer. And the point we're making with this slide is that that's not likely to be the case because if the rules are changed so that there's a substantial cost associated with a Form 9 transfer, in other words, when there's a transaction that triggers a Form 9 transfer, the operators will have to, post a single well financial assurance. The number of those transfers is likely to go down dramatically because operators are going to restructure or structure their deals to avoid that requirement and avoid the need for bonding up. And what Tom has listed here are just some examples of ways in which they might do that. There are probably other examples and ways to structure these deals that I can't even imagine. But our point is simply that we're not opposed to a single well financial assurance on transfer, just that it doesn't eliminate the need for single well financial assurance for all new wells.
Okay, so that's a distinction there that I think I was missing. So let's assume that the model will not include single well financial assurance for all new wells. Then what are your opinions and thoughts about the transfer piece, and how does this slide fit into that?
So I think I misheard you say we're assuming that it does not cover new wells or does cover new wells.
So let's assume not. Let's assume it's the current draft. And how does this slide tie in with the current draft and how transfers are treated, which is single well financial assurance upon all transfers except swapping of like acreage, right? So I guess I'm trying to figure out this distinction of, sorry, I'm just going to stop there. So if you could
Sure.
explain to me, thank you.
Yeah. Tom, you want me to cover that? Do you want to?
Yeah, I mean, I think the sort of core ask that we would have if the commission is going to rely on single well financial assurance upon transfer as sort of a primary or really any tool to make sure that wells are appropriately bonded, then the most important thing is, I think, this red line here in front of you, which needs to lay out in no uncertain terms that if things do sort of go off the rails, and if the buying operator is not able to post a single well financial assurance, then the selling operator does. And that's not at the expense of this other piece that was in the rules, the latest draft rules, where the director can file an application to have a hearing. That's a perfectly fine tool to include as well. But it certainly needs to be clear that the selling operator must post single well financial assurance if the buying operator doesn't.
Right.
I see what you're saying. Okay. How does this tie into, if I'm understanding our current rules correctly, which is if the buying operator can't post the appropriate bond amount, regardless if it's single well or a surety or cash or whatever, I believe those wells go back to the seller. So in this case, you're saying continue to transfer to the buyer. Seller then is responsible for the bonding up to single well financial assurance for whatever was transferred. And then how do those two rules interplay then?
So, Tom, let me cover this. Our understanding is that if you have a situation where a buyer sells the wells to a seller sells the wells to a buyer, and the buyer doesn't bond up, the commission won't approve the Form 9, the operator transfer. But what that doesn't do is undo the change of title. The corporate, the sale of the asset as a matter of property still goes through. And our understanding from listening to the Oberlin hearing and other conversations is that this commission does not believe it has the authority to order companies to unwind an actual sale of property. What the commission...
Okay, so sorry, I'm going to stop because I think that the new rules do allow us to send the wells back to the selling operator. And I might want some clarification from our AAG just to... Yeah. Okay, let's go ahead.
Yeah, I mean, my understanding, and certainly I think that would be helpful from the conversations we have, is the difference is the commission doesn't have to approve the operator transfer. And so the selling operator would still be responsible for complying with this commission's rules and managing it. But that creates a problem because the buyer's got the property, the buyer owns the well now, and there's a question about whether the operator actually has access and the ability to comply with this commission's rules. So it creates a mess. And that's why the draft rules provide for this hearing to be held so that it gives the commission a chance to unwind, to sort that out and unwind the problem. What it doesn't, as I understand it anyway, allow the commission to do is order the buyer to transfer title back to the seller. The buyer still owns the wells. And what Mr. Delahunty just described here is that if the under Rule 218H in that situation, there should be not just a provision for a hearing, but it should be automatic for that in that situation, regardless of any hearing, regardless of what happens, the seller has to automatically bond up and provide the single well financial assurances so that the idea would be that when the buyer and seller are negotiating their transaction and the terms of that transaction, they go into it knowing that come hook or crook, one of them is going to have to pay single well financial assurances, and they can decide how to allocate that cost, but it's going to have to happen. And then just to circle back to our original point, we support the general concept here. We just don't think it's a substitute for covering new wells, because I think you're likely to see many fewer Form 9 transfers if there's this kind of cost associated with those.
Is that a good or a bad thing if we see fewer transfers?
I don't think it's either, unless you're relying on transfers instead of full cost bonding for new wells. This is not a way of getting most wells bonded up to single well financial assurance. It's a helpful measure, but we still think it's necessary for the commission to require full cost bonding on new wells.
Okay, so thank you. So if in these other instances where someone may be getting around the transfer rules to avoid single well financial assurance, and unless they have a comprehensive bond, if that stays the way that it is, while they wouldn't get single well financial assurance, someone would be picking up new wells, which would get folded into their option, whatever option they're in, and at the very least then would be reflected in how much they have to bond additionally as part of their option, correct?
I think that's potentially right. Let's just take the example of let's say a tier 1 operator who buys some new wells. The tier 1 operator is covered by a blanket bond. If that operator buys new wells, and just to keep this simple, let's assume that the new wells don't throw off its production averages to bump it into a different tier. It's in the same tier as before. It just has more wells. What you basically have is an operator, and let's assume we're not getting into excess inactives or other complications like that. The operator's got the commission will have the same bond from that operator with more wells and greater risk. And so our point is that none of this is a substitute for taking a clean approach going forward and saying, operators, the rule is clear from here on out. We're going to work through what to do with existing wells, but from now on, if you drill a new well, you need to expect that you're going to have to post single well financial assurance. So these complexities don't arise, and we're covered fully going forward.
Thank you. And I apologize. I'm not sure if Commissioner Nanjapa asked a variation of this question, which for me is thoughts about single well financial assurance upon transfer, but allowing the trust fund option to be one of the options for single well financial assurance. And maybe you have to put a down payment into the sinking fund or the trust first, but then allowing someone to bond over time to get to the single well financial assurance. I'm wondering if you have thoughts about that. And I apologize if Commissioner Nanjapa asked this and I'm repeating.
Tom, do you want me to cover this? Or?
Yes, I can take a first crack at it.
Okay.
I mean, I think that what you're describing, Commissioner McGowan, is an additional way that we can sort of try to shore up some of the inherent weaknesses in using transfer as the point where full cost bonds are implemented. Certainly there are tools available to make that process a little bit smoother and more streamlined. I think, employing a trust fund in a smart way is one of them. Ensuring that the buying operator is responsible for that the selling operator is responsible for the single well financial assurance if needed. That's another safeguard, right? I think there are a lot of ways that we can make this sort of as good as possible. But again, just going back to the core point here, this is perhaps helpful to the reason we have this slide in here, and the reason we're talking about this is sort of a response to the larger conversation that's happened over the past few weeks, where we've talked about full cost bonding for new wells, and that's sort of slid to this place of trying to implement the same protection or the same requirement, but doing it at the point of transfer. And I think our core point here is that even if you make this as good as you can get some benefit from single well financial assurance on transfer, but you're never going to get the same protections as single well financial assurances for all new wells. That's really the core point we're making here.
Okay, thank you. I guess my last question is, do you think the risk for a new well is the same as the risk of an older, lower producing well?
Probably not. That said, here when we're dealing with, all of this conversation for financial assurance is a conversation about risk management. And unless we sort of know the future, there's always going to be some risk for all wells. And I would, I guess, sort of challenge us collectively to ask why the state would ever want to take on that risk voluntarily, especially when there's such a clean, clear opportunity to internalize that risk to the operator with new wells.
And I just add to that, to the extent that this is really a low risk at the outset, at least at the beginning of a well's life, then the cost to get a surety bond for that is also going to be really low. I mean, you heard Mr. Neslin talk about for Noble, they can get a $30 million surety bond. If that's so, then it shouldn't be an unreasonable ask for them to get a surety bond to cover all their new wells.
Right. 8 minutes worth of profit.
Thank you. Well, I mean, I think you're talking about the really big players. I haven't really heard you talk about some of the more medium-sized players and what that looks like for their portfolio. And I'm sure that they can respond to that at some point in time if they want to. Oh, I had another question. Now I can't remember it. So thank you.
Sure.
Right. And on that last point, you're right. We did focus on the big players, and that's because they're the ones drilling the wells.
And even for the operator that's not, the average cost to drill a new directional horizontal well today is on the order of 5 to 10 million per well. So what we're talking about is a very small percentage increase in that cost. And if there may be operators drilling, smaller pads or, maybe non-directional wells, but then the bonds for those should be also smaller as well. So, if you look at this from the point of their assessment of the cost up front before they drill the well, it's not a huge expense on a per well basis for drilling it.
Thanks.
Other questions? Commissioner Messmer?
Thank you, Mr. Chair. Thank you, Mr. Delahunty and Mr. Freeman for your presentation. Couple of questions here. So understanding fundamentally your opposition to the comprehensive bond, at least is my understanding in the way that it's presented right now. Have you given any consideration of the utilization of a comprehensive bond in a bespoke approach type of arrangement where you are crafting that comprehensive bond based on an operator's portfolio, taking into consideration where they would sit in the tier structure, their blanket bonding, their inactive wells, so on and so forth, in order to be able to create a potential number that would allow for administrative simplicity, but not inherently create a discount in where they would naturally fall in the option structure, and whether that would be an appropriate utilization of the comprehensive bond in your minds.
I guess our question there, if I'm understanding the question correctly, would be if the commission makes the comprehensive bond look a lot like the bespoke option, it's not totally clear what the advantage of the comprehensive bond would be. Why, if it's got all the sideboards and the process required for the bespoke option, why operators, what the operators view the benefit of the blanket bond option as being. So, if the commission required a hearing for the comprehensive bond and the bond was sized to, somehow, be a reasonable reflection of the number of wells and the risk presented by those wells, those would certainly be a better approach than the comprehensive bond. But it would raise the question of whether that would achieve the goals of the companies they're advocating for comprehensive bond. If they don't get the simplicity and the and avoid the process, it's not clear to us, what the role of the comprehensive bond would really serve in that case.
And I think one of the benefits of the comprehensive bond, as far as the way that I'm understanding it, is administrative simplicity in addressing a a flat amount for some period of time. And so in a bespoke option, you could create the ability for a comprehensive bond to be in place for 3 years or 5 years without having to do the administrative analysis of significant, well, not significant, but just the analysis of the adjustments on an annual basis. So while you were in this comprehensive concept. So that's my understanding of the benefit of looking at it from that. I think there was another concept that was thrown out earlier testimony yesterday that included a cap on blanket bonding amounts at 30 million, not inclusive of any kind of inactive or low producing single well financial assurance requirements or any kind of transfer requirements. I didn't know what you or your client's thoughts were on that.
So is the question, would it be better to say that comprehensive bond wouldn't cover any inactive or low producing wells, basically, or?
I'm not utilizing it. I don't think it was presented as an and/or. It is simply another element in the blanket bonding tiers that would set a cap at 30 million in the blanket bonding option 1, option 2 of 30 million, not inclusive of these other things that I had just mentioned.
I guess I'd have to see exactly how that was structured to really answer that. The question we have is, if there's a cap of 30 million on the blanket bond, what comes after that? For example, Oxy and Noble, for Oxy and Noble, 30 million means about $6,000 or $7,000 per well. Would they then be required to pay a surcharge for additional wells, or what would be, or would it just be, what would that look like?
Well, I'll give you an opportunity to do some math on that and apply the existing blanket bonding structure, and you can see how that would, whether or not that would be palatable. But I think it's important that you look at the existing numbers in the blanket bonding option structures and see even if any operators currently would be able to hit that $30 million cap in a straight blanket bonding scenario. So we can circle back around on that one. I want to go to your concerns around option 3. And I think perhaps you're mischaracterizing how option 3 works a little bit. While I appreciate that you're looking at things in a critical manner, and I think that's important as we look at all of these rules and as we're applying some of these ideas. I think one important element associated with both option 3 and option 4 is the idea that there is a commission hearing associated with them, where we look at the entire portfolio of an operator's assets, look at their retirement schedules, look at the wells that they intend to put on an out of service list, and then make an adjustment based on anticipated life of the wells, anticipated wells that are on the out of service list, any other factors that may be associated with that, and determine what the appropriate amount would be to put aside over some amount of time in order to accomplish single well financial assurance. So I don't think it's fair to say that they're going to utilize all the funding in order to be able to plug and abandon a third of their wells in the first 4 to 8 years and then have no financial assurance associated with that. I think that you're looking at that in a short term rather than the holistic financial assurance plan that gets developed with the option 3 and or option 4 concept when you're looking at how to accomplish single well financial assurance over a period of time comprehensively.
And that's a fair point. We did the analysis based on the numbers and the provisions, the default numbers and provisions in the rule. But it's certainly true that the commission has the opportunity to depart from those. But our point is that to the extent that the commission moves toward, a operator by operator bespoke type approach where it takes a fresh look and a full analysis of every operator, that's going to be a really huge administrative burden, both for the commission and the staff. And we would just advocate that the commission write these rules in a way that they're easy to apply and can be implemented without undue burdens on the staff and the commission. That's really why we started with the phased compliance plan to begin with the hope being that by keeping these rules simple, you won't have to do an operator by operator analysis and dig into the situation for each operator with a separate hearing, taking up your time and the staff's time for that.
And then on Rule 707, I think it's a good point that you bring up in Rule 707, and I'll look at the language that you suggested there as we analyze that, because I think that's, I think it is important that we have a record of review. And so appreciate you bringing that up. I don't have any further questions. Thank you.
Further questions for the panel? Mr. Freeman and Mr. Delahunty, if you could please make sure that you submit your red lines for us. Commissioners are going to be busy over the weekend looking at stuff, so appreciate that. Appreciate your being with us and presenting yet again.
Thank you.
Thank you.
Okay, I believe now we have Western Resource Advocates. Good morning. By 2 minutes. Still morning.
Good morning. Also with me is Dr. Allward.
Let's get him on to the panel.
When I joined as a panelist, I missed all the dialogue that happened during that time. So
we can hear you, Mr. Allward. Can you hear me?
yes, okay, here we go.
Oh, and we can see you too. Welcome.
All right, and I will share my screen.
We'll hold on until we get the screen sharing all done.
Are we there?
You're there. We can't see your next slide, but that's okay if that's what you want it to look like.
No, not really. Sorry about this.
No problem. Take your time.
Because now I've just reduced my whole window.
Ms. Larson, tips?
Am I still sharing?
So if you put it back in presentation mode, I believe you'll be able to select the manner in which it's presented to the world. So right now it's prompting your next slide. I think if you go to display settings towards the upper left hand of your screen, I think you'll be able to adjust the view.
Is this looking better?
Yes.
There you go. Now you got it.
Okay.
Okay. And now I get to say good afternoon to you both.
Thank
Good afternoon,
you.
Chair, Commissioners.
Thank you, Commissioners, Director Murphy, staff, parties, stakeholders, and hearing officers. I'm Dora Walker on behalf of Western Resource Advocates. And as you know, with me is Dr. Allward, ready to take questions you might have. As we have done throughout this rulemaking, we're going to focus on the definition of single well financial assurance. We do this because making sure locations and facilities are fully reclaimed is critical to the mission change mandate, including protecting wildlife and biological resources. Next slide, please. As currently defined, single well financial assurance is either the demonstrated costs or estimated costs of plugging and reclamation. Under the rule to estimate costs, the commission will consider plugging costs based on well depth, a per well reclamation matrix, and 7 additional relevant factors. In this presentation, we offer fixes to the draft rule and once again make a plug for an expanded matrix that puts flesh on the bones of the 7 additional relevant factors. We then point out the pitfalls of setting a specific default or one-size-fits-all cost estimate, like the one proposed by West Slope COGA yesterday. And as part of that discussion, we look at another set of orphan well program data and show that using average or 80th percentile of actual costs as a default fails to capture the not uncommon situation where actual costs are much higher. Next slide, please. First, turning to the current single well financial assurance estimate of plugging a well. This estimate is simply too low. Dr. Allward characterized the actual costs and depths of wells at the state's 23 orphan sites. The costs he found were $22,000 for shallow wells, $55,000 for medium depth wells, and $63,000 for the deepest wells. Moreover, the average cost of plugging those wells at the 23 orphan sites was $52,000. And even the West Slope COGA data showed an average plugging cost of more than $43,000. Therefore, the data in the record shows the current rule substantially underestimates the actual cost of plugging wells. Next slide, please. Second, the reclamation matrix. The current rule calculates reclamation costs on a per well basis. As many have commented, estimates of reclamation costs are appropriately based on acres disturbed, including acres of access roads, rather than on a per well basis. This is because costs increase as the size of the surface disturbance to be reclaimed increases. Next slide, please. Third, the list of 7 additional relevant factors, which under the current rule, the Commission will consider to estimate costs. A chief reason the current definition of single well financial assurance has survived this far is because the Commission was looking for a rule that was less complex, but still resulted in an accurate cost estimate. But actually, because the definition merely lists the 7 additional factors, the resulting rule is complicated indeed. There's no direction as to how those factors are to be weighed or how the associated costs are to be calculated. What's more, the rule lacks transparency, could result in significantly different outcomes depending on who applies it, and the indeterminate nature of the rule will undermine public trust in the process. Next slide, please. Dr. Allward's matrix, based on the 23 orphan sites, actually makes the reclamation matrix less complicated and burdensome, exactly because he assigns costs to these 7 additional factors. The list of additional factors corresponds to the elements of Dr. Allward's matrix. The only difference being that Dr. Allward addresses high priority habitat by looking at cost to restore native vegetation and adds age of a location as an additional factor. Next slide, please. This slide shows a revised matrix along the lines of Dr. Allward's proposal can be easy to apply. Plainly, the current rule anticipates the same information on the 7 factors would have to be available to the Commission. So Dr. Allward's matrix does not add any additional information or other burdens. Also, we have added citations to existing rules that require exactly the type of information associated with the 7 factors, information that the Commission is already comfortable requiring. Next slide, please. Fourth, here we want to point out an additional concern with the first part of the definition of single well financial assurance, that costs can be demonstrated. Under the rule, there's no criteria associated with that demonstration. However, there must be some way for the Commission to judge the accuracy of a demonstration. Therefore, we suggest that the rule require, as part of any demonstration, that the operator address and the Commission review all the factors relevant to a single well financial assurance estimate, including the additional 7 factors. Next slide, please. Turning to the question of establishing a default or one-size-fits-all estimate of plugging and reclamation costs. First, the problem with the default estimate coupled with the opportunity to demonstrate lower costs put Colorado at significant risk. This is because those operators who believe their costs will be below the default amount will demonstrate those costs as provided by the current rule. Those operators who believe their costs are at or above the default will be content with the default, but their actual costs may be way above the default. What this means is that by setting too low a default and an opportunity to demonstrate lower costs, the state will not be protected. This is because most of the time, the single well financial assurance default will be below or well below actual costs. Next slide, please. Let's look at some additional cost numbers. As Dr. Allward previously explained, based on the 23 orphan sites, the average cost of reclamation was $40,000 per acre. However, the 23 orphan sites represent a small data set that is not representative of the range of circumstances found across the state. Therefore, Dr. Allward went looking for more data and found costs associated with the state's orphan well projects in progress. Because these projects are in progress, actual costs will increase. From that total data set, he looked at projects on which spending was more than $25,000 because $25,000 was the lowest total cost associated with the 23 orphan sites. So Dr. Allward assumed that nearly all the projects would ultimately cost at least $25,000. Here's a graph that shows the 58 of the original 92 in progress orphan well projects with costs already above $25,000. Note the average cost for these projects, $239,000. Note the 80th percentile of these actual costs for these projects, $339,000. Note where the West Coast COGA quote for the 23 well pad of indeterminate size would fit into the spectrum. That quote was for $182,000. And note just how many expensive projects in progress are more costly and much more costly than the mean, the 80th percentile, the 23 well pad project, and the West COGA proposal of $140,000. Next slide, please. Also, it's important to understand that the in-progress costs are for projects, but this was the only data set available, additional data set. Dr. Allward looked more closely at some of those projects. Remember, he needed more data points. One of the $1 million projects consisted of just 2 locations and 0 wells. The 2 locations were 3.4 acres. The cost for this project was greater than $500,000 per location and $152,000 per acre. Dr. Allward tracked down information for 3 other high-cost projects. For these 3, he estimated actual cost to be $62,000 to $359,000 per acre, or $83,000 to $1,000 per site. Here are the take-home messages from our presentation. Next slide, please. West Coast COGA was wrong to say its proposal would protect the state in 9 out of 10 cases. To achieve what West COGA promised, that the default would reflect the 90th percentile of costs, the default would have to be $1 million. All that Dr. Allward has presented to you shows that his matrix is an accurate, fairly simple way to get at actual costs, including the 24% of high costs that are above average. It shows that the list of 7 additional factors holds the key to accurate single well financial assurance. And what we have also shown is that average plugging and reclamation costs are high. And the more we know, the higher those numbers have gone. We started at $58,000 and now West Coast COGA is suggesting $148,000. And not uncommonly, actual costs are very high and well above average. Thus, as you consider blanket bonds and Uber bonds and claims about how many wells can be plugged and locations reclaimed for how much money, please keep this analysis in mind. Thank you.
Thank you both for the presentation. Questions? Commissioner McGowan?
Thank you, Mr. Chair. And thank you for sharing this again today. I think I'm one of the folks who just has felt that the matrix was rather complicated and that we would have back and forth all the time with operators about whether they did or did not have certain situations. But aside from that, could you go back to the slide where you're showing the 80th percentile and the mean and the median? Yeah. So it's been a while since I've had a stats class, and I took stats for dummies in college. So let's just preface all of that. But I think when we look at data, you have to take into account any kind of outliers that skew your data. And so I'm just curious to know what these numbers look like if you take that $2.5 million project out of this, and then what happens to your mean, median, and 80th percentile? Do you know?
I'm assuming the question's directed at me primarily. So,
Or, you know, if Duro wants to jump on that.
So if we remove just the high value, the 80th percentile will drop to whatever the next lowest cost was. I'm not exactly sure what it was, but I believe it was in the $300,000 range, because the 80th percentile is just based on the number of projects. It's not an 80%, which it's the 80th percentile. So neither the median nor the 80th percentile would change by much.
Okay, so
And
sorry, hold on one second. So
yes.
I think I've heard other folks who have testified not say 80th percentile, but they want 80% of the cost covered. So what would that look like?
So 80% of the costs.
So if we took like the average single well financial assurance, they want single well financial assurance, I think, to be set at 80% of that, if I'm understanding past testimony correctly. Does that make sense?
I mean, your question makes sense. I don't know if I was hearing 80th percentile. And so I don't know if that's what others were actually proposing.
Okay.
And as far as the percent, the mean plus one standard deviation would be 84% of the values. So that's where we would be looking at, would be something more like that.
Okay, thank you. This is an interesting perspective, and I appreciate it. It helps to have it all kind of laid out.
Commissioner, may I ask you a question? So you're saying 80% of cost, but 80% of what? Average costs or total cost? I mean,
well, and perhaps, Ms. Walker, perhaps I was misinterpreting or understanding other folks who testified previously. I was under the impression that they wanted 80% of like the average cost covered in the final number that we chose for single well financial assurance, but I may have misunderstood that.
Well, we definitely have at various points offered estimates of average costs based on actual cost data. So then you would just multiply it by 0.8.
Yeah, thank you.
Commissioner Gonzalez.
Thank you, Chair. Thank you, Dr. Allward, Ms. Walker, for your presentations today. Appreciate it. I've got a question about kind of the second line at the header about these being 58 wells from the Orphan Well Program, of which $25,000 or more was spent. How many wells from the Orphan Well Program had spends of less than $25,000?
Of these in progress ones or of the completed ones?
I'm looking at your data here. So whatever parameters you put on this data that we're looking at from 25,000 to 2.5 million, what does that number look like if you included everything from 0 to 2.5 million? And I'm saying, you know, and I'm kind of looking at this from the perspective of Commissioner McGowan's question. If 2.5 million seems like an outlier to me, but it seems like you excluded anything less than 25,000 perhaps as outliers. And so that's just a bit of a manipulation that seems that I'm not quite comfortable with. I'd like to understand what the whole picture looks like.
Certainly. And I picked $25,000, not completely arbitrarily, but because that was the lowest cost of the 23 wells that the staff had presented in their presentation. So I made the assumption that that would ultimately be the lowest cost. There were 34 wells lower than $25,000, and they range from $14 to $24,000. So, and these are all in progress, so they are not yet completed projects. I think it's fair to say that anything below $1,000 is just barely begun. Where to actually make that cutoff is open to interpretation. That's very fair. And then what was I'm sorry, I don't recall what the follow-up.
Oh, I think it was just a
Oh.
long-winded question. I don't know if there was a follow-up, but let me know.
Yeah, what would the data look like? Well, there'd be a lot more data in the less than $50,000 bar. And the mean drops down then to $111,000. The 80th percentile is $82,000. But it seems very, it doesn't seem reasonable at all to me to include the $14 and the $103 project costs in this analysis at all.
Yeah, I mean, I think that's fair when we consider outliers on both ends of the distribution. So that's just more of a comment. And I think it's just helpful for me to understand kind of the parameters for this analysis.
And I appreciate the taking outliers out, but I don't think that's reasonable when we're trying to protect the state. It's those outliers that are going to get us. And so I think the high costs we need to make sure we include. And since all of these are in progress, and I don't know what state they're in, if they're 99% done or 50% done, that $2.5 million may not be an outlier if those other $1 million projects still have a lot of spending yet to come.
Is there any data? I appreciate that, right? You know, we're looking at incomplete data here. If you're looking at incomplete projects, right? We're just kind of placing that number on where they're at, you know, at this certain point of time. Is there enough data to look at completed projects to apply the same sort of analysis to?
So what I don't understand, there's 50 completed projects. And they overlap with the staff's 23 that they provided in their earlier presentations. And so I don't know why the staff did not choose to include all of those 50, but they did include that $200,000, which was the maximum among those completed. But again, all of those in the 23 orphan well projects that they provided to you were all on very flat ground, mostly agricultural, less than a half-acre disturbance. And so those wells are completely unrepresentative of what wells we're looking at going forward. I think your staff has all the details about how much these things cost and what might be more representative or less representative. And I really think for more details, you need to be looking at them.
That's fair. Thank you.
Further questions? All right, well, thank you both for the continued presentation for us. We appreciate that. I appreciate sort of the diving in on the one topic for us. It's really helpful.
Thank you. I appreciate it.
Thank you very much. Good to see you all again.
You too, Dr. Howard and Ms. Walker. All right, commissioners, it is 12:21. Our next presenter is a 40-minute presentation and then Q&A on top of that. So I think we should go ahead and take a short lunch break, maybe 30 minutes if we can get that done. So return back at 12:51. See you in 30. All right. Welcome back, everybody. It is 12:51, and we now will hear from our next group, the Conservation Alliance. And I see that we have Mr. Sura with us, and we have his slideshow on the screen.
Wonderful. Thank you. Is everybody shown up?
Yes, we have all of us. I believe that a commissioner or two may still be finalizing lunch plans, and therefore they may not have video on, but we are all here.
Sounds great. Thank you. My name is Matt Sura on behalf of Conservation Colorado, Western Colorado Alliance, and Grand Valley Citizens Alliance. I want to note at the start that the organizations have donated 9 minutes to Adams County, Aurora, and the Allied Local Government Coalition. So my presentation will therefore be less than 31 minutes. And I better set a timer. Go. So there are 6 areas of concern that we want to address today. One is the inactive and low producing wells, single well financial assurance, option levels, out of service wells, size of the problem, and administration of this rule. To start with inactive and low producing wells, these are the wells that are at the greatest risk of being orphaned. And I want to get into the definitions of those as well. First, no one wants to buy an inactive or low producing well. We heard this very clearly during the first early days of this effort during the straw dog hearings, when the Small Operator Society stated that wells that produce less than 2 barrels a day were unmarketable. There's no market for these low producing wells, and therefore they represent the greatest risk to the state for becoming orphans. I want to just take one more second to go through the PetroShare example. And I know that we've discussed this before, but hang with me. The PetroShare actually filed for Chapter 11 reorganization, but then ended up being forced into Chapter 7 liquidation. They had at the time an average well production of over 26 barrels a day across their portfolio. And PetroShare is not a unique example. In discussing this with a bankruptcy attorney, I understand that it is the debtors, creditors, and a bankruptcy judge that get to decide whether a bankruptcy will go forward as a Chapter 11, or whether it will be shifted from a Chapter 11 to a Chapter 7, as was the case here, and all their assets will be liquidated. Now, we have to assume that this will continue to happen, and all types of operators with various levels of production will be forced into Chapter 7 bankruptcy. And when they are, it will be the state of Colorado that will have to address these low producing wells that have become orphaned. We also have Extraction, a publicly traded company who filed for bankruptcy, even though they would have qualified as an option 1 operator at the time. I mean, we are fortunate that they were not forced into liquidation. In 2014, Occidental sold all of its California assets to California Resources Corporation, and within 5 years, CRC accumulated several years of financial losses before going through bankruptcy in July 2020, or filing for bankruptcy then, with more than $6 billion in total debt. This left in question the cleanup of more than 18,000 wells in the state of California, the fate of which were going to be decided by the creditors of CRC and a bankruptcy judge. So moving into definitions of low producing well and an inactive well definition. First, I'd like to say that there was a lot to support from Western Slope COGA's presentation yesterday, and really appreciate that effort. We do not, however, support Western Slope proposed changes, Western Slope COGA's proposed changes to the definition of low producing well. We encourage you to continue to support this definition that has broad support from both industry and local government stakeholders. I understand that there's been some discussion in requiring single well financial assurance for low producing wells and removing the need for a production threshold for this inactive well definition. If that occurs, we would support removing the production threshold from inactive wells. If it does not, this is what we would propose instead of what is there today. Moving into single well financial assurance, I want to talk a little bit about how it applies to low producing wells, transfers and new wells, and calculation of single well financial assurance. Now, after Western Slope COGA's presentation yesterday and the excellent job that Ana Gutierrez did, I have removed about a half a dozen slides, you'll be happy to know, on this issue. I have to say I was really heartened by that presentation and their position to require single well financial assurance for low producing wells for option 1 and 2, as this language would do. We also believe that the requirement for single well financial assurance for low producing wells must be applied across all option levels, including options 5 and 6. Calculating single well financial assurance is challenging, and you all know that. While we support the proposal by Rich Allward and Western Resource Advocates, we heard and understand your concern about the complexity of that proposal. We still believe the Allward proposal will be far more accurate than anything that has been proposed. However, after your discussions, we've worked to improve the proposal by the Colorado Oil and Gas Conservation Commission staff. Now, the COGC staff believes that they can calculate single well financial assurance through matrix, and so we have also used that framework. We believe with slight changes, the staff proposed matrix will be far more useful, accurate, and more protective than the current version. Now, looking at this slide, there are really two issues that we want to separate when you're looking at a single well financial assurance. The first is the location. And we've been talking about this as a single well financial assurance, but it really should be a single location financial assurance that accounts for wells that are present or not. There are a number of production facilities, as an example, that should be protected under this financial assurance rulemaking, but because they don't have wellheads located there, they may not be. So we're looking at a single location financial assurance, first and foremost, recognizing that it does need to account for the estimated cost to plug and abandon a well. And we have read and listened to Director Murphy's presentation, particularly the one in July, where she stated that the average cost just for plugging wells in the state of Colorado, as paid for by the state of Colorado in the Orphan Well Fund, was $52,000. Unfortunately, that $52,000 doesn't show up in the staff draft, and so we have adjusted it to reflect the actual cost that the state of Colorado has experienced. So for a well that is drilled to a total depth of 3,000, we're looking at $20,000. For a well drilled to a depth of 3,000 to 6,000, we've changed that to 40,000, and then for wells drilled to a depth of 6,000 or more feet, it's a $55,000 financial assurance. Again, we feel that this is more reflective of costs that have been incurred by the Orphan Well Fund of the state of Colorado. And frankly, it's more in line with what Western Slope COGA suggested the actual costs are, at least on the Western Slope. Now, turning to the reclamation matrix, again, we're looking, instead of a single well, we're looking at a location. And this also is reflecting the fact that you have a number of locations, particularly the ones that are being drilled now, that are multi-well locations. And this is a point that Western Slope COGA made, and we agree with. You know, certainly you shouldn't be penalized for doing multi-well pads. I mean, that's something that we want to encourage. And so there is likely going to be far less reclamation cost if you've got a number of wells on one location. So we'd like it to reflect that. So we're looking at a per oil and gas location. That's a defined term, looking at $25,000 up to 2 acres of disturbance. And then every additional 2 acres, $25,000. We think that this is really reasonable, certainly in line with what we've heard in some of the testimony, and will allow for the state of Colorado to address a large well pad that's 20 acres differently than a well pad that is 1 acre. And this just makes sense. We also want to make sure that in some places, and we saw this in Professor Allward's testimony, is that on the Western Slope in particular, there can be access roads that are going through prime wildlife habitat that are 2 miles and longer. And those also need to be accounted for in this accounting of disturbed acreage. Moving to option levels. We want them to be consistent across options. We want to level the playing field in respect to natural gas producers under all options, and want to look at the Uber bond and spend some time there. So turning to the submittal requirements, the bulk of the 48 pages of proposed rules is restating the required submittal requirements for each and every option level. We believe this is not only unnecessarily duplicative, but also confusing. Furthermore, we believe that a strong submittal requirements for one option is important for every option. This financial assurance should, in these requirements, these submittal requirements should apply to every operator in the state. In this language, again, we're just moving some of the current language that is found in option 1 in this case, but we've also added some additional criteria for really getting into certification of financial capability. This is some of the language that was offered by the conservation groups. It came from the EPA language that has been referenced by many operators, or by at least one operator and many other parties, and wanted to include that here. Moving into the submittal requirements, again, with the exception of the low producing well list section, this is simply moving the requirements for option 1 to make them requirements for all operators and for every option level. We contend that these are important submittal requirements for every operator. We've added a requirement for new wells and locations, but the rest is current language. We're advocating that every option level, including options 5 and 6, will need to have all of these categories of financial assurance, including single well financial assurance for transferred wells and new wells. Low producing wells are also required for each option, but listed separately under each option. And as an example of that, here's a streamlined option 1 requirement that only needs to refer back to the submittal requirements and financial assurance requirements. And moving into this is putting a finer point on the certification of financial capability. The submittal requirements just said the categories of information that we want. This is getting into the details of what we expect to see for them to be able to qualify for the most rigorous blanket bonding level that there is in the state of Colorado. We think that there should be these credit ratings. As opposed to that, you could look at the liabilities to income ratio. All of this information is going to be provided to you. I don't have the time to read it to you, but you've seen it before. And again, we would like to see these requirements be the same for all blanket bonding levels, including options 1, 2, and 6. So again, here's the information you saw earlier. The financial assurance amounts we haven't changed, but the inactive wells, because it allows for 10% of the operator's total number of wells, excluding out of service wells, we have to list those separately, and we've done that for each level. Again, I was really heartened by the presentation of Western Slope COGA yesterday, and appreciate the thoughtful work that Ana Gutierrez and her clients, Western Slope COGA, did. Particularly appreciate the support of single well financial assurance for low producing wells, although we need to reiterate that we support the current definition and not the proposed Western Slope COGA definition for low producing wells. However, we believe that this slide in this presentation was misleading and actually not that helpful for a financial assurance rulemaking. In this bell curve, the Piceance Basin operators are placed on the curve to demonstrate that the very low proposed thresholds for natural gas producers make sense. Well, this is the wrong metric for us to be concerned about. It is the wells owned by those operators that is our concern. And those are the risk to the state of Colorado. So let's see where the wells will land using the various option levels. As you can see on this slide, the more than 27 operators, 27,000 wells owned by gas operators, determined after numerous hours of wrestling with spreadsheets and oil and gas ratios, demonstrates that for at least 2020, the information that we had, there were 27,500 wells owned by 97 gas operators in the state that would land in terms of option levels, mostly in option 1. As you can see, nearly 17,000 or 61% of the wells owned by gas operators would be in level 1 using the extremely low thresholds in the current draft as compared to oil. For example, at current commodity prices, an option 1 operator could make $360 a day per well across their portfolio. That's the level that is being proposed right now by Western Slope COGA and adopted in the current draft. This is based on a ratio of 1 barrel equals 1 MCF. Because if it was an oil operator, they would have to make an average of $5,400 per well across their portfolio of wells. This 1 barrel equals 1.5 MCF is a ratio that cannot be found in literature and cannot be justified as a basis for thresholds based on the bell curve you see here. Placing most of the gas wells under level 1 is not accurate and will not adequately protect the state. Here's our proposal, our alternate proposal for gas producers. The industry itself has stated that 10 MCF is a low producing well. So that's $40 a day at current high commodity prices. We made that the cutoff for option 4. For the rest of the options, we changed the oil to gas conversion to 1 barrel of oil equals 3 MCF. This is the chart that begins to make a lot more sense and mirrors how oil wells are distributed through the option levels. And this is the money shot here. This is how the 2020 operators and their wells would be distributed using the proposal that you currently have before you. We would contend that there is a bias here. This is mostly natural gas operators that are in tier 1. And that is not accurate or a reflection of the risk that they pose to the state of Colorado and needs to be adjusted. Again, adjusting it the way that we proposed, this is how the 2020 operators wells would be distributed using our proposed changes to natural gas thresholds. Again, that's all we're changing is the natural gas thresholds as you see here. And this is how we've changed them. Again, it's going to be less than 180 or more than 180 MCF at the top tier, between 45 and 180 MCF. Second tier, the third tier is more than 10 to 45 MCF, and then less than 10 MCF as tier 4. Moving to Uber bond, the option for the option 6 or Uber bond is just bad policy. It allows operators to be able to cheaply buy their way out of nearly all the important financial protections and incentives for plugging wells in this rulemaking. As an example, there are no production requirements in the current draft. Being publicly traded is absolutely no protection to the state. And we can look to 2020 and XOG or extraction oil and gas bankruptcy for that. The fact that they can get a $30 million bond in financial assurance is absolutely no protection. As we've heard stated by financial surety experts, that only means that they have $30 million in collateral somewhere. That doesn't mean that the state is afforded any protection. So these well numbers speak for themselves. Two of the operators, Noble and Occidental, are currently bonded at $45 million each. While $30 million seems like an awful lot of money, they're asking for a 30% reduction in bonding amounts and potentially $100 million each in single well financial assurance amounts for the low producing wells. Frankly, their proposal is a huge giveaway to the largest operators with no assurance that they are financially sound. What I find most troubling is that this option removes any incentive to plug wells. Without production thresholds or without any limits on the number of inactive or low producing wells, and without single well financial assurance for low production wells, why would they plug them? The big three operators and their attorneys claim authorship for the out of service well policy. And I appreciate the work that they did on that. In fact, it's something that myself and my clients support. But they have, as you saw in the earlier slide, a majority of the low producing and inactive wells in the state. When they were asked about this yesterday, their attorneys simply responded that our clients tell us that they plan to plug thousands of wells. Well, that is verbal assurance. This is a financial assurance rulemaking. They're offering absolutely no protection for the thousands of inactive wells and low producing wells that they own in the state. Their verbal assurance that they intend to plug in abandoned wells should offer little comfort to the commission. Here's some ways that we could change this, and these are not listed in any order, but I wanted to give you some options. The over bond is not only a bad policy, it's completely unnecessary. At least one commissioner has mentioned that the option 6 could be accomplished through a bespoke option. So long as they're not exempted from single well financial assurance for transfers, new wells, and low producing wells, and given a huge discount from what they would have had to pay under option 1, I think that approach could make sense. This is another approach. This is an idea from Western Slope COGA's proposal. And to be clear, Western Slope COGA is not advocating doing away with option 6, but this proposal from Western Slope COGA makes option 6 somewhat unnecessary by putting a limit on the amount that they could spend for the blanket bond itself, not single well financial assurance or any of the bolt-ons, of $30 million. And then finally, this is a complete rewrite of option 6. And first, it would need criteria, actual criteria to be eligible for option 6. And we're putting forward basically the criteria production thresholds from option 1. And we're also, there needs to be a showing that they have the highest financial capability as previously described. And again, that's some of the language that we received from EPA. And then we would require a minimum of $30 million bond so long as there's no discount. The reason an operator may want to pursue this option in this rewrite that we've prepared for you is that the blanket bond would cover inactive wells up to 15% of the operator's wells, as opposed to 10. Moving to out of service wells, we want to talk about prioritizing plugging wells in wildlife habitat, requiring reporting of wells that are on the delayed repair list, and also prioritize plugging of leaking wells. So we're supporting the language as proposed by the Allied Local Government Coalition. You're going to be able to talk to Elizabeth Pranos about that. But I want to make sure that we also talk about this idea of reducing impacts, not only in disproportionately impacted communities, but also in wildlife habitat. There's a requirement that the operator discloses if they have wells on the out of service well list within priority wildlife habitat, but not that they prioritize plugging of those. And I think that was just an oversight, frankly. And so we've added to that, and I think that would help. We're also want to make sure that we're prioritizing those wells that are found to have leaks. I think that makes sense. And we know that these have leaks. I've shown you this before, but this is something that my clients just found earlier late last year. And the importance of this, and the reason I wanted to bring it up, is that this is coming outside of the casing. This happened when they shut in a well, in this case, but this would happen even if it was temporarily abandoned, because this is gas that is escaping outside of the casing, as you can see. And again, reason that we want to prioritize these wells is because this does happen. And when it does happen and it's disclosed, let's make those a priority to get plugged. I want to move into the size of the problem. There are going to be several thousand orphan wells revealed by the application of these rules. And want to just go again and talk about, this is a current draft. And some of what I stated in the last time I spoke before you has been mischaracterized. I wasn't saying that every low producing well is going to be orphaned. I was saying that the wells that we have to worry about are in the lowest tier operators and their low producing or inactive wells. And in this case, we've got nearly, 3,267 of them that would be in option 4. This problem is longstanding and common in all oil and gas producing states. These orphan wells, again, are not caused by these regulations, but revealed by them. So the $200 per well fee is a start, but it's likely not enough. If it costs to plug and abandon a well is $92,000 per well, and Colorado annually spends $10 million per well fee and $110 million from the federal government, the 3,267 wells will take 15 years to plug and abandon. And that's not adding the 600 odd wells that we have currently in the orphan well program. So to plug and abandon the 3,267 wells in 10 years, where we have this help with the federal government, Colorado will need to spend $30 million a year. Talking through the administration quickly, we agree with the reasoning behind the amnesty provision, but as written, we're concerned that it may be abused. We'd also like to have some automatic adjustments for inflation. Right now, the language throughout the rules suggests that references 707A1A. The director's review may include whether the operator's financial assurance should be updated to reflect inflation. I think that I would suggest that this puts an unnecessary burden on staff and the director, and that we would propose automatic adjustments made to things like single well financial assurance, surface owner bonds, and blanket bonding amounts. Thank you.
Thank you, Mr. Sura. Can you go back to the options part of your presentation?
Sure.
And I'm going to do something a little bit atypical, but as chair and as a commissioner, I've got the right to do this. I would like to bring Ana Gutierrez to the panel, and I'd like the two of you to talk to us about the two approaches because you said that you were happy or comfortable with some of the components of West Slope COGA, and then there are differences here, and I think we're kind of all over the place. And so I'd like to try to establish a dialogue or a debate, or both of you sort of talk us through your different perspectives.
And to be fair, Anna and I have been trading phone calls for the last 4 days. But as you know, we're all very busy right now, and we haven't been able to touch base. So I would like to do that. I'm not sure that the fishbowl of a hearing is a great place to have this debate, but I'm happy to share the screen with her.
Yeah, why don't we just share the screen and have an initial discussion?
Great.
And you have a weekend ahead of you as well, and you can keep talking. But it seems like there are good ideas here, and sometimes it seems like they're meeting, and sometimes it seems like they're crossing. And so I just wanted to give an opportunity, since you just spoke, maybe I could call on Ms. Gutierrez to sort of respond, and let's see where we're at. Does that Is that okay? And again, this is not counting against your time. I'm just trying to solve issues.
I appreciate that, Chair Robbins. And if we don't solve everything in this next 5 minutes with the speed round with Ana Gutierrez, I'm available all weekend to continue working on this with her, with you, with anyone that wants to talk about these issues.
Well, and I appreciate it. I think that's the one spirit that everyone is bringing to the table is sort of issue solving. So, Ms. Gutierrez, thank you for allowing me to call upon you unexpectedly. Do you want to talk to us?
I appreciate the opportunity. Thank you very much. And if small children run through the door, apologize in advance. And agreed. So Matt and I have had 3 conversations. I just want to clarify this, and Matt, I say this respectfully, but we have had 3 conversations leading up to hearing, but this particular issue wasn't raised as in respect to response to West Slope COGA's presentation. So it does come as just a touch of something that we could have discussed a bit back. Matt did call me yesterday, but that was during hearing. That aside, I'm here to have the conversation and work through this. I think just taking a step back, I would say that I fundamentally disagree with Mr. Sura's approach in that, as I understood it, is he stated that the goal is to get individual wells more into those categories, right? Into the middle or the lower categories. What we are looking at, and what I hear the commission looking at, is the entire portfolio of an individual operator. And our data that we have produced demonstrate that these are extremely strong and competitive operators in the state. So we're not crediting that operator for the strength of what they have and what they offer to the state. The ratios throughout between oil and gas are different precisely because we didn't look at ratios. That was entirely the step back that we took. We looked at gas as its own product, as its own play, because these are apples and oranges. This is not an arrangement that is how do we look in proportion to the next. We're not looking at one individual barrel of oil or 1 MCF of gas. I think and all of that data show that our folks in our wells are economic out for an extremely long time, much longer than you would see in an oil well producer. As we have all talked about, these MCF thresholds reflect the production from that operator, which is the next step proxy for revenue. To my knowledge, the only other agency that I think has done that is BLM, right? Looking at the operator on the whole on their per well average daily production. And even BLM says 60 MCFE, that's a highly producing operator. That's an operator that I'm going to start think about crediting them for financial assurance. So I entirely understand why Mr. Sura is asking these questions, right? We have a energy conversion that sits out there. It's used when some liquid comes out of the ground and we're trying to figure out what does that mean in MCF. I get that, but those are entirely different regulations and applied in entirely different ways, right? That's like pulling a Texas or Alaska definition out of context and saying, let's use it here. That's just not recommended policy. And at the core of this, I think I want to get this right, but I think it's Miss Mackenzie Smith from Evergreen. I think she painted a good picture for us, right? She has the background, the engineering background and the education to do it. But these products between oil, natural gas, CBM are very different. And the business models are drastically different. So creating just here's the number for oil, let's make it our benchmark for everything else, I think is the wrong approach.
And I agree, right? I absolutely agree. And again, this is not by wells, this is by operators and the wells that those operators have. So that's how I've done the tiering. And when I say that it took me hours, I was slightly exaggerating. It's taken me nearly 2 days. It was horrible work, as you can imagine.
I agree.
This is where it ended up. And this is not just Piceance Basin, what I'm showing you here. This is all the wells, all the natural gas operators in the state. And that includes those who are having to pump water and coal bed methane, down where Commissioner Robbins lives. this is out on the Eastern Plains. You know, this is all sorts of different operators with different costs. And you know, while I understand that, you know, Western Slope COGA wants to have its operators be under the blanket bonding, and we can still accomplish that. I didn't go with a 5.8 to 1 barrel because I did that and there was nobody in option one. And I know, and I agree that there are operators that are natural gas producers that, you know, are good operators, they're strong operators, they deserve to be in tier one. But having everybody in tier one, I don't think makes sense either. So again, there was a slight adjustment, and it still allows for most of your members and certainly most of the natural gas operators to be covered under financial assurance blanket bonding. But it just doesn't, it's not so skewed to option one. That's all.
And I hear you there. And I appreciate you taking a closer look at the data. But again, you know, what the data we have, and you are looking at the state, but in looking at what we have on the West Slope, we are like what you selected and revised feels a little bit arbitrary as well, right? If we're just picking a ratio of 3 to 1, and again, you're doing it as a ratio off of oil, where we're saying stop with the ratios. This is its own beast. This is its own product.
I mean, I just merely show it as an example that you have a tier one operator that is making $360 per well a day across their portfolio in tier one, and another operator also in tier one treated the same by the state that's making $5,400 a day per well across their portfolio. You know, all I'm using it as an example. I'm not saying that they have the same cost, because I know that they don't. I know that oil operators have pumpers that have to go out there every day. There's more costs associated with oil, and I absolutely understand that and have accounted for it. But and again, I think that this is skewed too much to natural gas producers. I think that it's a little bit of a giveaway to them. Having said that, you know, I appreciate the good work that you did in recognizing that low producing wells across all the tiers, you know, are a threat to the state, and looking at single well financial assurance for low producing wells.
And I would just say that I don't know that I would characterize our proposal there as low producing being a threat to the state, but being responsive to sort of commissioner and stakeholder concerns. And again, balancing out what options 1 and 2 offer to the state with the bonding up on low producing wells, we think just strengthens the overall package that remains strong as it is. So we do continue to stand by our proposals and our thresholds as we've presented them and as they were revised by Commissioner Messner some time ago.
And I am sorry that I didn't, when we talked months ago, talk to you about, you know, these thresholds. I didn't know that your proposal was going to get so much traction with the commission, frankly. We would have had a lot of conversations, but it has, and you know, it is the proposal on the table now. I think we all need to look at it with a discerning eye and say, does this make sense? Is really this what we see when we see all of our natural gas operators, that really 61%, you know, of those wells owned by those operators are going to be tier one, you know, and maybe that's true. I think that what we've proposed is a little bit more sense, is a little bit more balance, and incentivizes those tier 2 operators to plug and abandon well so they can get an option 1.
Okay, hold on. So I appreciate you both allowing us to be creative in this approach toward rulemaking. Before you go on, let me see if any of the commissioners have questions based upon this discussion. Nothing? Commissioner McGowan?
Thank you, Mr. Chair. I totally appreciate both conversations, and I think you know, one is looking at operators and single product, and the other is looking at wells and comparing to another product, if I'm understanding correctly. And I think, Mr. Sura, how are we determining when a well is economically viable? And so I feel like there's a little bit of putting some sort of measure on if a well is making $360 a day, there now it is financially viable and belongs in tier 1 versus a different amount. I'm not sure what the magic number is, and that's why I kept asking folks, how are you picking your number? How do we justify what goes in tier 1, what goes in tier 2, what goes in tier 3?
That's absolutely the question we should be asking. I agree.
And I'm wondering what you think about Ms. Gutierrez's comment that the BLM looks at 60 MCF as a well that's very healthy.
Sorry,
maybe I misunderstood.
No, I just want to, because it's a bigger picture and a larger look, and it makes a difference. But what BLM says is, because what we're looking at is per well average daily production across an operator's portfolio, and that's what BLM did. And when that tagline is 60 MCFE, they say, hey, that's a high producing operator. Let's start crediting them. We didn't make 60 the baseline for option 1 because we wanted to push the limits a little harder and really make that a more stringent category to get into. So we came down from that, and that's why you see 1 and 2 where they sit.
And I guess I would land with the BLM as well, crediting those operators with blanket bonding in level 2. They're clearly level 2 operators. They deserve to have blanket bonds, so long as they comply with some of the other requirements that we put forward. And we would like to see more kind of a clear financial health picture for any company that is going to be using blanket bonds. It really is a subsidy in some sort, and we're trusting them more than we would option 3 or 4 operator that is looking at single well financial assurance across their wells.
And I would just respectfully say that the blanket bonds in option 2 are extremely aggressive, right? Those numbers add up very, very quickly for an operator. So we are certainly shifting between option 1 and option 2. You saw that example yesterday between operators that had similar asset sets, and option 1 operators at 9 million and option 2 operators at 25 million for similarly situated positions. So I would argue that where we sit now with sort of not only the bucket, but the consequences of being in the bucket are taken care of. And then in addition to that, our proposal yesterday in being responsive to some of the concerns raised by conservation community is the additional bonding up of 90 and 95% of low producing wells. So on the whole, option 1 and option 2 operators, as we've assigned them, are going to be subject to an extremely rigid financial assurance.
So what I've put forward is an option, and I think that what we haven't seen, and I think that what I'm sure Julie is working on, Director Murphy is working on right now, is coming up with where the staff believes that the current draft will allocate different operators and their wells into these different thresholds and into these different levels. I thought that would be information that would be helpful to the commission to know what the current draft would do, and then to offer an alternative. And so that's what I've done. I'm not in a position to be able to say that $360 or $40, that an operator can't make money on that. I think that some of your testimony, indicated that $40 was kind of a little bit low, and that was a fair place to start with option 4. But I'm sure that there are operators that can make money with less than that. And I'm sure that there are operators, particularly in the San Juan Basin, that have to pump water all the time, and the electricity costs and the additional maintenance that requires, and the hauling of water, that they're not making money at $40 a well. So again, this is for the state. I have lived out in the Piceance Basin for more than a decade and have worked on those issues out there and understand, some of the economics are different, particularly for dry gas. Some of the condensate that is produced is also really helpful and helps bump up those economics on the Piceance Basin. So I'd love to continue this conversation.
Okay, hold on just a sec. I've got
be around.
Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you both, Mr. Sura and Ms. Gutierrez, for coming back and having this conversation. I guess I have a question. So, Mr. Sura, you, as part of this kind of proposal, you're also recommending additional certification of financial capability in order to get into certain tiers.
Correct.
If that were the case with the existing thresholds, and if they fell in the same way where we have most operators in options 1 or 2, I'm wondering what your thoughts are. And I mean, to me, that sort of indicates then that we've got the most wells among the strongest operators, and the tiers kind of reflect that. And this is for either of you to comment on it, if that logic makes sense. But I think that especially if we also are adding this financial capability component, then if you have more operators and more wells, I guess, even in these upper tiers, if they're qualifying based on these different things, then you're kind of ensuring that the most wells are better assured by the strongest operators. Does that make sense to both of you, either of you?
I was going to say, let's let both of them respond. And I don't care who goes first. Raise your hand, whoever's quicker.
I'll let Anna go.
There is an advantage to going second, so that's smart.
I couldn't win on that.
It's okay, I get it. I will answer this and then I'll politely excuse myself from this conversation because this is Mr. Sura's presentation. So my thought here is, as I have been understanding, Commissioner Nanjapa, your question about different thresholds for folks to enter into 1 and 2, you were seeing them, like perhaps the EPA thresholds, as an additional different criteria against which they could be measured to come in, but not a plus. Like you have to do our low producing well averages and you have to show this. That was not what I understood, Commissioner Nanjapa, you earlier kind of walking through. And I'll pause there because you came off mute.
Yeah, I mean, I have been considering, as I've been calling it, an on-ramp, that might be something like this as an or to the production. That's correct. But I am now asking in with respect to this particular proposal, if it is an and, I think it further, maybe it changes how the distribution ends up falling out. But I'm also curious, if it doesn't, and if the production values are a proxy for financial capability, then this shouldn't be a concern if it's an and for those high producing operators, I don't believe. But yeah, I just wanted comments to correct me if I'm wrong. And
No, that's very helpful. So to answer your question directly, I would be okay with this being an or, right? If you wanted an opportunity for somebody to also get into option 1, I would not support, West Slope COGA would not support this being an and. I think part of it is everybody was aiming for simplicity and cleanliness in the rule. And what we have put forth here is, production as a proxy for revenue, health, and wealth of an operator, whatever it is that you want to call it. And this exceptionally complicates that. Right? These are the type of analyses that are done when sureties are going to issue the bond. So this is going to happen as a part of the market scenario. And I don't think this needs to be the conversation for the threshold for someone to get into a blanket bonding scenario in options 1 and 2.
Mr.
And-
Sir, do you want to
Sorry.
respond?
Oh, yeah, go ahead.
Sure,
I
sure.
see you, Commissioner McGowan. Give me just a sec.
You know, some of what Anna said, I agree with. But this is frankly more important than production thresholds. And I think PetroShare is a good example. Extraction in 2020, when they went bankrupt, you know, had very high production thresholds. I think that this kind of information is going to actually reveal more and probably be more important to allocating risk. You know, and I think put the financial assurance where the risk is. You know, Matt Lepore keeps saying, and that can be revealed best by looking at the financial health of those companies. It is not, I don't think that the fact that they're producing 1 year is a proxy for whether or not that company is financially healthy. We don't know their debt to income ratio. We don't know anything about that company other than the fact that they have some wells that are producing.
Commissioner
So
McGowan?
to your question, Commissioner Nanjapa, yes, I think that this could be an on-ramp. Absolutely. And I think it's an and, you know, I would want to see this information and have those large operators or those very productive operators be able to demonstrate through these criteria that they are a healthy operator, not just productive.
Okay, may I
Go ahead.
just kind of follow up? Thank you, Mr. Chair. So, okay, thank you. I appreciate that. So I understand, Mr. Sir, where your position is that this would be an and that Ms. Gutierrez, you're saying it would be an or. I'm curious though, if production thresholds are a proxy, why is this a concern? Would it remove more operators from the option?
Ms.
believe-
Gutierrez?
Yeah, I believe that's for me. So I think that's part of the challenge for me here is we haven't run all of this evaluation, right? We are at, you know, the 11th hour. And so I don't have the answer for you on who goes in and who comes out based on shifting to have this as an and. But to me, it feels and seems inconsistent with a lot of our approach here and goal here, which is to simplify. And I do think production is a good proxy for an operator's health and wealth. And I also just want to say that what the whole program we're building out is not just looking at the per well average daily production, assigning a price tag and walking away. We have layer upon layer of protection built into this program, one of which is annual review, annual conversation. So those potential scenarios that conservation community identifies as concerns that we've come across in the past, those are conversations that we will be having. Those aren't things that we're going to wait 20 years and then say, oops, wish I would have had that conversation, right? We'll be in the room. So I do think on the whole, we can't look at this in isolation. On the whole, the program addresses the needs of the state and puts an incredible amount of pressure on operators with respect to financial assurance. And with that, I'm going to bow out unless there's another question for me.
I had, if I may, just a last, and I think this
You
Commissioner
don't get
McGowan
off
does
that
too.
easy. Hold on.
If I could just a last, I know you want to get out of here. I'm
That was
sorry.
okay. I'm imposing upon Mr. Sura, so.
No, it's fine.
So I'm gonna make you guys say yes or no on this one. So I'm just curious, you know, so if regardless of if it's an and or an or with this financial capability, if you know, if you're thinking of it in the one way that the production level is a proxy for financial health, or if you actually have literal, you know, proving up of financial health, wouldn't it be advantageous to have more wells in that option? Yes or no?
Can I restate the question to make sure I know what I'm answering? So is the question, would it be more advantageous to have more wells in options 1 and options 2?
Correct. And this is again with this sort of the premise that either the production value or perhaps some proving up of financial health you know, production levels are a proxy for financial health where you actually are proving it
Yeah.
up. Would that not then demonstrate that options 1 and 2, having the more wells in that would be beneficial?
My response is yes, because based on our numbers, our MCFs that we've put up, we do have, as I agree with Matt, more wells in option 2. And I said this in our presentation, that's a good stat. That's a great story for the state of Colorado. We have our strongest operators carrying and managing and operating the majority of our wells. I think that's a good thing. I think anything we do to inhibit entry into options 1 and 2 off of sort of the clean program we've already set, I think is problematic.
And I would agree. And just to be clear, I did say but I also said that if they're able to meet these requirements that we've put forward to your satisfaction, that could be an on-ramp if they were just below a threshold, as an example. I mean, this should be something that is considered probably and is far more important in my belief than production thresholds. As to whether or not it's a good thing for Colorado, you know, so long as there's no additional risk, right? I want to see a healthy oil and gas industry. And if they're all in tier 1, that would be great. So long as they all are justified in being there and don't represent a risk to the state for orphaning wells.
Thanks so much for humoring me.
Thank you.
Commissioner McGowan.
Thank you, Mr. Chair, and thank you for hanging in there. So I do feel like as part of my request to folks testifying and coming back to us, I've been very clear that I think that production is one surrogate of operator health, but we also need to look at the financial health of the operator. I think I've been like super duper clear that I would like to see how we fit both together. And so back to Commissioner Nanjapa's, I think, line of inquiry, if the options were to stay the way they were, and we added an and, which is some sort of surrogate for financial health, but it's not this laundry list that we have in front of us, is there one surrogate that you think is a good measure of financial health that we could put into each of these options that an operator can show? Or does it have to be this whole laundry list?
So EPA looks at a number of different factors when they're evaluating risk. I think that surety companies, as I understand it, you know, can look at a number of factors. You know, we've heard testimony and you all have heard from COGCC that operators that are not in compliance with rules generally are a higher risk. You know, so I think there are a lot of risk indicators, and I would encourage you to look at as many as you can. And this is a good list to start. You know, you might think that it seems like a laundry list, but it's 5 issues.
Ms. Gutierrez?
Yeah, and to answer your question, I think Mr. Sure answered it for me in that the surety looks at that, right? If they can go to market and get this bond we're asking for them from in options 1 and 2, that is your check and balance. If they come back and say, I can't get my bond at 20 million, that's an entirely different conversation, but that is for the surety market to have evaluated. I continue to believe we are looking at the health and wealth of the operator. We're doing it in a clean way, and there are built-in measures to make sure we continue to ensure the state is secured.
And the surety companies that we've heard from say that they're looking at for collateral. They want to minimize their risk to 0, and that is through collateral oftentimes. And yes, sometimes there are, you know, the EPA as an example looks at some of these issues. But surety companies that we've heard from in this rulemaking have stated that they just want to have 0 risk, and that means collateral or something, or a cash bond.
Commissioner McGowan?
Mr. Sura answered my question. Thank you.
Okay, Ms. Gutierrez, thanks again for coming back to us. John, Commissioner Messmer has a question before you go.
I just have a question in general, although I'm loving this Lincoln Douglas debate because this is the debate I have in my head, you know, every night as I look at these financial insurance rules. So thank you for playing that out on the big screen for me.
Lincoln, I call Lincoln.
I don't know if that's fair.
Let's go first last time.
But anyway, I just have general kind of comment question. And so I'm not gonna like ask both parties. So if there are others that would like to ask both parties, I'm happy to step back and wait.
Okay, so are you taking this to other questions from Mr. Sura? Is that what I'm hearing? Okay, anybody else with questions on this topic for our Lincoln Douglas debaters? Great, thank you again, Ms. Gutierrez, for allowing me to volunteer you to show up.
Thank you. Yeah,
And thank you.
Thank you, Matt.
Thank you, Mr. Sura, for allowing us to dive into that. I think that was helpful. So we will now ask you questions about all the other components of your presentation.
Great. Do you want me to have my screen up or do you want me to put that down?
I think you can keep it up. I've learned how to sort of minimize it until necessary. So Commissioner Messner, you have the floor.
Thank you, Mr. Chair, and thank you, Mr. Sura, for the presentation and for always being thorough in your thoughts. I mean, I think we've had kind of the conversation about production thresholds, but I'm going to take just a step back there because one of the, in my mind, one of the ways that the option system works is really looking at what operators, as far as their whole portfolio, are closer to the start of life versus the end of life, and ensuring as it goes through the different options that we start to develop additional financial assurance as they have lower and lower production thresholds. And so as you're looking at it and you're proposing these different things, I mean, I'm hearing a lot from some of the other commissioners about, you know, on-ramps to option one and so on and so forth. But I think that starts to screw up the model a little bit. So I want to get your thoughts on it, because the model is really, you know, if you've got a high production threshold, then generally speaking, the majority of your wells or some significant portion of your wells are closer to the beginning of their life to the end of their life. If you've got a production overall portfolio production threshold on the lower end of things, then generally speaking, you're closer to the end of your life than you are to the beginning of your life as far as these wells go. And so therefore, as you get to the end of your life, you're needing to put more and more money away, even to the point of single well financial assurance, in order to ensure, in order that the state has the financial assurance in place to ensure that that end of life operations occur. And so I guess and I don't necessarily have a problem with having some criteria within the options that just generally looks at an operator's financial health. So I'm not necessarily opposing that. I don't know as it has to be to the level of detail that you're providing, although I'll certainly read through it and consider it. But I guess my question to you is, I mean, is that how you see the option system working? And does that concept change this thought of whether or not operators should be able to on-ramp onto option one?
Yeah, thanks for the question. I think that production is important, clearly. And the number of inactive wells or low producing wells is obviously very important, and probably the most important thing. Because if an operator goes out of business and ends up in Chapter 7 bankruptcy, it's those low producing wells that are going to end up with a state. If the well is making money, somebody else is going to see that as an opportunity and will purchase those wells, and that is no longer a threat to be orphaned, right? So, you know, my sense is the low producing wells is absolutely the most risk, the highest risk to the state of Colorado. And after that, you know, it gets fuzzy. And what we've seen is that, you know, operators that, you know, on paper are producing a lot of oil and gas, you know, may have very, very high debt, as Extraction did before they went into bankruptcy, as did PetroShare. And we wouldn't know just from that one number that, you know, it was an operator we could trust. I think that getting into their financials is absolutely critical if we're going to allow for the blanket bonding option. We don't know if, you know, that they are a hollow company that you know, may be producing, but they have other assets in other states that aren't producing anything, or that they've got, you know, liabilities that we don't know about. You know, particularly when you're talking about, you know, some of these larger operators that are active in other states. We need to know their financial health before we want to trust them with a blanket bond, because that is, in some ways, it is subsidizing them being able to, you know, function in this state. We are assuming risk for that company. And, you know, we need to be sure that that assumption of risk is warranted. So some on-ramp may be necessary. I wouldn't want somebody that was making very, very little, and just because they had a bunch of money in the bank, you know, to be able to on-ramp. That there are a lot of calculations, and certainly, you know, what it would take to plug and abandon all their wells. You know, if they are all low producing, I don't think that they get into tier 1, regardless of how much money they have in the bank.
Okay, no, I appreciate that. I think that's the only question I have right now. Thank you for your presentation.
Further questions from commissioners? All right, I'm not seeing any at this point. Make sure you file your PowerPoint with us so that we've got it over the weekend. Spend as much time as you want on your own thinking through these things as well, or with others. I've got a real big conference room in the Chancery if everybody wants to gather there this weekend and figure this out. I won't be there, but would love to see a solution developed up for a presentation on Tuesday. Only half kidding. Now, I just want to say we all appreciate everybody's willingness to roll up their sleeves and really talk through these issues, especially knowing that everybody's looking at these issues with different prisms. But I appreciate the goodness of it all. I mean, everybody's just being really good about understanding that we're looking at it from different perspectives. So with that commentary, we will allow Mr. Sura to unpanel. And
I'm actually going to stick around.
Are you sticking around?
Okay,
you're going to be part of.
Sorry about that.
No problem. Surface Owner Coalition, you're on that one too, right?
Yeah.
Okay, well, we're not done with Sura yet, folks. So, which is fine. You add a lot of value. Okay, Surface Owner Coalition. Is this Mr. Prescott as well?
No, it's just going to be me today.
Oh, just you. Okay. Well then, I've got you down for 5 minutes. Take it away.
Hold on. I just want to make sure that I can see my screen. Thank you.
Are you screen sharing?
I am, and you don't see it.
You're not, I guess.
Okay, thank you.
That was my approach, is you're not screen sharing. If you are planning on it, we need to do something different.
I appreciate that. Now you can see it?
Yep.
All right, thank you. Matt Sura for the Surface Owner Coalition. Surface owner is any person owning all or part of the surface of land upon which oil and gas operations are conducted. I guess I want to just pause for a minute, because it's really important that you recognize that we only have an oil and gas industry because of surface owners either allowing oil and gas development on their land or being forced to allow oil and gas on their property. They are absolutely integral to this industry, and I think in some respects get a little bit of a short shrift in the rules generally. And I want to just talk about a number of issues, including surface owner bond amounts, looking at support for a definition of low producing wells, slight clarification to language in 503G, talking about adequate notice, and then talk about giving opportunities to the surface owners to plug in abandoned orphan sites on their own property. First, to start with surface owner bonds, surface owners that don't have the benefit of surface use agreement are not benefiting in any way from or any form from the development of their property. They shouldn't have to wait in line through the Oil and Gas Conservation Commission Orphan Well Fund for their well to be addressed. And that's why we would really like to see at least single well financial assurance for all wells that don't have a surface use agreement. Having said that, I haven't heard that idea get a lot of traction. So I want to address the proposal that's before us, which is a $4,000 per well for non-irrigated land or $10,000 for irrigated land. I appreciate the fact that it was doubled. I still think that it's awfully low. If there's a spill, if there's a problem, certainly if there's an orphanage, it's going to take more than that. I appreciate the discussion that was had about whether or not this was a retrospective or prospective rule. All of these are retrospective rules, and this should be as well. I agree with some of the comments, particularly by Commissioner Gonzalez, that they should know if they've got a surface use agreement with a landowner or not, with a surface owner. And if they don't, that's I would say a really troubling remark. If they wanted to do a blanket bond, I would assume that it would have to be $10,000 per well that it doesn't have a surface use agreement. And that would be the start. And certainly could allow that. That would give every surface owner, the assurance that there's at least $10,000 to deal with their concerns. Moving into definitions, support the current definition of low producing well. And want to also talk about Rule 503G12. And this language is not as clear as it should be. And for that, I'm going to take the blame. A low producing well is as you saw, is defined within a year, within 12 months. And we wanted to increase that 1 year threshold to 3 years. And the way that this reads is not as clear as it should be. Is the daily production averaged over 36 months? This language was not the intent of the parties. This language that I proposed here, I've checked with both local governments and some other stakeholders, and they would prefer this language as well. So that would be the one change that I would offer, and appreciate the support of that. Providing adequate notice to surface owners is important. I'm going to go through those following. 504B11 is about the director initiating a well closure and more or less an orphan bond, taking that bond and orphaning that well. I think that that's something that obviously the surface owner has, some stake in. And I think it's a mistake that they weren't notified of that hearing. I think it's also a mistake if surface owners are not told about, these hearing procedures to claim those bonds. And they may be in a position to plug and abandon the well themselves, or certainly to reclaim that well. They should have the opportunity to do so. And so that was the one change that I'd make there. Also in financial assurance hearings, there is, I agree that for financial assurance hearings for a financial assurance plan, it doesn't make sense to have surface owners invited. There's just far too many of them for some of these operators. But if there's a financial assurance hearing for a specific well in a specific location, say on a transfer, or there's a single well financial assurance that's being challenged under 218D5D, I think it's really important that the surface owner gets notified. That is his or her property that is being discussed. And they would be in a position to know if those that proposed single well financial assurance, for example, was adequate. And finally, again, I want to reflect on some of the conversation that Commissioner Gonzalez had with some of the local government folks. There's a lot of work to be done on plugging and abandoning orphaned wells. And I think giving the opportunity to surface owners to be part of that solution is really important. Surface owners want to have an opportunity to plug and abandon orphan wells. And even if there is only a partial payment from the state, getting surface owners involved in that work is going to increase the speed and potentially lower the cost of orphaning wells within the state of Colorado. Thanks.
Let me ask you a question about that last one. Really? I mean, I don't represent surface owners, but there are a subset of surface owners that would like to hire a plugging company and be in charge of plugging and abandoning a well on their own land?
Oh my goodness, yes.
Okay, well, I'm glad I asked the question.
Oh, absolutely. In fact, I can find within the Surface Owner Coalition and among clients that Steve and I represent, you know, a dozen that could come and talk to you at any time. There is a lot of development occurring, Commissioner Robbins, as you know, on the Front Range and throughout Colorado. And a lot of that is residential and commercial development that is happening adjacent to and on top of sometimes existing oil and gas wells. Some of those oil and gas wells that are orphaned are inhibiting development and other economic use of that property. Getting those wells plugged and abandoned is something that is very expensive, and yet there are surface owners that would pay that happily. And what I have started with, just to be clear, is that there is an orphan well fund. We've talked about the possibility of local governments partnering with the Colorado Gas Conservation Commission and taking on some of those orphan wells within their own jurisdiction. I'm saying let's also talk about, you know, maybe a grant program for surface owners that aren't going to maybe get 100% of it paid, but they would get a portion of it paid because they're going to be addressing those issues more quickly and, you know, putting some of their own resources. Maybe that makes sense financially for the Colorado Gas Conservation Commission to consider.
Okay. One other thought, talk to me a little bit about the 10K blanket bond per well.
Yeah, so I don't think that a blanket bond is necessarily a good idea nor needed. And I appreciated Commissioner Gonzalez's leadership on this issue. I think that it should, they know very well, every time that they do anything on a surface owner's property, they know and have to consult the surface use agreement if it exists. If it doesn't exist, you know, that's another issue. They're going to know that. And so I would prefer to see $10,000 or even $4,000 per well. If there is an operator who claims, as we've heard from some of the large operators, you know, just tell us, we'll put bonding aside. We'd rather have just one bond cover everything. We don't have to worry about counting. You know, it should be equivalent to $10,000 per well. Just to make sure that those surface owners are protected.
Okay. Other questions for the panel? Commissioner Gonzalez?
Thanks, Chair. Thank you, Mr. Sura, for your presentation on this and the last one. Got a couple questions. I'm just going to fumble through a little bit and see if we can have a little conversation around it. With regard to the surface owner bonds and specifically this slide that we're looking at, how should we be considering these amounts and a potential blanket bond amount in light and in conjunction with the other financial assurance protections that we are providing along with this rulemaking that we're doing?
Well, thank you for the question. And, you know, the way that it's stated is it's protecting surface owners from land damage. And and so, yes, I would like, and we had originally put forward a proposal to have it single well financial assurance to also protect against orphanage. What it is protection against land damage. and ensuring that there is going to be some money and some ability for that service owner to be made whole. If, you know, in one case, it might be that somebody ran over a fence, you know, broke a fence, and that fence can be repaired. Could be something that is much more drastic. It could be something where, you know, that there is a long-term spill that is found, that there is other things that are damaging their crops. You know, if they are reclaiming a pipeline, as an example, and they don't properly put the topsoil back on top, as an example, that's an issue that would cost a lot of money. And we have heard testimony from your own staff saying that topsoil is extremely expensive. And so ensuring that they're going to be able to be made whole, whether it's for crops or for a residential use or whatever use it's being put to, that use is going to be able to continue despite the oil and gas damage.
Yeah, I think I tend to look at it the same way that you do. I think that maybe the topsoil analogy maybe gets covered by some other rules under the reclamation side. I think specific to actual damage to crops and damage to things that are outside of, you know, of the actual plugging and reclamation of the pad, I think are important to consider and to offer those protections. So just, you know, it's a question that's come up, at least to me, independently. I wanted to make sure that we had that addressed here on the record. I appreciate you taking a crack at that. So one of the things that I did make a comment on, and I stand by that comment, that I think it is, you know, bad practice if someone doesn't know where they have their service owner bonds, you know, historically. The point was made to me, and I can respect this because, you know, I've seen it in actuality, is, you know, a lot of these companies as they stand now are, you know, the conglomerates of other smaller companies or even of other larger companies and other assets that have been, you know, aggregated to their current portfolio, and that, you know, so oftentimes they're subject to the record keeping of the company they bought or the assets they bought. Sometimes in mergers or system transfers or what have you, you know, data gets lost, and I hate bad data. You know, and I don't like bad record keeping either. That's something that's a personal pet peeve of mine, and I think there's better ways of doing it. But it's the reality of the situation for a lot of these companies. And so one of the proposals, I don't even know if it was a proposal that we got, one of the ideas that popped up was the idea of a blanket bond being a kind of backstop protection for some of these companies that may not know exactly where they are, right? It'd be great if they did, and I think they should. But if they don't, the idea of having a blanket bond that's a kind of a fixed amount to cover that was thrown out there. And so when I think about this blanket bond on a per well basis, it doesn't necessarily help address that problem or provide that coverage. Do you have any thoughts on that, on maybe if a flat rate might be a better way to go, and if there's a flat rate you think might be a sufficient amount to put in our rules?
Well, so some of the damage that could occur, you know, and it's hard to game this out, but land values are very high right now, and they're only going to get higher. And so I think that it would need to be commensurate with the land value in the area. And, you know, it would have to be hundreds of thousands of dollars.
Okay. I think we've heard numbers around that amount, you know, around, I think Commissioner Nanjapa threw out roughly, maybe an idea, so I won't hold her to it, about $200,000. And then we've heard similar numbers from the Noble groups, maybe without an exact figure being proffered. But that's helpful to think about. I just want to make sure that we have the, you know, the protections in place if we aren't able to accomplish a true identification for certain operators. So that's kind of one of the things that I'm thinking about, and we'll be thinking about over this weekend as we think about going into next week. So I appreciate your response there. Let's see, I had another question. Okay, so with the 504B11, the 704, I think it was 704 rule, not 704, I'm sorry, maybe 707 that you had identified there, and the 504B10. Will you skip to those slides just so I make sure I'm speaking off the right thing? So in regards to these three, and maybe one slide back gave me the outline. So if I'm looking at this, are you only requesting notice? Are you not requesting standing or participation in these processes and these hearings?
Yeah, I'm only asking for notice. I think participation or standing to participate is almost a foregone conclusion because the interests of the surface owner are so immediately being impacted by these decisions that I don't think that that standing threshold will be a problem at all for a surface owner. But if that surface owner doesn't know about the hearing, they can't participate and protect their rights.
Okay. And then my last question, or I hope it's my last question, is the to allow surface owners the ability to P&A orphan wells on their land, similar to what we talked about with local governments. You know, does this have the same idea? They would be able to access the orphan well fund in order to do that? Or are you asking for just a surface owner who says, hey, look, I don't want to wait on any of this. I've got the check. I can go do it. I've got the contacts. I'll bring a workover rig in. We can get this done. Is that more of what you're thinking?
I think they could probably already do that now.
Okay.
You know, they would have to work through somebody who was an operator, you know, but these companies that are doing the plugging and abandonment are operators. You know, don't have wells, but they are considered operators and have the ability to access those orphan wells. And I would hope that there's maybe approved list of plugging and abandonment companies that is, you know, held by the Oil and Gas Conservation Commission. You know, so long as they're using them, I think that probably, you know, may be able to happen, although I don't hear about it very often. But I do know that that it exists. And I think that allowing for, you know, some sort of grant program potentially where surface owners might have some access to some help to get their land, you know, reclaim their land, essentially, like literally reclaim their land. It actually could work to really benefit everybody. The Oil and Gas Conservation Commission would be able to double the amount of money that's going out there to plug and abandon and reclaim land. And the surface owner would have a little bit of help to offset those costs, you know, that were due to, you know, no fault of their own. There was an orphan well on their property.
Okay. Yeah, that's something I'm gonna give some thought to over this weekend, and I'll just kind of put a placeholder there for, you know, for any staff that's listening. And one question I have is, are there any, you know, from staff side, and this isn't necessarily for you, Mr. Sura, but just, you know, are there any concerns in terms of the coordination between an idea like this or an idea like letting the relevant local governments have access to the ability to plug orphan sites? You know, is there any concern it may interfere with staff's orchestration of the orphan well program? So just something that I'll be wrestling with and looking for the answer for that over the weekend. But throwing that out there, thank you for the conversation.
I appreciate that. And just quickly, I agree. I think there needs to be absolute coordination, hand in glove with the staff. They're the ones that are the experts. I wouldn't want to put a surface owner or a local government for that matter before the commission staff in directing those efforts.
Further questions? All right, Mr. Sura, thank you very much.
Thank you. Appreciate it.
All right, continuing down our list because it is still quite lengthy. We now have the Affiliated Local Government Coalition.
Good afternoon, commissioners. Elizabeth Pranios here on behalf of the City and County of Broomfield and the City of Lafayette, part of the Affiliated Local Government Coalition. I have joining me today Ms. Burke, who will help with the presentation. If you can give me 1 minute here to share our slides, that would be terrific. Let's see, here we go. Hopefully you are seeing those.
We are seeing them. They are not in presentation mode, if that makes a difference.
Let me try to put them in presentation mode. Would the slideshow mode work? Not sure why I'm not seeing the presentation mode option.
Slideshow is presentation mode.
Oh, perfect. Thank you. Okay. Terrific. Okay. That working?
Actually, we still see all the slides. I think if you go up to maybe swap display or use slideshow, maybe. There you go.
Okay. Thank you. Okay, terrific. Now I just have to figure out how to move them forward. I think I got that. Okay, great. So first, I just want to say We greatly appreciate all of the commissioners' time and effort on this important rulemaking, as well as Director Murphy and her staff's time. We are largely supportive of the current draft and just have a few select issues that we'd like to chat with you about today. Those include prioritizing the plugging of wells with unmitigated leaks, as well as spills and releases, bond amounts, relinquishment, and a few select other items. So hopefully, does that work? Yeah, okay. We have 3 revisions to Rule 434D that are intended to ensure that operators prioritize the plugging of wells on an operator's plugging list that have unmitigated leaks, spills, or releases. First, we suggest the addition of a new information requirement on Form 6A, detailing whether any wells on an operator's plugging list have unmitigated leaks, spills, or releases that are detected either by staff's proposed AVO requirement or by AQCC LDAR requirements. Second, we suggest adding a new requirement to 434D4 that requires that operators prioritize the plugging of these potentially problematic wells. And then third, we suggest a requirement that operators include in their Form 6B a list of any wells that have been plugged or have not been plugged and still remain on the operator's plugging list that have any leaks, spills, or releases that have not yet been mitigated. And the reason that we are suggesting these revisions to 434, a couple different reasons. So one is that there are a number of peer-reviewed studies that have identified leaks as well as spills and releases at shut-in and low-producing facilities. Our inspectors as well as inspectors of other local governments have also identified leaks, spills, and releases at inactive well sites or low-producing well sites in the state of Colorado. As you know, the current rules allow for wells on an operator's plugging list to remain on that list for several years, in some instances as long as 8 years. While we would certainly expect that most leaks, spills, or releases would be fully remediated or fixed well within these timeframes, we read the current rules as well as other of the commission's rules, including Rule 912 and the Air Quality Control Commission rules, to allow for the possibility that some leaks, spills, or releases could remain unresolved for an indefinite period of time. This possibility requires the prioritization of those problematic wells in terms of plugging. So we reviewed several studies that have found that inactive, including shut-in and low-producing wells, can leak or display signs of neglect or poor maintenance that can lead to a leak, spill, or release. One such study is a new study that was conducted just last May. This study was conducted in the Permian Basin, so not in Colorado. However, that study found a number of problems at specifically shut-in wells, non-producing wells, and abandoned wells. And those problems included rusty and leaking wellheads, open leaking casing, leaks at ball valves, damaged pipelines, leaks at open pipes, corrosion, and other various issues that either can lead to leaks, spills, or releases, or that just demonstrate a history of poor maintenance. Rule 434 D2A requires an operator to permanently cease hydrocarbon production from an oil or gas well in order to add the well to the operator's plugging list. This requirement should, in theory, mean that wells on an operator's plugging list are either shut in or temporarily abandoned, or in other states that limit the potential for emission spills and leases. Nevertheless, we know from the studies that I just mentioned, as well as, again, local government inspections and just common sense, that things can go wrong and the wells that are not supposed to leak can in fact still do so. For example, a valve used to shut in a well can leak or can be improperly closed or can be opened at some point, for example, by a trespasser. In addition, the current rules do not require operators to purge flow lines or tanks associated with out-of-service wells when adding such wells to the plugging list, and these sources can leak as well. We also know from studies and our own inspections that older, lower producing wells are not always as well maintained as newer, more economically productive wells. Per the current definition of inactive, lower producing wells are likely to end up on an operator's plugging list. Some of these older, lower producing wells may not have been well maintained prior to an operator ceasing hydrocarbon production, and thus may already be located at facilities that have unmitigated leaks, spills, or releases. You've heard a lot about the AQCC leak detection and repair requirements and why it is not appropriate for COGCC to adopt an LDAR or air quality requirement. Let me be crystal clear. We are not asking you to adopt an LDAR requirement or to regulate air quality. Our recommendation is simply that operators provide information in their Form 6A regarding any leaks detected but not repaired pursuant to the AQCC LDAR requirements or the AVO inspection requirement that is suggested by staff in Rule 434 D11D. And we think this is important for two reasons. First, with respect to leaks of air contaminants or emissions, the AQCC inspection requirements are likely to find more leaks than the proposed COGCC AVO inspection requirement. That's because AVO inspection requirements do not reliably detect air emissions, and this is borne out by the annual reports that operators submit to AQCC. Rather, instrument-based inspections detect many more leaks than AVO and are much more reliable. Second, the AQCC inspection requirements contain multiple exceptions to the mandatory repair timeframes for detected leaks. Slides 6 through 9 in this presentation detail all of these exceptions. I'm not going to go through all of them now, but the summary is that these exceptions leave open the possibility for a detected leak to remain unmitigated for an indefinite period of time. For example, a leak for which a part is required to repair may go unrepaired until 15 days after receipt of the part. We know from our experience with the COVID-19 pandemic that supply chain issues can delay the receipt of goods for months, if not longer. Informing COGCC of unmitigated leaks detected pursuant to the AQCC rules is inexpensive and easy. AQCC already requires operators notify, get to the right slide here. I think I went past it. I guess that's it. Well, I might have taken that slide out. Sorry about that. AQCC already requires operators notify the Air Pollution Control Division and the relevant local government of unmitigated leaks discovered in some circumstances. Actually, that is on this slide here. Our proposal would simply require operators to provide this exact same information to COGCC on Form 6A. In other circumstances, operators are not required to notify APCD or the relevant local government, but they are required to maintain records of their inspections and any delayed repairs. The delay of repair record keeping requirements are on slide 11. For these types of leaks, our proposal again would simply require operators to provide this specific record keeping information to COGCC on Form 6A. We have prepared red lines that show our recommended changes, and I would be happy to discuss them with you after Ms. Burke continues with the rest of the presentation. Take it away, Ms. Burke, if you're here.
Yeah, sorry, the old mute button. Thanks. Good afternoon, Kate Burke with the Boulder County Attorney's Office. And first, this is a slide from our earlier presentation. This is a response to some dialogue earlier. And I wanted to clarify that our earlier advocacy was for a marker at the 80th percentile, as opposed to 80% of any particular number. That's what this graph shows, that of the number of events, projects, actual plugging incidents, we're looking for a marker that would be enough to satisfy 80% of those. So just a reminder of that. And then can you go to the next, Elizabeth?
Of course.
And then this slide ignores that percentile concept just for a moment, mostly because I'm a poor statistician and even worse graph maker, but it makes an important point in a solid visual way. By staff's evaluation, the average cost to plug an orphan well, so plugging only now, is about $52,000. But the single well financial assurance for plugging right now is set at 1/5 that amount, half, or a quantum below the lowest identified cost for any of the orphan well projects. So this just makes no sense to me. I don't have the full data set stuff used, so I don't know where the 80th percentile of these project costs would fall, but I'm sure that it would be at or more likely well above the average of 52,000. Yet the draft rule sets the default at a tiny fraction of that amount. So the single well financial assurance for plugging itself should be significantly higher than it is. And our preference is at 80th percentile of whatever that best data set is. Okay, next slide. This one is another charting effort, but it's attempting to demonstrate how far stretched the Orphan Well Fund will be under the draft rules. The Orphan Well Fund will now be looked to cover all the risks that are left over from single well financial assurance, which we know at any level is not going to be 100% coverage. Number two, unknown remediation costs that lurk beneath orphan wells and locations. Number three, approximately 100 new orphans per year that arise if the last several years' trends are continuing. Number four, all the risk left uncovered by the discounted blanket bonds. And number five, whatever wells are orphan do relinquishment. So I think it may be appropriate that the Orphan Well Fund is working that hard, but it does demand that the Orphan Well Fund is adequately fed and maintained. So in thinking this through, I concluded that the annual registration fee needed to be $200 per well per year to raise $10 million. That is enough to take care of 100 new orphans per year. And then the federal funds that we're looking forward to will make a substantial dent in the existing backlog. But as I understand it, won't do much beyond that for future orphans to come. And so I was very glad to hear that PDC, Oxy, and Noble also came up with the $200 per well number, and that West Slope COGA too was amenable to that. And so then in addition, that the fractional pennies per foot of depth device that was proposed in the draft, as several of us ran math on that, and it didn't seem to add up to any significant funds. So it didn't seem to be worth its complexity, and that we think that should be abandoned for a flat, predictable fee starting at $200 and then to be revisited in that biennial schedule. Okay, next slide. We continue to advocate for the reclamation single well financial assurance to be measured by acre disturbed for all the reasons that you've already heard. And this is our graphic we had before, just showing that a single well can have a great deal of access road and associated pads and underground flow lines associated with it that will also need to be reclaimed. Next. And then I found this matrix going by acreage and also by types of soils and geography was presented in May by staff and might provide a good starting place to be able to tailor reclamation bond amounts to the acreage disturbed. So some of this work has been done. And then the proposal that Mr. Sura made just earlier from the conservation groups working off a per site amount is probably worth discussion. My one concern with that is to be sure that off-site issues such as flow lines and roads and non-co-located production facilities would also be included. Okay, next slide. Finally, we have our also list of important but miscellaneous items. The voluntary relinquishment issue, we have similar concerns around this to those Ms. Merlin listed earlier. And I actually have a quick and dirty red line effort to put some guardrails on that rule if you'd like to see it and if you have time. Option 5 of the bonding requires submittal of a certification of financial capability, but none of the other options do. So we want that same certification to be supplied for all options. 5% per year and 10% per year on ramps for options 3 and 4 are too low and slow. We support Earth Justice's points on that one. The option 6 super bond is also too low, as other parties have mentioned. We agree with them. We support the Earth Justice Group's recommendations for plugging benchmarks for the out of service well plugging list, a yearly benchmark. We support Adams County's clarifications to the definition of inactive well and clean up on the barrel of oil equivalent, MCF, MCFE formulas that seem to be a little confused. And then we also support our local government colleagues on their comments, even though we might present some slightly different ideas on some of those. So if we still have time, we can go to the next slide.
Is there another slide?
There's supposed to be.
don't think I have another slide, but I can stop screen sharing if you have a slide.
Well, I did have a slide.
Hold the time, Ms. Larson, while we figure out where their slides went.
Possibly in our inboxes.
I just go to it, it's version, this version column, version 95.3, etc. It's what it is the, here we go. Okay, so now let me share.
Okay.
Oh, you have to stop sharing this.
Did I stop sharing? I think I did.
No.
Yes. Okay.
It's red lines on the voluntary relinquishment rule that I'm trying to get to.
Yeah, I was going to ask you to go over that, so hopefully you can find it.
That was a pretty poorly disguised invitation to. Okay, you there? So, so the things I just threw this together. I'm not wedded to much of any of it, but the things I was trying to cover here were some of the possibilities of difficulty and sort of games playing. So in the first segment there, what I was trying to cover was in the civil law and bankruptcy, we might call a fraudulent transfer problem, where people quickly rid themselves of assets that they want to hide and then turn around and relinquish the rest of their wealth. So this would include a certification that the operator who wants to relinquish hasn't transferred any wells for the prior 12 months. And also to certify that it doesn't have the financial capability to decommission the wells. That might be inherent in the idea that it's going to a hearing, but that should be expressed. And then the second piece was an effort to get at what Ms. Merlin was talking about as far as what I'm calling sort of corporate shell games, where the same people or the same entities who are partners in or owners of or managers or members of one entity may reform themselves under a different name, but in fact are the same set of folks, and that they should also be prevented from operating in the state. So these are problematic. It was hard to even figure out how to write it. I'm not wedded to how I did write it, and which is part of the reason that, I mean, Boulder County in particular just has some real concerns about this rule, because it is hard to put these guardrails on. But if it's going to go forward, I think something along these lines would be very helpful. And Commissioner McGowan was talking about how in enforcement proceedings or bankruptcy, that orders can be clear about that it's the individuals behind the entity are also covered, but I just thought that should be expressed in the rule because it's pretty important. So that's what that is.
Thank you, Ms. Merlin. Or Ms. Berg, I appreciate the language that is similar to the thoughts that I had around that issue. I do have some questions of Ms. Paranos on some of the earlier stuff, but Ms. Commissioner McGowan, did you have a question on this issue?
Yes, thank you, Mr. Chair. So, and thank you for your thoughts about this. And I think I'm struggling also with the narrative that we've heard in testimony that there's all these zombie wells out there, get rid of them, get them out of the system. And I see the relinquishment program or avenue as an opportunity to deal with those. And then when we create it, everyone's unhappy that we're trying to figure out a way to deal with all these zombie wells that are out there. So it's been a frustrating week for me. So I'm not taking it out on you. I'm just expressing some like, wah! It just like competing narratives. And I appreciate you trying to put some red line in this and try to create some guardrails. I think that for me, A would not necessarily work, because if this kicks in, let's say we approve these at whatever time frame and they have until December to do it, some of these entities may have transferred something between, so that the 12 months prior I think is unfair. They didn't even know this was coming, that we were going to put this together. To everybody's point, it's apparently a shock that we're talking about this. So I don't think that they've gained the system up to today. And so I think we need to change the prior 12 months if we're going to keep this as an idea. And I just want to know what you think about that. And then I think I've heard Commissioner Gonzalez talk about, I'm not sure, I don't know how many of us have had jobs where we didn't necessarily agree or were on board with what our bosses or owners were doing or responsible for those decisions. And so I'm not sure how deep down we go when we say an operator, doesn't get to start over again under a new corporation. So I just want to make sure that we're having kind of that conversation too. And Commissioner Gonzalez, if I put words in your mouth, I apologize. So yeah, if you have thoughts about that, I'd appreciate it.
Yeah, as far as the period of time not to have transferred, I had the same thought. I almost put, counted months from April 15th to December 31st. But I also felt like so anyway, I'm open to that. Prior to this discussion today. So that's
Is Ms. Burke only freezing for me, or is she freezing for other folks? Do I have a bad connection?
Yeah, that's always the question, right? Commissioner McGowan, is it you or is it everybody else? I think she was freezing for everybody. But she's
sorry,
back.
Ms. Burke, could you restate what you said? You froze for a little bit.
Yeah, am I back?
You're back.
Okay. So I thought about that too. I left it at 12 months because, first of all, to echo my vague memory of how it works in civil law when judgment collection, but also because I thought if someone's been busily transferring even these last prior months before today, that might be, they might have been doing that in anticipation of a bankruptcy or something else too. So I just felt like I'd go ahead and make it bigger, but I'm very open to all of those details being tweaked. And then the second piece is really difficult. I mean, and this is, what Commissioner Robbins recognizes as piercing the corporate veil is tough and it's a mess. And so I tried. The concern is when you have an LLC, then you have members and some of them are known and some of them aren't, and it's not necessarily public. And then there's partners and there's the owner founder, and they might call themselves the president. And so it can be very difficult to figure out who am I concerned about here and how do I get at that. But again, I think if you're interested in the concept, your AAGs can look at other legal instances where we're trying to get the right parties in front of the court, for example, and they have to go through the same determination. So they're looking at it's always the management level and above major financial partners. There's a lot of things you could look at. It's tricky, and that's one of the reasons I almost hesitated to even try. But yeah.
Could we solve the problem by taking the language and tweaking it slightly to say the commission has the discretion and authority to prohibit blah, 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 subset based upon an analysis of the company, et cetera?
I would think so. I mean, that's what we're trying to build in is that we're just trying to prohibit anybody who might be out there having malicious thoughts about playing games and hiding behind entities. And so I think anything that gives you the ability to look at that and wherever you want to draw the lines, I think I would have faith in your AAGs, but I think something to that effect ought to be in there.
Great. I want to thank you for your quick editing. That's always helpful. If you guys can make sure you share your slide deck, that would be great as well. Commissioner McGowan, if you're done with this topic, I was going to go back to some of the earlier topics. Okay, let me go back to my notes here. So back to the initial discussion, Ms. Pranos, on the unmitigated leaks and all that kind of thing. Can you get back to that slide, to those slides?
Yes, I hope so. Can you see them?
Yeah, we're at the red lines. Okay, good.
Yep.
So, so I appreciate the clarification and the idea that you're calling for information sharing. And it sounds to me like you've come around to not to allowing the AQCC LDAR to just remain in place and not double down on that in our rules and instead go with the staff's AVO. And do I have that part right before I move forward?
That's correct, and that was always our position.
Okay, and I apologize if I misinterpreted that you were asking for something different. So with that clarification in place, I'm not sure I understood once the commission receives that, and then there is a quote prioritization for unmitigated leaks. What is meant by that? Like, what does prioritization mean, and what
Sure.
does unmitigated leaks mean?
Sure. So currently in Rule 434, once an operator puts a well on its plugging list, it has to provide in its 6A information on the location of those wells and whether they're located within 2,000 feet of a home, for example, or in a disproportionately impacted community. And there's a requirement that the operator prioritizes the plugging of wells that are in those locations, right? And that's clearly because that's sort of in recognition that some of these wells on an out of service list can pose a threat to public health, safety, welfare, of the environment. So when we went back and we looked at the AQCC rules with respect to air emissions and the commission's rules with respect to spills and leaks, and in recognition of this new AVO requirement that staff is suggesting, it appears to us that there's the potential for an unmitigated leak, whether it be an air emission or a spill from a tank that hasn't been fully drained yet, or a flow line that hasn't been purged, to occur at one of these wells on the operator's out of service list. And so just like we think it's important to prioritize the plugging of wells that are near homes and schools and in disproportionately impacted communities, we think it's also important to prioritize the plugging of wells that have unremediated contamination issues. And so we didn't specific timeframes into this rule in terms of how long the leak has gone on before it's important that that well gets prioritized by the operator on the list, because I think it would, it's going to be a case-by-case determination. Some leaks might go on longer than others, and some might be in the process of being remediated, but not fully remediated. Other considerations are important too, in terms of the location of the leaking well. But we do think it just makes common sense. Again, just makes sense to have operators not just looking at the location of the well site, but also are there leaks or spills or releases on a well on their plugging list, and if so, if they can't remediate those leaks in a timely manner, to perhaps move up the plugging of those wells.
Okay, thank you for that clarification. So, but there's no parameters around it. It's just prioritized. Is that right?
I mean, that's the current language that the staff rule uses. Yeah.
Okay. And then unmitigated leaks, that's defined to be, I think, if I'm thinking through this correctly, any leak that is otherwise meeting one of those exceptions that are not otherwise needing to be fixed quickly. Is that right?
So it would be certainly for any leak that the operator detects pursuant to the AQCC rule, and they don't immediately repair it and they put it on the delay of repair list. It would be one of those leaks for sure. It's also possible that an operator could detect, although we think it's unlikely, a leak with pursuant to the COGCC AVO requirement. And the COGCC AVO requirement doesn't have any repair timeframes associated with it, right? What staff has proposed is just go out and do an annual AVO of the wellhead. There's no repair timeframes associated with that. So we were trying not to impose additional requirements beyond what we think is necessary by suggesting repair timeframes for leaks detected with AVO. But certainly you could have an unmitigated leak that's detected by AVO. And then similarly, Rule 912 does require the reporting and at least the beginning of remediation of spills and releases. But there are some spills and releases that actually aren't subject to the reporting requirements in Rule 912. And there's also, it's possible that a spill or release might not be remediated quickly, and it can go longer than 90 days. And that could be indefinite as far as I can tell from reading the rules. And so again, coming up with, a specific time frame to define when an unmitigated leak is, a problem and should lead to prioritization, we just thought that was too complicated. And so we're really, leaving it up to the operator as well as, COGCC to figure out, okay, which leaks have been going on for too long, or which spills and releases have been going on for so long that the well really needs to be plugged more quickly than perhaps the operator might otherwise choose to do.
Okay. I think I understand at this point the approach, and thank you for bearing with. I know you've been trying to get this out and to everyone in a manner that is what you meant for a long time, and I think there's been a lot of, consternation or other around it, but I appreciate that. I think Commissioner McGowan has a follow-up question on this topic.
Thank you, Mr. Chair, and thank you, Ms. Paranos, for sharing this information today. I know everyone has real lives. I didn't know if you listened to some of the discussions yesterday with industry about this issue, and I'm wondering if we were to put milestones around what has to happen with an out of service well to purge the equipment, depressurize, etc. If that solves all of this reporting problem, if we went towards some sort of milestones with out of service wells.
I certainly think that would help. I have not had a chance to fully discuss that option with my clients nor with the rest of the ALGC and see if that satisfies folks' concerns. I did hear that. I thought about that. I think that helps. I think we just need to think through a little bit more and make sure that completely resolves the issue, because as I mentioned, it does seem like there are some spills or releases or leaks that can go on for an indefinite period of time. And so again, it would be that question of making sure that, even if operators are doing the final decommissioning, purging all equipment, turning off electricity, all of those things, if there's specified timeframes for them to do them, are they still making sure that at the top of their list, these are these wells that are problematic and have remained problematic for a long period of time?
Thank you. I appreciate that, and I look forward to your feedback if you have time to think about it and circle back with your folks.
Absolutely.
Commissioner Messner.
Thank you, Mr. Chair. And thank you both for your presentation today, and Ms. Paranos for clarifying the kind of the request around the plugging list. This is kind of how I initially interpreted it. I'm a little disappointed that there's no soapy water associated with this, though.
I'm not sure how that entered into other folks' minds, that was something we were planning to propose, but there you go.
I am a little confused because there was some concern about additional reporting, and so you're not asking for additional reporting associated with except reporting that would already be done. I mean, unless they're submitting a form 6A, and I acknowledge that and understand that, but
that's
other
fair.
than that, it's the 6 month, it's a 12-month, right?
We are simply saying if an operator yes, it's just it's information sharing, either due to existing COGCC requirements like this AVO requirement or the AQCC requirements. We are not suggesting in any way that operators create a new LDAR report or even a new record that they have to maintain. All of the information that we believe operators should be providing to COGCC, they are already either providing to the Air Pollution Control Division or the relevant local government in some instances, or they are maintaining those records pursuant to AQCC regulations. And in the slides, you can see all of the different rules and where they apply, because it is complicated under the AQCC rules in terms of when an operator has to notify APCD versus or the local government versus when they don't. It just depends on a number of factors, including the location of the facility and also the type of leak detection instrument that the operator uses to identify the leak.
Okay, thank you.
I just wanted to add real quick to that. Boulder County has new regulations in place that require a monthly report from operators about their own inspections. And after some initial, as this only went into effect 6 or 8 months ago, and once it was clear on both sides what was needed, the operators have been able to provide that information very straightforward, which is more information than I think what Ms. Pranios is suggesting. So even though they don't necessarily have to make that same report to COGCC, they have to keep those records. I mean, I'm sorry, AQCC, they have to keep those records under AQCC regs, and to just run the report and send it to us doesn't appear on our side to have been much of a burden.
Other commissioners with questions? Okay, well, thank you both on behalf of your numerous communities. We do appreciate what you brought to the table. We would appreciate seeing those red lines in the inbox. And this has been helpful, I think, this afternoon. I'm going to call an audible. I'd like a break. It's almost 3 o'clock. Let's return at 3:10, which is 12 minutes from now. All right. Hello, everybody. It is 3:11. We are back on the record, and we are continuing through our party presentations. 9 to go. We first will take up a presentation by the City of Brighton Group. That's Brighton, Commerce City, Larimer County, and City of Thornton. Third time's the charm. We get to hear from Mr. Sura.
Thank you, Chair Robbins. Stephen Lewis Prescott here. I'll do the intros and give Mrs. Sura's voice a little rest.
Oh, great. Good to see you, Mr. Lewis Prescott.
Thank you. Stephen Lewis Prescott on behalf of the City of Thornton. With me is Ms. Sura for the City of Brighton, Commerce City, and Larimer County.
So the outline of the presentation today is we're going to discuss a minor revision to the proposed language at 503G12, support for low producing wells definition, the existing one, calculation of single well financial assurance, support for the ALG's leak reporting proposal, and support for Pitkin County's position to apply state bonding on federal lands immediately.
I'll jump in here with respect to Rule 503G12 and the threshold for local government and surface owner standing with Rule 211 applications. And first, I think the local governments and surface owners alike would like to thank the commission and staff for the thoughtful just process this has gone through, and stakeholders across the board. I think there's general agreement that we got to a good rule here, and we're very appreciative. Now you're looking at a red line here and wondering why the heck are we redlining it when this was essentially our language. And frankly, it's not a change. It's not meant to be a substantive change. It's meant to be a clarification. I think we had a midnight oh crap moment looking at how it's written for a minimum of 36 consecutive months when taken in line with the definition of low producing well, which we'll look at in a second. It really caused concern as to how this would be interpreted by future applicants and commissions and staff, and really wanting to avoid ambiguity. You know, the intent is there. I don't think we're doing anything to change the intent, but just clarify the language. And that's what we are proposing with this, what we believe to be a minimal change. If we go to the next slide and look at low producing well, I think you'll see what we're talking about. Daily average of less than 2 barrels or 10 MCF of gas over the previous 12 months. And if we go back and look at the definition as admittedly we proposed, and it was poor drafting on our part, that for a minimum of 36 consecutive months doesn't jive well with the existing definition of low producing well. So the proposal here is just to clean up on this, and our apologies for proposing less than unambiguous and clear language.
Thanks, Stephen. And we do support this low producing well definition that has been discussed by numerous parties, and I think was universally supported, at least in the pre-hearing statements. Now, there are some parties that are trying to change it. We'd like to see this remain. I want to move into single well financial assurance proposal. The proposal being put forward by the Brighton Group looks at an estimated cost of plugging and abandonment that better reflects the reported Colorado Oil and Gas Conservation Commission Orphan Well Fund expenses. And that is $20,000 for 3,000 feet or less, $40,000 for 3,000 to 6,000, and $55,000 for more than 6,000 feet. I also want to move into $100,000 and support for $100,000 for oil and gas locations, with some ability for the Colorado Oil and Gas Conservation Commission staff to adjust that cost in outlying cases using the other relevant factors you see here from the existing regulations or the existing draft, including this language, just making it very clear that we're looking at offsite production facilities, length of offsite flow lines, and access roads as well. Single well financial assurance needs to apply to all oil and gas locations that are associated with inactive or low producing wells. And this is a little bit of a visual a little preview that you're going to get from Adams County. But this demonstrates that there are production facilities located sometimes well away from oil and gas wells themselves. And of course, that flow line has to be accounted for, as well as the footprint for the production facility that it's going to. An example from a client of mine is this 5-spot location. You've got 5 wells here, but you also have in the middle of that and flow lines going from each one of these wells to this production facility. In the current draft, it's not clear that this production facility would be addressed. There it is. And finally, I want to support the Allied Local Government Coalition's leak reporting proposal that you just heard about, and support for April 15th, 2022, the effective date for application of state financial assurance rules on federal public lands. Thank you.
To unmute. I was here the whole time. I was eating an apple. Commissioner McGowan, I am now unmuted and I saw your hand out of the right corner of my eye.
Thank you, Mr. Chair. And I'm sorry, I'm just feeling a little brain dead. Can you explain to me why each year for the past 3 years is better or preferable than for a minimum of 36 consecutive months?
Yeah, I think the concern and the ambiguity there, frankly, is whether we're looking at a low producing well each individual month or daily average. And Matt, I like your thoughts on this as well. We went back and forth and just had some confusion with how this was written.
Oh, and one of my clients thought that it meant that the average was going to be over 36 months. And that's just not, I don't think that that's what we were thinking about. The way that the low producing well definition is that it's a daily average over the last 12 months. So it's really looking at the last year. And you'll remember that language initially said 365 days. And, you know, there was some request from industry to change that to 12 months, and that's what happened. We just then, again, that was a late night, right before we went before you at the closing statement. You'll remember that that's when this language came out. We checked with a number of local government allies, and everybody kind of signed off on it, but it was admittedly done hurriedly. And and looking at the language, it wasn't as clear as we'd like it to be as to what it actually means. And so you want to look at a low producing well is defined only, it can't be defined by a day, it can't be defined by a month, it has to be defined by a year, and that year's production, averaged over that year. And so we wanted to make sure that it was done in increments of 3 years, and again, that was also to try to comply with what we heard, some questions from the commissioners, but also the industry saying that really 3 years is more appropriate than a year snapshot.
Others with questions? Commissioner McGowan, did you have follow-up?
So thank you, Mr. Chair. So are you trying to say that you're worried someone might read that and read that it could be interpreted on a per month basis and instead of an average over a year?
The concern from my side was that it would be looked at an average over 3 years instead of 1 year, as the low producing well definition suggests, the past 12 months. So this new definition says you look at the average each year for the past 3 years instead of the average over 3 years.
Okay.
As an example, if all of a sudden, somebody reworked a well that had been shut in for 2 years and reworked that well, and all of a sudden it came back into production, you wouldn't want to try to average it over the last 3 years. You would want to look at it at the last year, and count that year of production as kind of resetting the clock or taking it out of inactive or low producing status.
Thank you, Mr. Chair. I wonder if we could go to the slide that talked about associated production facilities. And I mean, I see what you're suggesting here. How are you suggesting? I mean, maybe walk through it a little slower so that this brain dead individual can figure this out. But are you going to pick a location to associate the production facility to if you've got multi well sites being gathered into one production facility, or are you going to treat that production facility independent? Or I'm struggling a little bit how functionally that works.
Yeah, I think that we need to reconsider this as location by location when we're looking at reclamation, because there are a number of oil and gas locations, a defined term, permitted locations, that are on the map that you can find that all need financial assurance, if they're low producing or associated with low producing wells. And so that is the concern, is that particularly with single well financial assurance for low producing wells, we want to make sure that we're capturing every land disturbance, that is already permitted by the Oil and Gas Conservation Commission, as well as those locations that have the wellheads themselves and the plugging costs. But really, it needs to be looked at separately, because in many cases, particularly on the Front Range, actually on the Western Slope as well, you've got wellheads that are located, and then you've got a production facility. Maybe it's a compressor station, maybe it's a bank of compressor engines in Rifle, and that doesn't have any wellheads associated with it, or there are not any wellheads there, and yet that is certainly an oil and gas location.
And I appreciate that. Are we, I guess my question again is your suggestion that those get treated as an independent location, or should that be tied into a well pad? So even if it's multiple well pads that are associated with the production facility, does it just get associated with one of them as far as determining this piece? Or does it get treated independently, I guess?
Well, my sense is that it would need to be treated independently because we don't know, and in many cases, there may be one well that is plugged and abandoned and the rest of the wells would remain. And so I don't know that associating it with one well would make sense. I think you almost have to treat it separately, and it's not a mystery. We have a list of oil and gas locations. You can look up oil and gas locations, at the Colorado Gas Conservation Commission map or COGCC, and there's a list there for us, just like there's a list of oil and gas wells. And my sense is that we would be well served, particularly for those locations, those production facilities that are located away from oil and gas wellheads, to consider them separately.
Okay, thank you.
Thank you.
Other questions? Bless you. All right, I'm seeing no further hands. Thank you both for the presentation and for being with us this afternoon.
Thank you much.
We now will hear from the Board of County Commissioners of the County of Pitkin. So let's give us a sec to. Hello.
Hello, Commissioner Robbins. Laura Maker, representing the Board of County Commissioners of Pitkin County, Colorado. I was once told that 3:20 was the perfect time in any deposition to slip any question in and trip up a witness, because everybody is absolutely exhausted after a long day of trying to think through really difficult things. So I hope you all will bear with me, and I recognize that you really have been at it for quite a while. I am here to talk about the thing that I always talk to you guys about in respect to this particular rulemaking, and that is the application of financial assurance, the state financial assurance regulations to federal lands. I'm going to pull up a presentation, and I have to apologize, it's low tech and just as boring as 3:20 calls for. So can you all see that?
We can. You're not quite in presentation mode, if that makes a difference.
Okay.
Now you are. You're good.
All right. So again, on the financial assurance rulemaking, I was so encouraged that this commission has decided that financial assurance should apply to federal lands. Pitkin County proposed language that basically called for the delta between whatever the state requirement would be and whatever has previously been provided to a federal agency for a well on federal lands. So this was really to address what the commission had identified and staff had identified, and I think the other parties, as a double bonding concern. So what we had proposed was basically to just require the delta between whatever the state would require and whatever had previously been paid to a federal agency. So this is Pitkin's proposed language. The most recent draft changes the previous drafts, is no surprise, and deals with financial assurance in two ways. One was taking into account the commission's comments regarding the time frame applicability, and the other was, I think, ostensibly trying to get at ensuring that there was no double bonding. Unfortunately, I think that this has maybe gone beyond that. So I want to flag a couple concerns for the commission regarding this language. There are two, I think, critical differences. The concern identified previously was double bonding. So the Pitkin proposal only required the delta between the state financial assurance and the federal financial assurance amounts. The 21122 draft adds in what Commissioner Messner had discussed regarding substantially equivalent. So, there's a little flexibility there. And then it takes a step beyond that and says, what additional financial assurance is required so long as it is not duplicative of whatever the financial amount imposed is, can be discussed with the chair and with staff. That's a huge loophole. It does not put this down to the delta that this commission had talked about and had been raised as the concern of double bonding. So it really does open this door wide open. So I'm going to go back a slide and have you guys look at the actual language in the 211 draft. So bear with me because I know looking at language is getting quite old. But if you look at this right here, that's what I'm concerned about. The second sort of part. The financial assurance, the commission or director will determine what financial assurance is required by the federal government is substantially equivalent, and if not, what additional financial assurance the commission would require. This doesn't speak to the delta at all, and it doesn't require the delta. So this is really quite open in a way that I at least did not hear from the various commissioners when you guys were discussing this. So I want to flag this issue for you. The second critical difference, I think, between what had been discussed is the time frame for adoption. Pitt-King continues to advocate for this as the time frame upon the adoption of the COGCC rules. I did certainly hear the commissioners and staff say they're concerned, you know, a BLM rulemaking is coming, and they anticipate that could change the amount of federal financial assurance various entities are providing. As we've discussed before, there's no guarantee of that time frame. In fact, timeframes for federal financial assurance are likely to go well beyond what has been proposed by staff in this most recent rule. The 12, and I think I have 1212 draft on there, I think 1211 draft, specifically says that the rules would apply 90 days after the BLM rulemaking concludes, or no later than October 15th, 2023. If the commission really does believe that there needs to be this ability for staff to understand what the federal government is going to do, despite the fact that, you know, our concerns here in the state don't go away no matter what the federal government does, and the federal government can change this multiple times in multiple directions on multiple timescales, I think it's really important to understand that you're likely going to end up on October 15th, 2023, not having a final federal rulemaking. And so you've pushed this back in the hope that you'll have more information. You are likely not to have. And you will likely see changes in the federal rules in the future in such a way that you'll end up sort of chasing the federal government around on this issue in a way that really doesn't meet the state of Colorado's needs. I'm happy to answer any questions. I've tried to keep this short and sweet. I know I've talked to you guys about this issue, and it's a pretty small, discrete issue in the scope of a very large, complex rulemaking. So I thank the commission, staff, and the parties for their time and thoughtful sort of approaches during this rulemaking.
Questions, commissioners? Commissioner Nanjapi.
Thank you, Mr. Chair, and thank you very much, Ms. Maker, for presenting again today. I just had a couple of questions, I think, to clarify. First, I think I've heard from some stakeholders that often the federal bonding amounts are provided across larger areas, and so are not tied necessarily to a single well, and in some cases maybe even be tied to the operator across multiple states. So, you know, I've been thinking about this in terms of this delta, because I do agree that, you know, it would be good if we could ensure that there was good coverage when we felt that that amount was not sufficient. And so I'm curious if you could maybe elaborate a little bit on how you see that getting calculated. And then the second piece of the question is that a couple of different stakeholders have sort of suggested language instead of the substantially equivalent to something more like exceeds or is equivalent. And in that instance, then we would not, require additional bonding. But if it did not exceed or was equivalent to what we would require, then we would. But I'm still trying to figure out how this delta would be calculated. So if you could,
yeah,
help me understand.
If it's all right, I'd like to answer the second question first, because I think it's the easier question. Certainly, I'm fine with that language. There are different approaches to get to the same thing, which is making sure that there is no delta. It's covered one way or another, whether it's state or financial. So, I recognize that people have different ability to draft different solutions, and you come to the same outcome. So I don't want to get too hung up on that. I think the first question is really where the crux is, right? And what I had tried to do in my drafting was to really say, if an operator can demonstrate that they've provided federal financial assurance for this well, then that applies. Now, if you have an operator that has a number of wells that comes under sort of, I don't want to get too confused with my technology, but more or less a blanket bond amount with the federal government, there is the ability to divide and do basic math. Say you've got 200 wells, you put 200,000 out there, that comes up with a pretty clear number associated with each well. I specifically did not include that in the draft because I do think that it's important to allow staff to have some review of this and to come up with some language to address that. I think it's one way to do it, but there's probably pitfalls there. And so I was hopeful that we might see some of those raised and identified, and I don't know that we've quite gotten there. So there's the simple approach that will probably come back and be a headache, but it's doable.
Thank you. I had another question, but now I know what it was. I'm sorry. So you had mentioned that you would prefer to see our rules apply to federal wells right away. And then you also mentioned that, if it was October 15th, 2023, we may still not have the federal rules. But I believe the way we've written this is that it would be our rules will apply by that date or 90 days after the rulemaking if it occurs before that.
Yes, and that's correct. I just expect you probably on October 23rd or near before that, we'll get some sort of request saying, oh, I think the federal rules may come in, in 6 months. And so let's push this back another 6 months. And you may end up in a situation where you're getting requests to push this back and back and back, and it ends up really not applying in reality. And I really, really would caution you against that approach.
Okay, I appreciate that clarification on that point. I think that at least for this commissioner, if we put that language into the rule, that it would be either, our rules apply, and then perhaps on each annual review, if something has changed on the federal side, then we can reevaluate at that point. But I don't, at least, in my view, if we put that language into rule, then if nothing is in place yet on the federal side by that date certain, then our rules, they just have to comply with our rules at that point.
And just to clarify, if you put them into effect immediately with this rulemaking, then you would go through that same annual process where if the federal rules change, you can capture that.
That's a good point as well, and I agree. Thank you.
From my perspective, this is our financial assurance rulemaking. If we were to be asked to extend it again, we'd have to, that would be a new rulemaking, which is a pretty high task. And I'd even be comfortable saying in the SBP that we're not planning on doing that, if that would make you more comfortable.
I appreciate that. I just expect that if you're delaying the application of this in the hopes that you'll have a complete federal rulemaking, it's unlikely. The GAO and the CRS reports suggest the federal rulemaking process takes at least 3 years. So you're probably not going to end up where you want, as much as we would love that.
So we're like winning.
You're winning.
Now
See, you're winning at something.
we're in the year. Okay, I don't mean to be facetious late in the day. Thank you very much. Are there other questions? Commissioner Messmer, was that a, no, okay. All right, thank you very much. We now will bring in Adams County.
Good afternoon.
Hi, everyone. Hopefully I remember how to do this with the share screen option. Here we go. Can everyone see that for me?
Yes, we can.
Awesome. Good afternoon, everyone. And I just want to reintroduce myself. I'm Christy Fitch, an assistant county attorney with Adams County. And with me, a guy that you already know very well, Mr. Gregory Dean. We would like to thank the commission for the revised rules on February 11th of this month, and just have a few updates on what the county is requesting changes to. Specifically, the county is going to be talking about the inactive well definition, reclamation bonding determinations for single well financial assurance, transfer of operatorship, single well financial assurance for low producing wells, timelines, and timelines for submitting single well financial assurance. And on that note, I'm going to pass it over to Mr. Dean.
Thank you, Ms. Fitch, and good afternoon, commissioners. In our final time, I want to discuss our outstanding comments and concerns with this final draft. I want to first commend Director Murphy and her staff for putting forward a very comprehensive draft that addresses most of the county's concerns and integrates varying perspectives into a generally balanced set of rules that we're largely supportive of. First, as it relates to the definition of an inactive well, the county fully supports the inclusion of a production threshold in this definition. We believe a production volume metric will help protect against what the county calls ultra low producing wells that are higher risk to be orphaned in the future and represent nearly 3/4 of all the wells in Adams County. This further helps alleviate potential gamesmanship from certain operators, turning on their wells for one day to keep them in an active status and delaying their plugging requirements. We, however, propose that the volume metric in this definition be changed to 1 barrel of oil per day or 5.8 MCF gas per day. Our red lines are on the screen, rather than using a BOE or MCFV calculation. We support the associated exception provisions in Rule 434C for plugging of inactive wells that would allow an operator to keep their inactive well alive if they simply file a single well financial assurance or place that well on an out of service well list. We think this definition is more simplistic and easier to calculate and sets a production threshold that is commensurate with the heightened risk of these wells and provides some flexibility for operators. Next slide. So next, regarding surface reclamation bonding for single well financial assurance, the county asserts that a per acre disturbance calculation is equitable and a qualitative mechanism for assessing bonding required in these instances. The map on the screen demonstrates this concept and is a representative of the type of assets in the county. Around 70% of all the wells in the county are not co-located with their production facilities, meaning buried off-location flow lines are needed to get the product from the well to the facility. In the county, the average flow line length is around 2,200 feet, and the average access road is around 1,900 feet. This means that when it comes time to reclaim the site, one single well without any flow lines that will have about an acre of disturbance on average, whereas a site with off-location flow lines that need, under the commission's rule, to be dug up and removed and have distant production facilities would have a disturbance area of twice that amount or more. Meaning a per well only assessment may not be adequate to estimate these costs. However, for the sake of simplicity in the rules, the county would be supportive of the proposal by West Slope COGA requiring $100,000 per pad surface bond plus a per well plugging bond based on the depth of the well, with the ability of the director or the commission to require higher amounts on a site-specific basis. We, however, do support a higher per well plugging bond amount as represented by other parties, somewhere between $40,000 and $55,000 per well in Adams County. We support this avenue if it is clear in the rules that the surface bond would cover reclamation costs for these isolated production facilities, off-location flow lines, and access roads. The county believes this proposal, while significantly easier to administer, would get us closer to that 80th percentile of costs that we've previously proposed, just based on the data from the orphan wells provided by the commission. Next slide. Pertaining to the transfer of operatorship, the county appreciates and is very supportive of the proposed amendments to Rule 218. Specifically, we support the new provisions requiring a single well financial assurance for all transferred wells. The county does recommend a provision in Rule 218D that would require a reevaluation of a buying operator's financial assurance plan for all transfers to ensure eligibility of any previously approved plan option as a result of the transfer. For example, if an option 2 operator acquires wells that reduces their asset production below the proposed amounts, it could force them into an option 3 plan instead. This will ensure that the appropriate bonding levels are being met and the risk is being assessed as a result of the transfer of operatorship. Next slide, please. The county also supports the proposal by West Slope COGA that requires a single well financial assurance for all low producing wells above the 10% and 5% thresholds covered under the blanket bonds for option 1 and 2 operators, respectively, in Rule 702D. However, in supporting this change, we do not support West Slope COGA's proposed changes to the definition of a low producing or an inactive well, and request that the definition of a low producing well be left unchanged, as is currently proposed in the draft rules, at 2 barrels of oil per day or 10 MCF of gas per day. We believe this proposal is a good compromise with the county's previous request that would have required single well financial assurance for all low producing wells, regardless of an operator's blanket bond tier, and adequately addresses the inherent higher risks these types of wells have. Next. And then finally, for the timelines of securing single well financial assurance, the county supports the requirement for such for all wells under option 3 and option 4 plans as presented. We acknowledge the need to allow these operators some time to bond up fully over time. However, the county contends that allowing them 10 or 20 years to bond up fully to file all the required financial assurance as currently proposed is not protective and would leave orphan well program with assets absent adequate bonding in place should they become orphaned before that full bond is secured. Many of the operators active in our county that could fall into these categories have portfolios that are likely nearing the end of their productive life and will need to be plugged before that 10 or 20-year timeline is met. Therefore, we propose requiring an initial down payment of 20% of the required financial assurance in these instances in the first year, followed by a 5% or 10% per year after that for all option 3 or 4 plans, respectively. Similar to how a bank may require a down payment on a mortgage, the COGCC in granting this extended time is to secure their full bonding for these operators is essentially taking a significant risk on them. A risk that is in practice leveraged against the Orphan Well Fund as a backstop. And therefore the COGCC should require a higher upfront bond as a demonstration of that operator's financial solvency and as a good faith that they can and will fulfill their long-term bonding obligations over time. If we review this proposal in practice using Painted Pegasus as an example, this operator would have classified as an option 3 or an option 4 operator. And under that would have required a single well financial assurance for all of their wells. Using the West Slope COGA proposal at $100,000 per site plus $30,000 per well, that would result in P3 requiring $17 million in bonding. 20% upfront bond would equate to $3.4 million. When you look at their wells when they took them over in 2018, and then at 5% per year in 2019, 2020, and 2021, that's about $850,000 per year, and would have resulted in around $6 million in bonding being secured by the COGCC prior to this company filing for bankruptcy at the end of 2021. We acknowledge that $6 million is probably not enough to cover the full cost to remediate these wells, which is probably closer to $16 million. However, it gets us closer than the $305,000 that will likely be secured in this instance. Lastly, we want to support several provisions proposed by other local government parties, including the leak detection reporting requirements and the assessment of a flat $200 per well annual registration fee for the Orphan Well Fund that was presented by the affiliated local government coalition. The county also supports the upcoming proposal from the city of Aurora for amendments to the out-of-service well provisions. And this concludes the county's testimony. And again, thank the commission and the staff for allowing us to participate and contribute.
Thank you, Mr. Dean. Always very understanding of the approach. I appreciate the clarity that you provide. to us. Do folks have questions? Commissioner Nanjapa?
Thank you, Mr. Chair, and thank you very much, Mr. Dean and Ms. Fitch. I just had a quick question on the down payment concept. I think this is an interesting concept. Do you think, and in particular, given the example of Paints to Pegasus, that the 20% amount, should that be, and apologies if you suggested this differently for the different options, but should that remain the same across the board, depending, for each option, or would you be comfortable with entertaining, a different proportion depending on the option that you're in? I'm just kind of thinking about this in terms of, would this impose more of an initial hardship for certain operators? And then the second part of that question would be, would you be comfortable with that 20% being provided in a surety?
So yeah, great questions. And I'm not tied to 20%. I put 20% down because I recently bought a house and I put 20% down, so I didn't have to pay PMI insurance. So that was on my that was on my head. And so I thought in my head, well, that's what the bank requires, so they don't have to have insurance. So I threw that 20%. I'm not married to it. And for the sake of simplicity, I applied it to both option 3 and 4. But again, I acknowledge that probably option 3 is lower risk. So maybe 15% or something, some other number. Again, I'm not married to it. I just think at 5% per year, giving someone 20 years to bond up when their wells are probably not going to last 20 years seems to be setting the Orphan Well Fund and the Orphan Well program up for disappointment. And again, I'm a geologist by training, so I'm not super familiar with the different types of financial instruments. So I apologize. I'm not also tied to which type of surety or bond. I think a bond would probably suffice, just based on my information from this rulemaking. Christy Fish gave me a thumbs up, so that's good when your attorney says that's fine. So that's probably where I would fall on that. And again, I'm not tied to that amount. It makes me a little queasy when I know that some wells are probably going to need to be plugged in 2 or 3 years or 5 years. We support those provisions that give credit to those operators in option 3 and 4. So if they are a good operator and they're plugging their wells, it gives them that credit for plugging in abandonment and reclamation. We support that fully, and we think that provision should stay, and that should be taken into account over the course of, it's just giving that upfront payment kind of like speeds the timeline up by 2, 3, 4 years, which I think is needed.
Thank you very much. I appreciate the response. And I do think, having something up front, like with some of these trust fund options, I think, although we're, seeking a certain percentage per year, it's not entirely clear to me, how much kind of gets deposited by which, by month or by, is it all just in the lump per year? So I kind of like this idea of a deposit, and especially if it could be done in a bond or something. This also kind of gets at something that was raised by the conservation groups, Mr. Freeman et al., where they were talking about options 3 and 4 not having a provision, the provision that allows for a 1-to-1 deduction for the wells on the plugging list. In other words, that it would be, if you put wells on a plugging list, that those are separate and apart from the wells that you otherwise have that are currently, in some form of activity, but are, that you then get credit for those wells that you plug, not the ones that you immediately put on the out of service list. I was just curious if you had any thoughts or comments on that.
Yeah, I tend to agree with that notion, only because there's limited financial assurance or none required for out of service wells, and especially under option 3 and 4, those operators, I don't want to say that all those operators are higher risk necessarily, but those wells are higher risk typically. And so I would be a little nervous about not counting those, especially if at the end of the day, if they're putting all their wells on an out of service well list, they don't really have a cash flow to then pay for plugging. And so that's kind of my concern with that. And I think Aurora might be talking a little bit more about out of service well lists and financial assurance.
Okay, thank you. And then last question, this is not something that you directly discussed, but I've been asking this question about on-ramps, to option one, based on especially like financial capability. And I'm curious if you have any thoughts on that. So in other words, an option 3 or 4 operator could potentially on-ramp in to option one based on being able to prove up financial health or something of that nature. What are your thoughts on that?
On the surface, I think I would be supportive of that. I feel the financial assurance process it's a process, not a static thing. I don't think once you're classified as option 3, you can't move anywhere up or down. And I think there's some provisions in the rules that allow a review either annually or biannually or every time a well is transferred. And I think that's probably where it would be most appropriate to reassess. I think if that operator has a history of demonstrating that they've secured their financial assurance, they're meeting their plugging obligations, they're in good standing with the commission, and they can demonstrate financial health, I don't see why they couldn't be classified, maybe on a one-off basis. Obviously, after a public hearing and allow everyone to present evidence as to why or why not. But on its surface, I think that's a fine example. And I point back to like own resources in Evergreen. They're very different. Those operators are not active in Adams County, and we don't really have a lot of those types of wells in Adams County. Most of them are purely gas or purely oil or a mix. And so that's not as much of a concern in Adams County, but I get where you're coming from, statewide.
Okay, thank you. And given that there's been a fairly large proportion of wells that have gone into the orphan well program in your county, unfortunately, I was curious what your thoughts were on the amnesty, given that there's been a lot of discussion about whether or not this is a good idea.
It's funny you bring that up. Thank you for that question. I just had this conversation with Christy. Our absence of discussion on that topic was intentional. On the surface, I get it. It makes a lot of sense. Painted Pegasus, it's been a long process to get those wells into the orphan well program. I get it. We want them under the control of the COGCC sooner rather than later. I get it, and I support that notion. It's really hard to swallow when you've worked with these operators and they've been so combative with you. It's hard to go, okay, sure, just give me your wells. It's hard. And so we might be open to the idea with some sort of provisions that prevents abuse. Again, making sure that similar, I think it was Wild Earth Guardians, ABC becomes ABC Production Company. And I think the commission's smart enough to see through that ruse, and I don't think that would happen. On the other side, I also don't think a lot of operators are gonna, no offense, are gonna use that. I just don't see, as it's written, how it benefits them. To be completely honest, I see how it benefits us. I see how it benefits the COGCC. I just don't see how it benefits them, because one way or another, they're leaving. I don't see why they would say, hey, yeah, you know what, I'm going to work with you, because most of the time, the operators that are giving up all of their wells are the ones we have problems with. It's the ones the commissions already know. They're already working through those processes. And then there's those legal questions of if they're already in bankruptcy, can they even legally do that? Can they say, hey, I'm going through bankruptcy, I'm just going to give you all my wells? I don't know if a bankruptcy court would even allow it to happen. So that's the other thing. And I'm not an attorney, and I'm sorry to put Christy on the spot there. Sorry.
No, I think Greg kind of shows our, I guess, intimidation by that provision. I do think it shows a lot of ability to potentially be abused. I'm not saying it will be. I think Greg and I have been kind of going back and forth on it since it was released on the 10th on whether or not we think anyone would even use it. And without an SBAP at this moment, we were kind of looking for like a why from the COGCC and staff as well on, I know it came up in the hearing when I was out of office, but we get it. We get why the COGCC wants to take wells now, that they're going to get eventually through a quicker, easier process for staff. But we are just concerned with the operators that might abuse that system. And like I'm saying, it's probably not going to happen, but we have to make sure that concern is heard.
Thank you so much. I really appreciate the responses.
Thank you for letting us tear an answer out to that question from you, Mr. Dean.
I was hoping you wouldn't ask.
You're up there.
I'm not sure my commissioners would want me saying, yeah, just give us your orphans.
My support for it is with sufficient safeguards. So we'll see where we end up. Commissioner Messner had a question.
Thank you, Mr. Chair. And thank you for the presentation. So option 3 and 4 as written indicates that the presumption is 10% for option 3 and a 5% per year, or sorry, a 5% per year for option 3 and a 10% per year for option 4. It doesn't say that that's a fixed amount, and it also talks about how it's has a full commission hearing to determine, amongst other things, the presumptive life of the wells and other factors to determine what an appropriate financial assurance plan would be for those particular situations. So I guess I'm trying to understand if it seems appropriate to do a 20%. First of all, for option 4, that would just be 2 years of payments anyway, right? And for an option 3, it would be significant. It would be more, right? So I mean, you'd have to get more out of that. But I guess I'm trying to understand what the difference is and looking at an operator by operator specific situation, look at the portfolio of wells they have, look at the anticipated life of those wells, develop a specific financial assurance plan based on number of wells they're planning on putting on the out of service list, what their financial health is, what their, and then making a determination of how long that those wells will pay into it. I mean, what's the difference between that and having this fixed amount that you have to put 20% down and then move forward from there?
So the way our red line is written is it says the presumptive condition is 20%. To your very point, there may be an instance where 20% isn't necessary. That, to Commissioner Njapa's point, maybe an option 3 operator demonstrates that they're financially solvent and we're less concerned about it. But there are probably a lot of operators that may not be able to demonstrate that clearly to the commission. And so having that safeguard in there gives a little bit of certainty for Adams County. I mean, we're about to get another 189 orphan wells in March. So we want to make sure that that presumption is protective enough to make sure that, instead of 305,000 bonding, if those wells go orphan, we could have secured 6 million. We get it, that's not enough, but at the end of the day, it's more than 300,000. So
I think the other end of that spectrum, as far as the way I think about this and looking at runways and developing any kind of single well financial assurance plan that is applied over multiple years, is that you don't have the other end of that spectrum occur, right? Where you are asking for too much upfront and an operator makes the decision, I just can't do this, so I'm walking away from these wells right now, which is exactly what you're trying to avoid, right? And so I think there's a balance there, and I'll think about your proposal and how that applies. But I mean, these are the things that I think about when I'm trying to make a determination on how much upfront in this particular situation, right? And then how much timeline or runway to be able to afford an operator so that they are able to ultimately, in the end, maintain their responsibility themselves to plug and abandon their assets, rather than having to have orphan wells dealt with by the state. So
yeah, and if I may respond to that, I agree with you completely. I think we spoke about a spectrum last time. We know there's wells that are going to be orphaned by some operators, no matter what financial assurance rules are adopted. We have also this tier that's probably teetering, and we want to prevent those teetering operators from tipping over. And so if that number is 15% or something, I think what the county really wants to get at is a demonstration of financial solvency and a demonstration of good faith that they intend to meet their bonding obligations to the state. Because we're limited at the county to what we can retroactively adopt on existing oil and gas facilities. So that's why we're relying really heavily on the COGCC here, because most of our assets are these ones that are teetering. I mean, we're not as concerned with, the Great Western 50 well pads. We're concerned with the smaller single well pads that haven't produced anything in 2 years or 3 years. And we want to prevent those from becoming orphaned And so what's that number? I threw out, like I said, I threw out 20% because in my head I'm like PMI insurance, but I'm open to suggestions, and it could be, I really truly, I don't want to add more burden to the commission or to staff. I think a lot of these financial assurance rules and practice are going to be on a case-by-case basis, which adds a lot of time. I understand that. And we're trying to prevent that where we can. And so that's my long rambling response saying I agree with you there.
And then as far as the inactive well definition goes, I mean, I think you heard from previous testimony, I was interested in a production threshold for inactive well, but as things evolved and now we're looking at single well financial assurance for low producing wells, I guess I'm wondering why maintain a production threshold for inactive wells if we've got single well financial assurance already being contemplated for low producing wells, which would cover inactive wells. And so I guess would potentially, I mean, it's a strong step towards eliminating that potential gamesmanship you're concerned about, I think.
Yeah, and so it's challenging because I agree. If low producing wells in our definition, in our proposal, which is kind of a pseudo support of West Slope COGA, but keeping the definition of low producing the same, we'd probably be more open to removing the production threshold for an inactive well. But we weren't sure how the commissioners were going to take that, how you were going to take that. So we didn't want to put all of our eggs in the low producing basket. So we kind of spread them around. I think we would be open to the idea if the definition of low producing well stayed the same and was rolled into the option 1, option 2 requirements, because it's already required for option 3 and 4, which we're very happy about. And it's required for, I think it's 10% and 5% for options 1 and 2 respectively. If that stays as is, then that would be something we would be supportive of. Obviously, in the draft, it currently says inactive wells, so we kind of were like, okay, if it's only inactive wells, we would want a production threshold on an inactive well. I think Director Murphy made an excellent point. We also agree that inactive well is kind of an operational standard. So if you want to keep that kind of clean in the commission's rules, we get that. If you don't want to adopt low producing in the definition for option 1, option 2, then maybe create a new definition of like an idle well or a marginally producing well or something like that that would kind of catch those low producers. And I think I presented on that last time. It's like 80% of our wells or 75% of our wells are not just barely low producing, they're like a quarter of the low producing threshold.
Got it. Appreciate the responses in your presentation. Thank you.
And I did have just one comment to make on that. I think you asked that question to Matt Sura on the off-location flow lines and the production facilities. That's a hard question. And so the way the COGCC classifies it now is that the closest well is associated with the facility. Now, if that well is plugged, just the well, but they have another well or 2 wells that are going to that facility, they should be able to transfer that bond that's should already exist because likely that well needs a single well financial assurance. They can transfer that to the next closest well or to another well. I think that we could give some discretion to the operator to pick which well they want to assign that to. There is some instances in Adams County and in the Eastern Plains where, and this one gets a little sticky, there are multiple operators that share one production facility. So there's 4 wells that go to one production facility, 2 are one operator, 2 are another. That would be a little more challenging. And in those cases, I would default to they both need a single well financial assurance for the surface and the well. And then the first well that's plugged, obviously they're not going to reclaim the surface production facility, so they'll get that portion of their bond back. And then that other operator still has it. So if they plug it, they'll get their bond back. And if it's orphaned, then the bond's still there. That would be the way that I would probably think it would need to work. Because the well itself, the wellhead itself and the little fence around it, they're so small in Adams County. They're like 0.2 of an acre or less. And so I think that surface, that plugging, that P&A amount, that 30,000 or 40,000 or 55,000, whatever it is, will probably be enough to cover the well itself and the immediately small surrounding footprint. If you're not reclaiming the production facility too.
I appreciate that suggestion. Thank you.
Thank you, Mr. Dean. Thank you, Ms. Fitch. We appreciate Adams County's continued participation with us. All right, we now have City of Aurora. We're looking to bring Mr. Moore to the table.
Thank you for allowing me to be here. I will share my screen and we'll get started. All right, I want to make sure everyone can see this in presentation mode.
Yes, it is now in presentation mode and we can see it and we can see you and we hear you.
Wonderful. Thank you so much. Well, good afternoon, Mr. Chair, commissioners, and staff. My name is Jeffrey Moore. I'm the manager of the Oil and Gas Division for the City of Aurora. And thank you so much for the opportunity to share my comments today. My comments will be focused on the February 11th draft. I do want to express support for Adams County's comments, the City of Brighton, ALGC, and also the industry comments and recommendation on the flat annual registration fee of $200 per well. The topics I'm going to cover today are three. Voluntary relinquishment, the out-of-service wells, and some perspective on orphan wells. So the first is on the voluntary relinquishment. And after thoughtful consideration, we actually support this by the commission. We think it has some advantages. It obviously gives the commission the ability to understand quickly how many wells may reach the orphan well program and to understand your authority very quickly. We do want to make sure that the opportunity is limited, and this year it is currently, although we would even recommend that you back up that a little bit to even June 30th of this year. We want the opportunity to be limited in time. I don't personally believe that there's going to be a lot of abuse of this because commodity prices are high right now and are expected to remain high through the year. So operators are obviously not going to relinquish wells that are profitable. But I do think that this is going to help not create orphan wells, but help to identify wells which are likely already in a true orphan status. We just don't know it yet. I do think that there's a need to provide some additional boundaries here. And that is, as has been discussed by others today, that all of the operators' wells need to be included in this program. That this has to be an all or none. And I would recommend the sentence that operator must include all wells as of January 1st of this year. Again, the purpose is not for the operator who has high producing wells and a few that are shut in. This is for that operator who has wells that are essentially not producing or are uneconomic at this point and is intending to essentially walk away from them soon anyway. Now turning to out of service wells. Again, this is a good concept and we support it, understanding that the intent is to provide the operator an opportunity to identify wells that they intend to plug. There are some benefits to the operators. There's no financial assurance required regularly or during transfer for out-of-service wells, and they have at least 4 years, in some cases 8 years, to plug those wells. However, as currently structured, there are some potential loopholes in this concept. The first is that there's uncertainty with what kind of wells can be added to the plugging list. I'll cover that in the next slide. There's also currently an option to remove wells from the plugging list for beneficial use. We want to make sure that there's boundaries on that as well. Let me explain that a little bit further. In 434D subpart 2, it states that an operator can file a Form 6A after permanently ceasing hydrocarbon production. But then in the next section, section 3, it asks the operator to list the date that each well will cease, has ceased or will cease production or utilization. We believe that there needs to be some better consistency between these sections to indicate exactly when and what kind of wells the operator can submit to the list. Additionally, in subsection 9, the operator may repurpose an out-of-service well for beneficial use other than hydrocarbon production. I do think that there's an opportunity that a well could come off the list for beneficial use, and then later an operator would want to reestablish hydrocarbon production, and I don't think that that is a great idea. When we look at the definitions here, I still have a little bit of concern. In a previous draft, the definition of out-of-service well indicated there had to be approval of the Form 6A, In the current draft of February 11th, that language has been removed and it's simply submission of a form. Same thing for the definition of the plugging list. Earlier draft had it being approved, now it's just submitted. When I see that language, it means to me that this is an informational form that's submitted by the operator that doesn't have specific approval by the commission, and it could be changed at any time by the operator, and that is concerning. I want to talk a little bit about the time of the wells, the length of time on the list. We already know that to get on the list, you could be an inactive well first, and to get designation as inactive well, it takes 12 months average of very low production, less than a barrel of oil, less than an MCF of gas. Once you reach inactive status, the operator then has 6 months to file their form. Now, depending on the number of wells that they intend to file, they may have either 5, 6, 7, or 8 years to plug those wells. In future wells or future years after 2022, they have 4 years to plug those wells. First, I think these timeframes are too long. I would suggest cutting them in half. The 4 years becomes 2, the 8 years becomes 4. The reason is that, again, there's no financial assurance that's required here by the operators for any of these wells during those time periods. Additionally, there's no intermediate requirements for the operators to actually do any of this work on an annual basis. An annual report is required to the director, but again, there's no requirement for the operator to do any of the work until the end of their time period. So that is of concern. Finally, back in 434D subpart 1, currently there is a restriction where operators can only submit an out of service well list 3 months out of the year, April, May, and June. I believe that this actually could prevent operators from meeting the 6-month post inactive well status requirement for placing wells on the out of service list. And I'm not sure why we would restrict them to only 3 months of the year in filing that list. So in summary for the out of service wells, first, I think that we ought to revert the definitions of out of service well and plugging list to include the word approved. There should be clarity of which wells can be added to the list, and that clarity that wells cannot be removed from the plugging list. If they are, I think single well financial assurance should be immediately required for any well that's removed from the out of service list. We should reduce the length of time allowed on the plugging list and add an annual requirement to plug a percentage of wells on the list each year when that list is active. All right, my last topic, and I've creatively titled this slide, No Need to Fear Orphan Wells. And I've stated this before, but we're going to have additional wells orphaned in 2022. We've already talked about Painted Pegasus. They have 1 well in Aurora. We're fortunate for that, but nevertheless, there are going to be additional wells added to the orphan well list this year. There are others that will follow. We probably just won't know about it until this year or next year. I do support the opportunity and the ideas to minimize the number of potential new orphans, but I think we have to keep in mind that there are going to be new orphan wells, even if we ignored this whole rulemaking. And what I want to see is that we create rules that are the best for the future for our state, and not rules trying to avoid orphan wells at all cost. I don't think that's the right model. I do have some other minor corrections in language, but those are, I don't have time to present those today, but they'll be in my slide here that I'll submit after my presentation. And with that, I just want to thank you again for your time and your diligence, and just to let you know that you are making a difference in our state and in our future generations. And for that, I thank you.
And we appreciate that. Thanks. And we appreciate your presentation on behalf of the city of Aurora. Very well thought out. If you could send that to us, that would be great.
Of course.
Questions, commissioners? Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Mr. Moore, for being here today and sticking it out with us. Appreciate it. I'm wondering if there are certain milestones that we could put in for the out of service list so that you know that an operator is in good faith making progress, not waiting till the 11th hour or the 11th minute of the whatever day. And would that help with your concern?
Yes, thank you, Commissioner McGowan. That would help with my concern. I think if it's a 4-year list, it'd be easy to take the number of wells that are on the list, divide that by 4, or express it as a percentage, 25% per year. And I think that's a very reasonable number, just to, again, make sure that we're making steady progress and the operator is not waiting until the very end of the time that they have available without any financial assurance being available for any of those wells.
Okay. And I appreciate your comment of regardless of what happens to the rules, we're going to see more orphan wells and kind of your perspective on what the goal should be. And I appreciate that. Sometimes we can get lost in the weeds and we need to pull back a little bit sometimes.
Thank you.
Are there questions? All right, thank you, Mr. Moore. Appreciate it.
You're welcome.
We will now call upon Colorado Communities for Climate Action.
Good afternoon, Mr. Evans.
Good afternoon, Mr. Randall, and good afternoon, Mr. Easley.
Thank you, Mr. Chair, and thank you, commissioners. I will endeavor to share my screen, and Mr. Easley is going to handle the heavy lifting here, and I'll help with questions as needed. All right, are you able to see my screen, and is it in presentation mode?
Yes and yes.
Terrific, thank you. Tom, go ahead.
Good afternoon, commissioners. I'm Tom Easley with Colorado Communities for Climate Action, the coalition of 40 local governments representing 1/4 of the state's population, advocating for stronger state and federal climate policy. Next slide, please. A recent opinion piece by Eagle County Commissioner and CC4CA Vice President Matt Scher captures our concerns about the threats from methane pollution from wells at the end of their useful lives and beyond. He goes on to say that Colorado is now experiencing wildfires year-round in places we never thought were fire-prone, mudslides, wildly unpredictable snowfall, temperature extremes, and perpetual drought continue to alter our way of life in ways that are already quite different than just a generation ago. Next slide, please. Our coalition members are engaged because they understand the climate crisis is real and immediate. More headlines from just the past several months drive this point home. Nationally, more than 40% of Americans live in counties hit by climate disasters in 2021. Coloradans this year saw record-breaking heat and dust bowl conditions, the culmination of over 2 decades of drought, the likes of which haven't been seen in over 1,200 years. Next slide, please. Local governments all across the state have become painfully aware that they must be on the front lines of responding to climate change. As Clear Creek County Commissioner and CC4CA President George Marlin points out, we should not have to bear the brunt of the costs of first responders, healthcare workers, business and residential destruction, or hits to the local economy. In Boulder County, the cost to respond to the Marshall Fire that caused over $500 million worth of property destruction are not yet fully tallied, but undoubtedly millions more will be needed to finance recovery efforts. County estimates the 2013 flood cost $98 million in road and bridge damage and $22 million to buildings, reservoirs, and open space properties. In Glenwood Springs, the cost to the city and local economy from a 2020 Grizzly Creek fire are double-barreled, first from the fire itself, and then last year from the mudslides from burn scars that closed I-70 multiple times, both in the heart of the tourism season. Watershed repair impacts alone cost an estimated $86 million. Next slide, please. Science is clear. Preventing methane escape from oil and gas operations is critical to getting the emissions reductions that the state targets call for. Methane's elevated heat trapping potency occurs in the first decade as released, making it critically important to control these leaks at the earliest possible date. There continues to be strong evidence that super emitters are a large source of methane emissions. We simply don't know how much of a threat plugged and abandoned wells are. We must move to implement cost-effective advanced screening technologies, such as top-down aerial measurements that will catch all significant sources of methane leaks. We maintain our recommendation that the SPEP should specify that the director will collaborate with the Air Division to develop a plan to conduct emissions monitoring from P&A wells. Next slide. We are pleased to see that the February 11th draft makes much more explicit that plugging wells in DI communities must be prioritized in operating plugging lists. We continue to recommend that the SBAP highlight the importance of engaging and informing DI communities when operators make well plugging decisions. Next slide, please. You've already heard a lot about the points on this slide. I'll just say that we share the concerns of our local government colleagues that you already heard from today. We support their positions on all these bulleted topics, including prioritization of plugging wells with identified leaks that Ms. Peranios presented this afternoon. To conclude, thank you for so thoroughly taking on this critically important rulemaking and hanging in there this long couple of days. Local governments are stepping up to do our part to fight climate disruption, but we need the state to do everything it can too. We urge the Commission to adopt the strongest possible financial assurance rules. Thank you. Be glad to take questions.
Thank you both for being with us this afternoon and for the presentation. Commissioners, do you folks have questions? Commissioner McGowan.
Thank you, Mr. Chair, and thanks for the presentation today. I've been thinking a lot about the comments about engaging disproportionately impacted communities in the out of service, the plugging prioritization. I'm just unsure what that conversation looks like. Here's a list of wells that we want to plug. You've been prioritized already as disproportionately impacted communities. And I'm really not trying to sound snippy, but what does the conversation look like after that?
Thank you for the question. And I think there's two answers to that question. One is that operators should be doing everything possible to communicate with DI communities. I mean, they're already required to consult during the beginning stages of a well, and it simply makes sense to close the loop at the end of the life of a well. There may be reasons that DI communities want to see a particular well plugged prior to others for health reasons, or who knows what other sorts of reasons. But in the end, it's simply an opportunity to continue to build that relationship between operators and DI communities that's been missing for so long.
Great. I'm not seeing further discussions or further questions. Thank you both.
Great. Thank you.
Thank you.
We now have 350 Colorado.
Sorry, I did that thing where I'm signed in as Deb again.
No problem. We know who you are.
You know who I am. All right, and I'll tell you who I am. Thanks for taking the time. I'm going to share my screen for a little bit. Do this. Oh, sorry, that's not what I meant to do. Let me try again. It's been I've been with you the whole 3 days that we've been on, and it's been a long 3 days. Okay, slideshow, that's what I want. There we go, thanks. All right, hi, my name is Kate Christensen. I'm the Oil and Gas Campaign Coordinator for 350 Colorado. I'm gonna try and have a little fun with this next 8 minutes. I want to start by saying happy anniversary, belated anniversary to everybody, to all the over 100 other parties, commissioner, chair, director, staff. We started talking about this February 10th, 2021. So it's been a big year, and I just want to say happy anniversary, everyone. And what's happened the past year? Industry is killing it. Congratulations, industry. Shell's profits have been over 19 billion as opposed to less than 5 the year before. Chevron had its best year since 2014. Awesome job, guys. We should, given that oil is $90 a barrel right now, we should be able to get some financial assurances. So in the past year, how are we doing? Since SB 19181, and we shall require every operator to provide the assurance to be financially capable of fulfilling obligations. So how have we been doing? They've got a ton of money right now, so that's awesome. So narrowing down to this current draft, this is what we support. There's quite a few things. Prioritizing, like Commissioner McGowan just mentioned, plugging wells in disproportionately impacted communities. We feel like the commission can go farther and prioritize plugging all the wells, not just some of them. We support the full cost bonding on transfer, but also what Earth Justice Group was saying about if the buyer can't provide full cost bonding, then the seller must, and closing all those loopholes. Timelines for plugging out of service wells, we're really glad those are back in. We think the commission could include a significant penalty if industry does not go for that, does not fall in that timeline. We align with a lot of other parties in a lot of other ways. Earth Justice Group, full cost bonds for new wells, kind of a no-brainer. Like you can save the money while you're making it. We support the local government recommendations for leak detection, repair. We support the intent, some of what West Slope COGA was saying, like simplify. We just have a different way of simplifying. Single well financial assurance for every well. Simple. You don't have to do the options. I also agree with, I think Matt Sarah spoke 3 times, and I think it was when he was with the conservation group that he said, production is not a proxy for health and wealth of a company. And that was some of what we were going to talk to. I'm going to breeze through it because you already dug into that with him. PetroShare, Extraction, those were companies that had a lot of production and went bankrupt. So just using production as the only measure of a company's health and wealth, not a good idea. A couple other examples, Chesapeake Energy, Trident Exploration of Canada, other examples of companies where that happened. A couple of things about the rules that could be improved: inactive and temporary abandoned wells. Under the rules, industry can renew the status of wells. They can do this indefinitely, submitting paperwork every 6 months. That shouldn't be allowed. There should be a limit. And we think 6 months is good, year at most. There's a few things missing in financial assurance hearings. We need to add language stating how notice will be given to the public. Sometimes people like me, we have opinions on stuff that we like to share with you. I don't know if you notice, but we do. And we think the rules could explicitly state that the public will be allowed to submit comments on financial assurance hearings, and sworn testimony should be required. So now I'm gonna stop. I'm gonna do something a little risky. I know that we've all been on Zoom for 3 days straight, and everyone is feeling a little like, I'm gonna encourage everyone to like find their inner thespian, maybe stretch out a little. I mean, you know you want to. Just give it a little stretch. That's right. Chair Robbins, give it a little stretch. Everybody wants to, you know, I'm standing up, I'm gonna do a little quad stretch. Okay, this is what I want you to do. Okay, yeah, exactly. We're gonna stretch it out. We're gonna find a little improv here. I want 4 people to be bank executives and 1 person to be my adult child. And I'm going to choose Commissioner Gonzalez. You get to be my adult son. So this is what we're imagining here. I am a homeowner in Colorado, and I'm coming to you, bank executives, because I have owned a home for 10 years in Colorado. And because Colorado home prices have gone through the roof, I'm sitting pretty because it's gained a lot of money, right? And I want to keep that money. But I don't want to pay my mortgage anymore. And there's a few other people like me in the state. So I come to you, bank executives, and I say, hey, bank executives, I made some bad choices and I want to keep all the money I've earned, but I don't want to pay my mortgage anymore. Can you help me out? There's not much of a house left anymore. I kind of trashed it. There's maybe a few studs left that you could use for kindling, but I sold all the appliances and I took out electrical stuff. I kind of trashed the yard while I did it. I think the gas line to my house might be leaking. My neighbors have been talking about being sick. And I've had, you know, I care about my neighbors. I've had a lot of heartfelt discussions with them about how they feel living next to my house, but you know, property rights, and also it's kind of their fault for living next to me. They could just move. And I need your help, please, cleaning this up. I heard there's a federal program that will help with this because there's other people like me. And then you, this is your turn, and you can say, you make a face at me, you say, you scamp, you little scamp, you shouldn't have done that. But you're right, there's some federal taxpayer bailout coming in, and you know, you got us in a pickle here. We'll take care of your whole mess, and you get to keep all that money, but just don't buy another house in Colorado again. Say, okay, thanks. Thank you so much. I really appreciate it. I made some bad retirement decisions, and I just really appreciate the help. So take my money. And then I go to my son, Commissioner Gonzalez, and I say, son, I've got all this money. You can buy a down payment. It's a down payment for a really big, nice house in Colorado, because we've got really low severance. I mean, really low property taxes still. It's a good investment. But here's the thing. You can't tell the bank I'm your mom. I see the look on your face. It's not that I'm embarrassed of you. It's just that we'll get in trouble. So don't tell. I know when I got divorced from your dad, we have different names. And so I don't think they'll figure it out unless they dig really deep, and who has the time for that? So just in a couple years, when the bank president changes, you go, you take the money, and you start again. End scene. Thank you for indulging in that with me. That's how I voluntarily relinquished my house. So what's next? So if you do amnesty, don't do it. It doesn't make sense, but you can close the loopholes if you decide that's the way you want to go. And I think Kate Burke kind of had a lot of the same ideas in her red line of these. One of the things that I want to say is that we definitely supported Wild Earth Guardian's desire to renotice the section, but also no other states have an amnesty program like this. Internationally, we're going the wrong direction. Australia is a really good example. Woodside Petroleum left them with over $1 billion in obligations. Instead of saying, you're right, just like, here's 10 months, we'll take care of it for you. They went after them with trailing liability. And there's more about it in this, give me more about it in the carbon tracker thing. But what's happening here is that industry is using Colorado as a test case to see how much they can get away with. Don't let them. Don't sacrifice us like that. So like we said, for the past year, we need full cost bonding, full cost financial assurance for every well. Based on North Dakota and BLM data, we feel that that's $282,000. I realize other people have different numbers. Regardless, full cost assurance for each well just makes it clean, it makes it simple, and it protects Coloradans. And we also could use a climate remediation fee because, as you know, fires, stuff is happening, climate change, burning hydrocarbons, you know, oil and methane industry. Thank you for your time. I hope that was quick. Any questions? Did you have a little fun?
It was entertaining.
Okay, good. That's what I was hoping. It's hard to be last after 3 days.
I think you're one of our few stakeholders who could have pulled that off at 4:37 on a Friday afternoon after a long week. Thank you. And thank you for the points that are made. And I made a list. And so it'll go into my thinking as we think about this over the next few days. Just briefly, the local government and LDAR, you heard Ms. Paranos, because I think you've been here the whole time. Were you comfortable with the sort of reiteration of what she's been saying all along in terms of what that looks like?
I mean, I think it makes sense for the well monitoring to go through the AQCC, as long as that is continually communicated to the COGCC. The part I didn't get yesterday was why everyone was saying that was so burdensome. Like if all of that is already happening and all those air quality rules are being considered, I don't know why you wouldn't do some monitoring of shut-in wells. But I do think like AVO monitoring is not great. It like she said, like she demonstrated, like 90% of leaks are detected with the equipment. That's why Earthworks goes out with the floor cameras, right? Because a lot of times you can't smell it, you can't see it, but it's making people sick and it's hurting the climate. So the more monitoring we can do with instruments, the better. And it should be required. Whatever agency requires it, it doesn't matter, but it should be required. Leaks should be detected and they should be required to be fixed and prioritized.
Okay. And then the place where we are on the federal rules, you said you were supportive, is that right?
I'm glad that the federal rules are included. I liked what the Citizens for Healthy Community had to say about adding the water and surface, like kind of insurance plans. I'm using the wrong words because as you all, it's been a long day, but do you remember that kind of this morning when Natasha Leger was talking about that? I'm definitely supportive of that as well. But at least including federal assurances, I think is important.
Okay. Do other commissioners have questions? I guess my last point is, you know, on the amnesty, and I realize you would rather us not do that, but, and I didn't know that we were the only state or country in the nation that is doing it. It wasn't an operator idea. It was, I think it was our idea. And I think it's trying to solve a problem and not trying to create an outlet to be abused. And so I too appreciated Ms. Burke's proposed fleshing that up. And, you know, and some of those were ideas that I think some of the commissioners had floated around. So let's, you know, I don't know where we're going to land on that, but I just wanted to give you that perspective because you said that the, you know, industry is using Colorado as a test case. I think it's kind of backwards. I think we're actually offering this potentially as something that is beneficial. And so we'll have to wait and see, but I do want to put, you know, if we go there, put some flags around it so that it's not abused.
Yeah, I wonder, like, what would the mechanism be? One thing I don't think was in Ms. Burke's rules, I've been thinking about a lot, is how would you find out if another operator started operating under a different name in Colorado after they already got an amnesty, right? And if you did find out like years later, you need to have no statute of limitations for going after them. It was like when all those production reports went missing and they found out like 3 years later, but we couldn't go get that money because it was like a year statute of limitations or something. Like there needs to be, beyond guardrails, really serious penalties. Like there's, in these rules in general, there's so many carrots and like no sticks. Like in that ridiculous example I used about amnesty, right? Like bank executives are never sitting around saying, how can we incentivize responsible mortgage payers to pay their mortgage? Like that's not a question. If you have an obligation, you take care of it. And people never say, how do I incentivize people to pay child support? You don't. They pay it or you garnish wages. Like it's, I don't know that the word obligation in this rulemaking means the same thing that it does to the rest of the world outside of it. You know what I'm saying? So operators are responsible or they're not. And I think less incentives and more penalties and fines and abilities to go after people who break the rules would be useful.
Okay. Thank you for being with us this afternoon and for the entertaining presentation that also contains a lot of substance. So we appreciate it.
All right, thanks so much. I really do. I know I'm cranky, but I appreciate all the time everyone has put into this. So thank you.
Great.
Special thanks to Commissioner Gonzalez for being my adult son. Bye.
All right. We now will bring in 350 Colorado.
Okay, everybody see that?
Yes, we can see that. We can see you, Mr. Foote, and we can hear you.
Very good, thank you. All right, well, thank you very much, Mr. Chair, and good afternoon, commissioners. My name is Mike Foote, and I'm an attorney representing Colorado Rising in this rulemaking. I'm afraid I don't have a theater production for you, but I do recognize we're near the end of a really long process, and it's been long because you've taken so much public comment, and that's very much appreciated, so thank you for that. There isn't too much to say that hasn't already been said, but I'd like to focus on a few concepts that you've already heard today that we particularly agree with, and then move on to a couple of bigger picture thoughts. So to amplify a couple of things without repeating most of the details you've already heard, first, we share the Earth Justice position on single well financial assurances for all new and transferred wells, and have been advocating for the same thing throughout this process. Going forward, single well financial assurance for all wells reduces complexity, loopholes, and risk. But in the absence of that, there are some ways that current draft could be strengthened. We appreciate the Earth Justice position on the undue hardship language in option 5. The operator should have to prove undue hardship rather than just believe it. We agree with the Rule 707 revision proposed by Earth Justice 2 because it's important to have some kind of record that can be reviewed by the public and provide transparency to your decision making. We agree with the Conservation Alliance on several things, one of them being the addition of a certification of financial capability to the financial assurance plans. And we echo their Uber bond concerns along with several other parties. And we do agree with something that was mentioned earlier today by CHC, which is that you should always take a precautionary approach with these rules and otherwise, rather than a reactive approach. So next, I want to offer a couple of bigger picture thoughts. First, going back to yesterday and putting into context what some of the parties presented as a paradigm shift. No doubt, this rule changes things about the financial assurances. And the General Assembly recognized the current system was badly in need of reform. And since the system was so poor to begin with, any substantial fixing of it would necessarily be a big change. But this commission should keep in mind that under the current rules, most operators have extremely low assurances in relation to their assets, many along the lines of just a couple $1,000s average per well. And party presentations yesterday projected assurances under the proposed rules at 3 to 6 times or maybe even higher than what they are now. And that sounds like a lot on its face, but not once you consider if the average per well assurance from a particular operator was $2,000, tripling that gets us just to $6,000. And yes, that's an increase, but it's kind of like a retailer making a clearance sale discount from 70% off to 50% off. You save a little less than you would have before, but you're still getting a really good deal and you should take advantage of that sale. Operators in Colorado are still getting a really good deal under these proposed rules, just not as good as before, and still wouldn't be putting down anywhere close to what it costs to actually plug and abandon a well. So there's a saying out there related to the overall philosophies of legal systems that I can't independently verify its veracity, of course, but it goes something like this. In England, whatever is not prohibited is allowed. In Germany, whatever is not allowed is prohibited. And in France, everything is allowed, even if it is prohibited. And I think comparing those three legal perspectives, at least as presented in this saying, is instructive because it may give the commission insight as to why environmental and community groups have explored so many what-if scenarios during this rulemaking. It comes from quite a bit of experience that shows much more often than not, if an off-ramp exists, operators will take it. A rule may come across on its face one way, but in actual application, it turns out much differently. And I think it's fair to represent the view of many non-industry community groups is that operators have often behaved consistent with the third saying, but at the very least, they have been allowed to operate under the first saying with the help of off-ramps exceptions, and exemptions. So we hope you'll approach your final rule drafting exercise by adhering to more of the second saying, which would be much more protective to the state. In other words, practically speaking, less off-ramps, more guardrails. Some potential guardrails on this newest draft have already been discussed today, and that's good. That's much appreciated. We hope that that kind of mindset will continue throughout your deliberations to make sure the commission doesn't have to come back and do this whole process over again in the near future. So thank you very much for your attention throughout the day, your good questions, and your diligence. We appreciate it.
Thank you, Mr. Foote, for the presentation. Do we have questions? One of the problems in going toward the end, Mr. Foote, is that you reiterated things that we've already had questions with parties about, like support for this, not support for that. So not having questions now just means we've asked them before. So
it's not a problem.
Right. Very good. Thank you for being with us this afternoon. We now will bring in Anthem Ranch Community Association.
Good afternoon. Can you hear me?
Yes, and we can see you.
Great. Okay. Well, that's not so necessary. Chair Robbins, would you indulge me before the time clock starts? I want to commend you for doing something that was so desperately needed in this rulemaking. We've been spending a year on it, and there's been no shortage of posturing on all parties' parts. And today you broke that posturing, that prism that we looked through by asking Matt Sura to allow Ms. Gutierrez to have a dialogue. That's what we need to get to this final set of rules. We are all here because we care deeply about this state and the people in it. So thank you for pushing that Lincoln Douglas debate and allowing us to set the mood for this final stage. And I know I'm the next to last person on the last law or rule setting, so I will make my comments brief, but thank you for doing that. Chair Robbins, commissioners and staff, thank you for the opportunity to speak with you once again. I'm Susan Spees here on behalf of Anthem Ranch Community Association's Board of Directors. The current draft of the financial assurance rules has some modifications that are of concern to our association. I want to focus primarily on the 700 rules. While in Rule 702, you have technically eliminated the tier designation, which I've harped on a bit when speaking with you, there still is an inadequate funding for the plugging and abandoning of wells by all operators. All wells should be accounted for equally and to a level of support that reflects the cost to plug and abandon or reclaim non-producing wells. In 702D1 and 2, the blanket financial amount ranges from $5,000 to $18,000, depending on the size of the operator. And the proposed amounts of the financial assurances over the life of the well do not come near enough to covering that prospective costs. We've heard numbers from $92,000. I've seen some written as $140,000 per well. While we prefer something simplistic, similar to what API suggested yesterday, more dialogue like we've been hearing today might lead us to the best solution to a very complex issue. In section 702D 6BI under option 6 plans, you do set the comprehensive amounts for wells at $30 million, but it used to be $45 million. Seems like it's going in the wrong direction. As a community surrounded by literally hundreds of wells, Broomfield and Weld County wells, we are critically aware of the health risks we face when these wells are no longer productive and need to be plugged and abandoned. In Colorado, there are roughly 53,700 plus wells. About 23,000 of those wells are marginal producers, only producing 5 to 15 barrels per day. 8,538 wells are producing only 1 to 5 barrels per day, and 17,196 are inactive. Well, the state currently has some bonded money from operators. There is significantly less than the estimated $8 billion it costs to clean up all wells. Now, I know not all wells are going to have to be cleaned up on the same day or the same year, but we need to work towards having the money to support that. I suspect that the day is going to come sooner rather than later for needing to abandon a whole lot more wells. Anthem Ranch believes that the commissioners and the COGCC staff have worked diligently to fulfill the mandates of Senate Bill 19181. We just want the mandates to be front and center with the financial assurance rules. The burden financially and health-wise for the proper cleanup at the end of the well's lifespan will be paid for by residents rather than by the operators who have owned and profited from those wells. Let me offer a specific example. I live, as many of you know, and have been to the house to see, 1,260 feet from the nearest wellhead of the Livingston pad in Broomfield. Over the past several weeks, Extraction/Civitas has been coming in to add pump wells to all 18 wells because the flow of these new wells has dropped significantly. In order to install a well pump, which will suck out the product, the wellhead has to be cut out, cleaned, and left open for a period of time, resulting in multiple measured exceedances of VOCs, particularly the BTEX. And these are being spewed into the air that I and my neighbors are breathing every minute of every day. My voice is raspy today, my eyes are itchy. It's because that's what's happening. The equipment is still there. And just this morning, I received the AQ readings that are still high. These wells may reach an unacceptably low level of productivity soon, much sooner than Civitas ever imagined. Our concern is that there may be insufficient funds to cover the plugging and abandoning of these residential wells in the near future. And finally, I want to make a challenge to COGCC, not related to rulemaking, but what we are seeing in the DJ Basin here in our region, and I think throughout much of the DJ Basin, is well production is going down. I suspect we are quickly approaching a point where it will become economically disadvantageous to try and capture the oil and gas under our feet. Let's find out what the actual availability of product is. So thank you very much, and I'd be happy to answer any questions you might have.
Thank you, Dr.
I'll let you go home.
We appreciate you being with us late this afternoon and providing perspective. Commissioners, are there questions? And I also want to say, we do think the willingness on your part as a volunteer to come in and provide perspective of someone who is in a community that is near oil and gas development, it's really helpful to get that perspective. And I know you spent a lot of time with us, and we appreciate that.
Thank you.
All right, I am not seeing questions, so thank you.
Good
again.
luck.
Thank you. We appreciate that thought as well. We now will hear from the citizen group.
So I'm now going to share my screen, hopefully.
Okay.
Has Phil joined us yet, Barbara?
We do have Mr. Doe, but he is not visual or audible at this point.
Okay, I was saving myself for a big surprise, but
Okay.
I'll defer to majority will.
Okay.
Maria, I just want to confirm, we see your slides and they are in presentation mode.
Okay, thank you.
Okay. I'm Wes Wilson, retired environmental engineer, formerly employed by the EPA here in Denver. Today, we're representing these organizations. They include a wide range of Colorado citizens, the often ignored 99%, the students, the retirees, the people who are working today, running a business, keeping our state going. The commission must base the need for increased bonding on the climate crisis and the health risks this industry creates. It's these risks, these consequences, that SB 181 obligates the commission to avoid. Now, commissioners have observed that full cost bonding is either not needed for new wells because of the low risk, or is unaffordable for operators with low producing wells. Is this why the commission ignored our full cost bonding option? The position is supported especially by Commissioner Gonzalez, who questions if 100% reduction of taxpayer risk is even necessary. Commissioner Gonzalez also takes the position of his prior industry employer, that the industry has better things to do with its money. This is why we already have hundreds of abandoned wells with more to come. Commissioner Gonzalez, your position demonstrates you're not content neutral and why you should recuse yourself from this rule vote. We demand the AG's office reconsider its reasoning in this regard. As we demonstrated in our Be to Change alternate proposal with cost benefit analysis, full cost bonding is necessary to protect the public from inheriting industry risk. Our proposal has a one-time legacy fee of $37,500 for each well, which is beneficial to the state and would provide many cleanup jobs. The legacy orphan well fee in the commission's draft rule is only $200 per well, apparently because you're counting on that federal orphan funding. Commission staff reported that there is a legacy of some 19,000 wells in the state that produce little or next to nothing, so are at risk of becoming orphans. If you don't get this well closing cost fully funded now, while the price of oil is high, there's near certainty these closing costs will become public costs. And imposing these public costs, in our opinion, requires a vote of the people under the state's Tabor Amendment and is beyond your authority as set forth in Article 11 of the state constitution. As for small operators, the requirements of our Be the Change proposal dictate that small operators would have 3 years to post their $150,000 per well bond and the $37,500 legacy fund, or then apply for bankruptcy. Full cost bonding for the public will protect the public from the risk of inheriting as much as $7.7 billion in closing costs if all unplugged wells are orphaned. Just the 19,000 useless wells would cost $2.9 billion to close at $150,000 each. With the amnesty provision, makes even more likely. The risk is great the public will inherit significant costs if you don't act now to fully bond. The window of opportunity is narrow for the industry's boom will end soon. Now, Barbara Mills-Brio will present examples of what small operators would face to provide full cost funding.
Yeah, thanks, Wes. So far the discussion has totally been on how much can an operator afford to pay. And we want to shift it to, sorry, to shift this slide to, how much operators are making. So I'm going to address the ability of several small companies with fewer wells, not the big guys, in this regard. So I got all my data from the COGCC website and the EIA website. I used average price of oil and average price of gas per year. I multiplied not the gas and the oil produced, but the gas and the oil sales for each of these companies by those averages per year. And as you can see, PetroShare, they've been brought up a lot. They declared bankruptcy in 2020, and Colorado collected $325,000 in surety bonds for 89 wells, which Carbon Tracker estimates would cost $16 million to plug and abandon at about $189,000 per well, plus cost for reclamation. They turned over 55 wells to the state as part of the bankruptcy, and now they're part of the Orphan Well program. Over the years 2018 to 2021, yeah, your data shows that they're still producing, even though they were taken over by Wattenberg, an entity formed by their key post-bankruptcy creditors. PetroShare in those 4 years made a net profit. I used 60%, I used 40% of their gross as lifting costs. So 60%, they made over $76 million. In Petro, over the same 4 years, made a net profit of $9.5 million from their 80 stripper wells. And they also have 12 non-producing wells. That's on your based on your 2020 data. Then Magpie, over 2018 to 2021, made a net profit of $21.5 million. This company has 95 oil and or gas wells, 54 of which are producing, which leaves 41 non-producing. Renegade Resources, this is the company that was adversely affected by the Firestone house explosion, and a couple of people died, and subsequent business decisions made by Anadarko and Occidental. Even given these business decisions, Renegade made a net profit of over $6.6 million on those 4 years, 2018 to 2021. Mallard made $290 million over that time period. They have 162 wells, 23 of which are producing. So as you can see, some small operators are making more than others. So the ones presented, their net income over the 4 years between 6.6 million and 290 million. Surely they can be required to set aside enough of this money to pay and to plug and abandon their wells and reclaim the area around these wells. Is sort of the story of the grasshopper and the ant. One thing Matt Lepore stated in one of his slides, there were 47,000 plugged wells in Colorado. Your database shows a total closer to 26,000. I'm glad to discuss this data and upload more for you if you want it. Thank you. Bill.
Okay, thank you. I feel like a Bubandatum, the very last. The information contained in Barb's table reinforces our contention that from a social justice standpoint, operators, many of whom are making millions of dollars annually, should be required to cover the risk of closing their own wells. It is morally repugnant to contemplate that through this rulemaking process, the citizens of Colorado will likely be handed a bill at some future date to clean up somebody else's massively expensive mess. This injustice becomes even more offensive when we consider that most of the people who will be getting this bill will never even come close to making $1 million, not even in several lifetimes of labor. And as to the oil industry's repeated claim that we are simply hollering wolf as to the abandoned well risks, we say that the new $4.7 billion federal subsidy to close abandoned wells gives a lie to this self-serving nonsense. That the state last year doubled its number of abandoned wells indicates the problem is real. That the COGCC wants to get its hands on as much of the public's $4.7 billion as it can underscores this reality. That last week, this commission spent considerable time discussing the 19,000 wells it discovered may be at risk of becoming orphan seals the deal. That the EPA says there are approximately 3 million abandoned wells in the United States gives a lie to the idea that the problem isn't critical and enduring. Finally, I offer this observation. Most of what we've heard over the past month concerning bonding and financial solvency is an industry complaint over what the law demands. The industry does not like the fact that they've finally been called to account to cover their financial risks, that the public is to be protected against inheriting those risks. They've enlisted this agency to help them rewrite the law, and you have all eagerly hopped to. You do not have that authority. Your job is to enforce the law, not rewrite it. For example, the law specifically requires that wells be individually bonded before they are transferred. You've revoked that requirement. Mr. Robbins has stated the requirement is unenforceable because it interferes with the operator's business decisions. Mr. Robbins, the operators has recourse if he thinks the law unconstitutional. He can go to court. Your job is to tell them that if they don't bond before the transfer, the well operating permit will not be renewed. That's simple enough and enforceable. The law requires that all new wells be individually bonded. Here again, you've largely revoked that requirement of law. The law asks that an operator's ability to satisfy every financial requirement of the law be reviewed annually. You all have taken it upon yourselves to make that requirement a nullity for publicly traded operators. The big guys like Chevron and Occidental get a pass. It is undoubtedly an accident. Mr. Gonzalez, a longtime former employee of Occidental, argued so strongly for this revocation. In summary, the law's declared purpose to protect the public, including its purse, has been sacrificed in these proceedings, destroyed actually. One of the concerns that caused this law to be written, the awareness that climate collapse is an ever-growing possibility, never once informed any discussion conducted by you all over the past month. That is damning. Thank you.
Thank you for the presentation this afternoon. I appreciate you being with us late in the day, and I look to see if my fellow commissioners have any questions of the panel. I'm not seeing any questions. Thank you very much.
Yep, sure.
Thank you.
Where are you? Where are the commissioners? We don't see them.
We're here.
Oh.
Okay, commissioners, that takes us through the party presentations that were set up for today. And that would conclude the work of the commission today. I'd like to sort of frame where I see us, and I'd like to suggest a proposal in terms of going forward. Well, let me get my notes. So at this point, we've taken all the party public comment on the final, the most recent red line, and there is a lot there, in my opinion. And we are due to reconvene on the next Tuesday and Wednesday for deliberations and finalization of financial assurance rulemaking. And the question before us is, are we ready to make the best final decision on what I agree is a paradigm shift on financial assurance rules by next Wednesday? And I would love to be able to say that I think the answer to that question is yes, but I, as one commissioner, think the answer to that question is not yes. I think that that's not from a mighty effort on everyone's part of trying really hard to go through a lot of substance. And I also think that we are remarkably close to being in a good place to indeed determine the best new financial assurance regulatory protocol for the state. My suggestion is we take 4 additional business days and get this right. And conclude the rulemaking on final deliberations on March 1st. I think this will give us an additional productive amount of time to ensure that we're able to go through all of the information we've received in slow measured steps. It'll give us the time to hold, and staff time to hold, positive, prudential, deliberative discussions. It'll give us time to have initial deliberations and then take some time and step back and then come back for additional deliberations. So what my proposal is we spend the weekend digesting the feedback from the parties and convene on Tuesday morning from 9 to 10-ish, 11-ish to issue spot. So that gives all of us a chance to go through our notes and issue spot the issues that are out there that deserve deliberative approach from us. We then take a break and give staff a chance to put the issues in a PowerPoint like we've been doing. And then we spend that afternoon, the 22nd, and then possibly the 23rd, if need be, working through the issues, identifying landing spots on issues, and where necessary, and I think this is important because I think there are going to be some spots
providing some guidance to draft to do some minor additional tweaks to the rules. I then suggest we break. We give staff until that weekend, Sunday, the 27th, to put out the final product that would include the landing spots we've landed on issues. And it would potentially have some additional final red lines that is a result of guidance from us. We would then reconvene on March 1st to discuss and finalize and make final action on the revised red line rules. A couple of components, process components to this plan that I threw out to you is I would not suggest we close the record. If we close the record, then we can't call parties back during deliberations. And I think there might be opportunities for us to call an individual party or parties back on a specific, tangible issue. And so I'd like to do that. Having said that, I, for one, do not need further stakeholder comment, like everybody get another 5 minutes to go over where we end up. I think we've heard from everybody on the issues very, very much. It's been awesome. I appreciate the dedication of our stakeholders to this process. Having not closed the record, that also does not foreclose any one commissioner for entertaining one-on-one discussions with stakeholders like we've been doing all along. You just need you would need to disclose that. If a commissioner thinks they've heard enough, they just don't need to answer the phone or the email. And so it's up to the commissioners as to whether you want to have additional one-on-one stakeholder discussions. The last component to this plan is what's the impact? It's 15 days instead of April 15th, we have an effective date of April 30th. So that's my end of the day sort of thought process to provide us with what I think is an appropriate level of time to get to the best decision for the state of Colorado. And I could be all off board. You guys could be totally ready to go. And if that's the case, then that's fine. I'm planning on doubling down all weekend anyway. But I think that from my perspective, there's merit to this. And it would result in what's most important, which is creating the best financial assurance rules for moving forward for the state. Thoughts, and I also would entertain thoughts from Director Murphy as I drop this on her too. So, Commissioner Nanjapa.
I'll let Director Murphy go first, but she says no. Okay. I appreciate this thought because I do, there's a part of me that feels like it's a tight, couple of days that we're going to have to get through. Maybe before I get too far, can you just go over, so the dates would be, again, we'd meet on Tuesday, the 22nd for a couple hours, let staff go back and kind of organize things, then come back that same afternoon and also meet the 23rd. Is that correct?
Yes. I mean, depending upon how much time we need. We had the 22nd and 23rd set aside. So we would come in on the 22nd, having spent the weekend individually issue identifying and organizing our thoughts, get all that out on the table. And then staff can help set that up in an hour or two, come back that afternoon, the 22nd, morning of the 23rd, whatever it may take, land as many issues as we can, but give ourselves the opportunity that we may need final drafting and give staff that opportunity to do that. Get that final draft from staff sometime that weekend, and then come back on the 1st for final deliberations. I'm hoping that this two-step approach will land a bunch of things, give some additional time for the more contentious things, and then land those things in the best way for the state of Colorado.
Okay, and then is your thought then that we would have the 1st and the 2nd, or was there another day that week, or was it just the 1st and with the intent of trying to finish everything that day?
I was just throwing out the 1st. I would let Director Murphy and Ms. Hearings Manager Larson massage the ideas because they're better at
the, creating a calendar than I am, but I guess my thought was, I don't know, and maybe it's going to be a, let's see where we get on the 22nd and the 23rd. And if the final sort of set of things that need to be revised is small, we could just go to the first. If the issues are larger, we could do that Monday, the 28th and Tuesday, the 1st.
Okay. Yeah, no, I appreciate that. I think that's a little bit along the lines of what I was thinking, is kind of seeing, how much we can accomplish on the 22nd and the 23rd, and or alternatively kind of breaking up the days. I think we have other hearing matters on the 24th, if I've got my calendar correct. So potentially doing, a little bit of identifying issues, deliberating on some stuff, maybe coming back and identifying, different sections of the rules, issues the following day and doing the same thing, and kind of, I'm just wondering if maybe there's, certainly there's a million ways we can slice this, but I think I guess I'll just say, I'm more inclined to kind of start laying things out and see where we get, and also looking to Director Murphy in terms of how you would like to kind of see us organize our thoughts. That always helps, I think, in the past when you kind of laid out a framework. But, I'm open to going a few more days. I think, to the extent that we can wrap up by the 1st or 2nd, I think that'd be good. But yeah.
Commissioner Nanjapa is kind of, that's the other piece. I don't want to go through middle of March. I think we need, we've got all the information, we've got all the wonderful stakeholder input. I just want to give us a deliberative time that is consistent with all of the time we took to get here, which is a year. Other commissioners with thoughts? Commissioner Messmer?
Thank you, Mr. Chair. I appreciate the idea of making sure that we get this right. I think I'm also, I'm in a place that I'm comfortable rolling Monday or Tuesday, Wednesday next week and getting this thing done, right? At the same time, I'll respect whatever time other commissioners need in order to be able to address this. I think my suggestion would be, let's anticipate having full days on Tuesday and Wednesday, getting through absolutely as much as we can, which still allows Wednesday, Thursday, potentially we can get a final draft out on Friday, have final deliberations and be done before next weekend. If that seems feasible, if we've got to roll into the next week because commissioners aren't quite ready yet, I get that. But at least from this commissioner's perspective, I've got my head around this. I feel like I know where I need to roll with it. So sooner the better for me.
I would make one note that was influential in the work and the idea that I had. If we act by the 23rd, the effective date can be the 15th. If we act after the 23rd, whether it's next Thursday, Friday, Monday, the effective date becomes the 30th. So with that in mind, I was taking those extra days just to give us time, since it doesn't really matter if we go past the 23rd. So I just throw that out there for your thought process as we think about this. Director Murphy?
Thanks. And Commissioner Gonzalez, if you want to go ahead. Okay. I would, it takes a lot of time to work through rules and make conforming changes and kind of dial in all of the pieces. And so I think if we have a point at which the commissioners are done and staff has a couple of days without further changes coming in to actually do that work, we'll end up with better work product in terms of like errors or like typos and those kinds of like little kind of connecting the dots things. And so I like Commissioner Nanjapa's idea, so long as there's a point at which we're done next week and staff gets, again, like a business day at least to work through those revisions. Sorry about we have my entire household home now, so we might get lots of interruptions on a Friday night. So that's my only caveat to Commissioner Nanjapa's comments. Obviously, Commissioner Mesner, we were prepared to dial that in the magical hours between like the 22nd and 23rd next week too. So we'll accommodate your schedules. And those are my only comments. Sorry, Chair.
No, thanks. Appreciate it. Commissioner Gonzalez, you gave a thumbs up. Is that just like you're comfortable with this supposal if we do it this way?
I'm comfortable with all three supposals that have been supposed.
Anybody else want to weigh in? Commissioner McGowan.
Oops. Thank you, Mr. Chair. I mean, I think the elegant thing about this is if it doesn't go as fast as we want it to, or we think it's going to, we have time to work through some things. So I think our goal should be try to plow through it. But if we hit some, bumps in the road, we have time to work through some of those things that if we find they're kind of split, or we think we're close, but not quite there. So.
Commissioner Nanjapa.
Thank you. Just a question more than anything. I mean, I know we have some items that have been calendared, February 24th and March 2nd, I think, and 9th. Are any of those flexible? Oh, I hope we don't go into the 9th, but are any of those, flexible where we could have those days instead to kind of get more of this stuff done before switching gears again? Maybe this is a me question.
Yeah, so the 24th, we have the two OGDPs that we continued from this Wednesday's hearing, Laramie and Vecta. Counsel to Laramie and Vecta advised me that they do need to have those matters heard on the 24th, and they're only available in the morning.
And do we have other matters on the 2nd, or?
On March 2nd, we have two OGDPs that are scheduled to be heard. And let me just double check. I believe those are the only two contested matters that are up that day, and it's several presentations. We could certainly coordinate with council on those OGDPs and see if they are amenable to having those heard on the 9th.
Thank you. I appreciate that. I know that creates more hassle for you, but I'm just, I think to the extent that we can, kind of get through as much as possible, as quickly as possible, that would be great. And I guess the last thing I would just say is, yeah, just reiterating that Director Murphy, if you've got kind of an organization in mind of the order in which maybe we can attack some things, I think that would really be helpful, and then we can organize our thoughts around those.
Okay, seeing no hard firmness from anybody about the calendar, I think what we can do is just move to continue this matter, and I reached offline to AAG Davenport on this, to March 1st, which is the potential latest date, and then adjourn to February 22nd at 9 a.m., which is when we're planning on coming back. And I guess what commissioners should plan on doing over the 3-day weekend is spending time with all of the issues and all of the product that we have. And we'll come back and we will see how we do on the 22nd. It seems like we've got agreement around spending that morning, starting with kind of issue identifying and then giving staff a chance to put all that into a doc. And, I think staff may be doing that anyway, but and then we can start moving through issues sequentially on the afternoon of the 22nd, see where we are on the 23rd, and make a game day call if we're going to be done by the 23rd, or if we're going to take up the additional time frame that I started out with in the articulated proposal. Everybody good? All right, great work, everybody. Great work to the 60 participants that are still with us at 5:27 on a Friday afternoon. Really cannot thank the state of Colorado's citizens and local governments and operators and environmental organizations and
citizens, communities, and people for the, really fantastic attention to a very important topic for the state of Colorado. And we look forward to getting it right. With that, I would look for a motion to continue this matter to March 1st and a motion to adjourn until February 22nd at 9 a.m.
So moved.
Second.
Motion and a second. All those in favor signify by saying aye.
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 Any opposed? We're adjourned. Thank you, everybody.